Very good. Una facilità. Vale, vale. Bien, pero para Yes, ঘুরে দেখে দিল
matter first.
yes yes
Then, yes. Appellate side 1030 matter, item 1 and 2.
yes. What is the contempt?
Your Lordship, see your Lordship's order, your Lordship has entirely dealt with prior to issuance of the rule. In the affidavit, they have admitted.
Food supply.
Yes. Your Lordship was pleased not to give effect to the tender that has been given effect to a work order issued. In the affidavit, my lord, they have admitted that.
You are appearing.
My lord, I have, my lord, we filed, my lord, the affidavits. My lord, there were 4, my lord, contemnors.
Yes.
My lord, on 3, my lord, I have, my lord, said, my lord, apology, my lord, has been asked for, my lord, everywhere. My lord, as far as 3 are concerned, my lord, they were not involved at all. And my lord, no, my lord, service, my lord, had been,
Which of the three?
my lord, 2, 3, and 4.
Well.
My lord, they have filed, my lord, affidavits. My lord, 1, my lord, who's, my lord, the local, at that point of time, the local authority, my lord,
Yes.
had, my lord, overlooked it. He's admitted, my lord, his fault. And, my lord, thereafter, my lord, on instructions, my lord, he has, my lord, cancelled, my lord, that allotment. And, my lord, he is someone, my lord, I have given, my lord, I'm only seeking, my lord, your lordship's indulgence here. My lord, he genuinely made a mistake. He has, my lord, given his career. My lord, it's close to retirement, my lord. He has, my lord, all along, my lord, not had anything, my lord, never ever violated, has a good, my lord, service record. My lord, he has, my lord, asked for, my lord.
You were satisfied it was not deliberate.
Yes, my lord. My lord, in fact, my lord, when he first came to me, my lord, he said, my lord, that I have not received this. Then, my lord, I asked for, my lord, the, my lord, document which was annexed and asked him this, my lord, he was in tears, my lord, saying that he was never.
I'll accept the apology. Yes.
Paragraph 7, my lord, tally C.
My lord, I have admitted, my
My
lord, I
respondent number 1 probably is not appearing today. Yes, check.
yes, all have come, my lord, all have.
Must have come.
My lord,
Must have come.
7, can you see the content number 1, paragraph 7? He has admitted.
আমি বলছি তো।
And I think it is instruction of the London Advocate General to draft this.
No, Mr. Basu, this cannot be concocted. This is the absolute truth.
No. I cannot say conducted.
This is
Advice of Mr. Mukherjee.
escaped my attention is absolute truth. So we should honor that. The learned senior advocate, the learned advocate general appearing on behalf of the contemner submits that insofar as alleged contemner numbers 2, 3, and 4 are concerned, they were not involved in the process of issuing work order, which has been construed by this court as deliberate violation of the court's order. Full stop. Next para. However, inasmuch as alleged contemner number 1 is concerned, it is submitted that the candid truth has been revealed in paragraph number 7 of the affidavit in opposition affidavit filed by the said contemner. Full stop. It appears from the said paragraph that the statement made therein speaks of the truth, and there is no attempt to concoct a story in order to avoid the rigors of contempt. Full stop. In the third sentence of the said paragraph, it has been candidly admitted by the alleged contemner that the communication of the order escaped his attention, for which he tenders unqualified apology. Full stop. Next para. Keeping in view the advanced stage of service of the alleged contemner number 1 and the fact that he has tendered unconditional apology, bona fide doubt arises as regards whether the mistake committed by the said alleged contemner was unintended. Full stop. Next para. Since such doubt remains, it would not be prudent for the court to take resort to the extreme remedy of penalizing the alleged contemner for deliberate violation of the order of court. Full stop. Hence, accepting the apologies of all the alleged contemners, WP CRC 65 of 2023 is discharged. Full stop. The contempt application is accordingly disposed of.
What is the consequential order?
What is that?
Only a so
But they have already.
But I,
no, no.
my lord,
Can
kindly
you
have
come
a
to
look
page
at
10?
page ten,
Page
my
10.
lord, of one's affidavit. My lord, kindly take, my lord. My lord, paragraph 2. My lord,
This
we
is
have
so
said
cause
that,
notice.
no, one, my lord, I have said selection was not valid. A stay order was, then my lord, in view of the, for supply or has been decided, if you have anything to say, my lord, this is, my lord, just, and my lord, it will happen, my lord, because the order was there, my lord, there's.
Very well. This much.
problem.
No, that will not do, but unless it is cancelled,
আরে করে দেবো বলছি না
As a very I'll record one line. আরেকটা line add করে দিন. However, comma, the alleged contemner shall ensure that the work order issued in violation of the order of this court be immediately cancelled and due steps be taken to comply with the order of this court in true spirit.
I'm grateful, my lord.
Original side, তারপরে। আচ্ছা আমার তো লিস্ট কিন্তু আজকে চাই পুরো লিস্ট সব লিস্টে দিয়ে করে দেবো।
One sentence we added.
2023-এর যা যা পেন্ডিং ম্যাটার আছে আরবিট্রেশন এইগুলো আছে টোটাল ডেট ওয়াইজ গুলো ছাড়া না আরবিট্রেশনই বলতে আমার আরবিট্রেশনে আছে আরবিট্রেশনের 2023 শুধু আছে আমার
বেরিয়ে গেল নাকি?
না 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 আমি বলছি লিবার্টি মেনশন যেগুলো সেগুলো তো নিয়ে নেবো যেগুলো ডিপার্টমেন্টে রয়েছে বা কিছু নেই আচ্ছা যেগুলো ডেট ফিক্সড আছে সেগুলো ডেটে আসবে আর যেগুলো বাকি ডেট ফিক্স ছাড়া সব লিস্টে দিয়ে দেবে লিবার্টি টু মেনশন পেয়েছেন আর মেনশন করতে হবে না আমি মেনশন করছি একদম সমস্ত লিস্টে দিয়ে দেবেন কালকে দিয়ে দিন একদম কালকে ঠিক আছে 23টা শেষ করে নিই তারপর শুধু ওয়েবসাইট
One line may be added that personal appearance is dispensed with.
Very one line ওটা দিয়ে personal appearance of the alleged contemners be dispensed with.
Grateful, Lordship.
Original site mentioning.
My lord, may I have your Lordship's kindly to mention this matter for correction of your Lordship's leaves.
Original
Whatever
site?
it is, my lord.
Yes, hand on.
My lord, in the second page, instead of January.
Point out when it appears as to be mentioned tomorrow, we'll just correct. করে দেবো? কালকে to be mentioned. Yes. One who is appearing.
Lordship, I am appearing for the
Yes.
petition.
What is that?
Item number 1.
Lordship, this is my section 11 application. Lordship, in the last order had directed for preparing a consolidated affidavit of service.
Right.
Lordship, this is my consolidated.
Good service has been effected on all the respondents.
Lordship, the speed post service shows insufficient address, but
All
we had given the letters, emails to the registered email address of the partnership firm.
Huh.
Lordship, nothing has bounced back, so therefore we take it that it has been received.
What is
Because,
the dispute?
Lordship, the dispute arises from a facility agreement, loan facility agreement, which starts from page number 13 of the petition. Lordship, through this loan facility agreement, one Ugro Capital.
Master service agreement is different.
Lordship, the master service agreement is between Ugro Capital
Right.
and another party. And the respondents here are the agents of this respondent party against the master service agreement was between Ugro Capital and Hema Engineering, where Hema Engineering,
Master service agreement contained any arbitration clause?
it has a separate arbitration clause where the venue is Delhi. We are not,
Very well. Let me see the relevant agreement,
Lordship,
your
the
facility-
relevant
facility agreement or whatever.
facility agreement starts from page number 13, Lordship,
30.
and the clause is at page 18, clause 13. The governing law, jurisdiction and arbitration.
What is your present dispute?
Lordship, the present dispute is we had, my client had given a loan of around 80 lakhs,
Right.
out of which there has been some repayment, but the rest has not been made. So the
So
dispute,
you'd move against the agent without the principal.
Lordship,
Because
Lordship,
he has, the agent you are saying is, has acted beyond the scope of the agency. Otherwise-
Lordship, here, the relationship between the principal,
Yes,
the master service agreement is, Lordship, for example, between A and B, where B, the objective of B was to identify some of the customers who needed financial help. So we
you
had,
are not a party there.
no,
Oh, acha. Very good. Then you are not bothered with it.
no.
So show me the page 18.
Lordship, page 18, clause 13.
Is there anything contrary in the master?
Nothing contrary.
Nothing
Lordship,
contrary.
Nothing contrary. Lordship, we had given a demand notice, which is at page 62,
Yes. 62, right?
where we had claimed about 81 lakh 44,000. Then we had, Lordship, given a section 21 notice, which is at page 93.
Very good. What is the valuation of the?
Lordship, the valuation will be around 82 lakhs.
I'll appoint some High Court judge.
Lordship, any
Should be
advocate,
senior advocate.
any senior advocate,
Not very senior, but
not very.
yes. Very good. Take it. Despite repeated efforts to serve, none appears for the respondent, although the petitioner is represented through counsel. Full stop, the affidavit of service is kept on record. Full stop, next para. The dispute which has arisen between the parties primarily pertains to a money claim and falls within the purview of clause 13 of the facility agreement between the parties dated September, 5th September. Some things are scored through. Page 14, please come to that.
Lordship, page 14, the date will be at.
এখন আপাতত লিখেন September 5, 2019,
Lordship,
which is the concerned arbitration clause.
Lordship.
Full stop, next para. The said clause provides that in the event of any dispute or difference between the parties under the agreement, including in relation to the construction or interpretation of the agreement, the parties shall first endeavor to settle such dispute or difference by amicable negotiations. Full stop, if the negotiations do not result in a resolution of the dispute or difference, either party shall be entitled to submit such dispute or difference to arbitration. Full stop, 1 minute, a second. What about the negotiations?
Lordship, the negotiations, like the demand notice was given on 7th April 2021.
Not a negotiation.
Lordship,
That's not a negotiation.
Lordship, that is what was done. The demand notice was given, therefore.
So you'll have to exhaust that first.
But Lordship, there is no one who is receiving the notice, or we are not being able to trace the respondents. They are not even there in the last address. All kinds of approach has been exhausted.
What is the statement in your application regarding that negotiation? Very well. They have taken out a section 21. No, they have not taken out. You have taken out. So you'll have to satisfy me on that. I'll grant you liberty to file supplementary affidavit, produce whatever document you have regarding negotiation.
Negotiation.
What about the negotiation? Prior negotiation was to be there. Where is the attempt of negotiation?
That attempt has not been exercised.
Then you
Fine.
cannot.
I understand.
Then I'll have to dismiss it with liberty to file after the negotiation is over.
But Milord will kindly take this into consideration that this is Milord is implicit a case of money lent and advanced. Your
There is a
Lordship-
specific clause of negotiation.
Yes, that is there. That is there. But Milord, kindly keep
Negotiated with-
keep this pending Vishal, my lord, we have
Push-up.
been calling upon them.
It
Even-
does not transpire from the averments made in the application per se that any prior attempt at negotiation was undertaken by the parties. First up, since clause 13.2 specifically contemplates prior negotiation, comma, only on the failure of which the matter would be referred to arbitration, comma, the petitioner is directed to satisfy this court regarding prior negotiations or attempts thereto having taken place, at least on the part of the petitioner. First up, on the prayer of learned counsel for the petitioner is directed to file a supplementary affidavit indicating such efforts on the part of the petitioner, comma, if any. First up, the supplementary affidavit shall be filed on the next returnable date, that is on next Monday. I'm keeping it.
Lord, kindly take, Lord, we have not attempted that.
No, we don't know. We
We are-
can.
Then I'll
Lord,
record that. Are you sure on that? You have instruction on that?
Lord, we will take instructions kindly. Your lordship's directions, my lord, will
If
will
any.
be there. If any, yes.
That's
If
there in my
any.
order.
Lord, if there is.
When should
no
I keep
such-
it?
My lord, after 15 days, my lord.
We had made a demand.
Within 15 days, there is a change of determination. There is a
No.
chance
My
of
lord, I will not be there. There's some
15 days.
Dorkan
Then
made.
come back tomorrow. No, that is not a reason.
My lord, not tomorrow. Sir. After 15 days,
24th.
my lord, let it be 25th or 26th. My lord, 24th, I'm not there.
Very well. The matter shall next be listed under the same heading on April 26, 2023.
I'm here for the 26th, no?
Should have pointed this out, ma'am, at the outset.
Lordship, actually, I thought it was a demand
And even look
notice.
into the arbitration clause. Anyway,
We shall exercise, my lord. Obliged.
Item number 2.
yes,
So
Mr.
sorry,
Shen.
my lord, on the last occasion, I got stuck in the other courtroom.
Lord,
could come on time.
yesterday, your
Yes,
lordship
Mr.
not have
Chakravarti.
passed an order, Lord, on a similar matter between the same parties.
Acha.
Lord, Mr. Sen wanted to, Lord, refer to your lordships to some, Lord, points that he wants to raise. Perhaps, Lord, if I have understood him correctly, Lord, here in this matter,
Yes.
2 purchase orders have been, Lord, referred to in the petition.
It is for the petitioner.
He's for the
The
respondent.
respondent,
before
my
the
lord,
respondent.
I have taken a preliminary objection that this section 11 is not maintainable because they have tried to
Hmm.
make a composite reference for arbitration. There are
For
two
that.
separate and distinct purchase orders involved.
This is regarding the other.
This is regarding the other one. In the other matter, Mr. Siddhartha Banerjee
There
has
was
been
only
appointed.
one purchase order, so there was no
Yes, there
difficulty.
was no difficulty, my lord.
But may I
did
just
not object.
answer to this? May I just show you lordship only one document? But kindly take page 14 and page 22. Page 14, kindly take page
Have you
14.
got that previous order, Mr. Chakravarti?
Okay.
Should you just taken out a printout?
AP 83. I'll get a printer right now.
14 and?
Page 14, kindly first take.
Yes.
Lord, kindly see at the top right hand side, order number. My lord may see it ends with 1. 1.
Yes.
Date is 14th August 18. Then kindly, my lord, come down to the box, contract number. Lord, right hand side, contract number.
Yes.
C32225.
Right.
Now kindly come to page 22, the second purchase order. Lord, the contract number is same.
Should I formally record your objection, Mr. Shen?
Yes, your lordship, now only one line of argument, my lord. In the judgment of Duro Felguera, the Honorable Supreme Court has decided the same point, that even if the work is intrinsically interlinked, as well as if it pertains to the same project, then also if there are separate purchase orders or work orders or contracts involved containing different
Brought that
arbitration
judgment?
clauses. Yes, your lordship.
Cited.
Here the contract is the same.
Mr. Chakravarti,
Well, the
please bring the
parent
other,
order.
my other order.
Really give me 1 second. Print code anis na bolto.
Yes. Yes, Mr. Shen, you first. Let
Paragraph
him submit first.
22.
হ্যাঁ, আর কি চাইছে?
Paragraph 22.
Paragraph 22 onwards, my lord.
All right,
Because
all
from
right.
there on, the
Yes, yes. whatever.
discussion regarding the composite reference had taken place. My lord, on behalf of GPL, it was repeatedly urged that the works are intrinsically connected, inseparable, integrated, interlinked, and they are one composite contract. And that they were split up only on the request and representations given by Duro Felguera and FGI. As discussed earlier, as per the amended provision, Section 11(6), the power of Supreme Court or the High Court is only to examine the existence of an arbitration agreement. From the record, all that we could see are 5 separate letters of award, 5 separate contracts, separate subject matters, separate and distinct work. each containing separate arbitration clause signed by the respective parties to the contract. Well, this was argued.
So
Similar
in
case,
your case, what are the distinct works?
the two purchase orders are separate,
The work is same.
and the two purchase orders contain separate arbitration.
No, that is
clauses.
different. Can I once look into the work order?
Yes, Your Lordship.
Yes, that
Page number
contains the
14.
arbitration clause.
Yes, Your Lordship.
Very well. Let us come to that.
Page 14 is the first work order.
You want to see the scope of the work.
It's a contract for supply. It's a purchase order for supply of goods.
But the turnkey for the construction. sir.
Well, the project is that of Cochin Shipyard. Supply of materials.
This was the other order, 83, AP 83.
AP 83.
Yes, I'm sorry. Mr. Shen, please come back to our, the contract.
Yes, Your Lordship. Page number 14 is the first purchase order.
14 is yes. What is
And
the
then-
scope of the work?
Well, this is for supply of good for materials.
Where do I
Like the
get it?
materials have
Anything
been
else?
item
NIT or
description.
NIT or something else?
Yes, Your Lordship. No,
Show me
there
that.
is no NIT, my lord. There is
sir.
only a purchase order involved, and the arbitration clause is at page 21.
21, yes.
Clause number 24, Your Lordship. In the event of any dispute or difference arising out of and in connection with the purchase order, such disputes shall be firstly attempted to be settled by way of mutual discussion. In case of failure of the parties to reach an amicable settlement within 30 days from the date of referring the disputes for mutual discussion,
Yes.
the disputes will be referred to arbitration. And then on failure to arrive at a mutual settlement, then the arbitration clause is there.
This
But
i-
my argument is
Yes. Section 21 was composite.
Section 21 was composite.
Achha.
And also
Yes.
section 21, my
Please
lord,
show me
is in
that,
the
please.
second volume, my lord.
Second volume, right?
It is at page 201. In fact, the section 21 notice contemplates 3 purchase orders.
What about the other one? They're waiting
It
for
is not
this.
there.
Waiting for this.
I don't know, my lord, but it is not there.
Anyway,
My lord, if your lordship sees page 201,
201, yes.
please take notice that pursuant to clause 24B of the agreement purchase order dated 14/8/2018 and subsequent amendments are referred, then 2 is mentioned. Well, just 3 lines from the bottom of the page, and then again 3 on the next page. Invocation pertains to 3 separate purchase orders, maybe for the same project, maybe, but my lord,
Transactions are
transactions different, my lord, the scope is different, my lord, there are distinct arbitration clauses involved, as well as the
arbitration clauses are identical.
identical, my
But,
lord,
yes,
but
Separate
the
clauses.
word is
Hmm.
that disputes arising out of this
This
purchase.
agreement, yes.
That is where I'm at.
All right.
So that is my only objection to this, my lord. It had to be either 2 or 3 references, my lord, under each of the purchase order, because a
Supreme
composite
Court say,
reference
let
is
us
not- yes,
continue with that.
yes, my lord.
I've understood the context of your argument, yes. We were at para
Paragraph
22.
22.
Right.
My lord, then the
You have read
finding-
para 22, so
Yes,
need
your
not
lordship.
repeat.
I'm just indicating the finding.
Yes, yes, absolutely.
Well, we have to read paragraph 22 onwards only. Well, the argument is there
Mhm.
entirely. Then all 5, then paragraph 23, my lord, all the 5 contracts awarded to Durofelware and FGI have independent arbitration clauses.
Hmm.
Mr. Sunil Gupta and Mr. A.M. Singhvi, learned senior counsel, have taken us through the contract agreements and submitted that all 5 different contracts have independent arbitration clauses. In the contract new package, there is a header supply of bulk materials, etc., etc. Well, and I'm not reading that.
Why you
Similar-
had different work orders issued?
Well, it's from time to
Different
time.
time to
From
time.
time to time,
Mhm.
yes, your lordship. Maybe for the same project, we require further materials.
Maybe.
So
yes.
from time to time, purchase
That's right.
orders have been placed on them.
Right, right.
But then, my lord, paragraph
January.
42. Paragraph 42, the learned senior counsel for GPL relied upon chloro controls. Well, this is the first case wherein the composite reference was decided.
Right.
Chloro controls to contend that where various agreements constitute a composite transaction, courts can refer disputes to arbitration if all ancillary agreements are relatable to the principal agreement. And performance of one agreement is so intrinsically interlinked with the other agreements. Even though chloro controls has considered the doctrine of composite reference, composite performance, etc., the ratio of chlorocontrols may not be applicable to the case in hand. In chlorocontrols, the arbitration clause in the principal agreement, that is clause 30, required that any dispute or difference arising under or in connection with the principal or mother agreement, which could not be settled by friendly negotiation and agreement between the parties, would be finally settled by arbitration conducted in accordance with the rules of ICC. The words thereon, under and in connection with, in the principal agreement was very wide to make it more comprehensive. In that background, the performance of all other agreements by respective parties, including third parties, non-signatories, had to fall in line with the principal agreement. In such factual background, it was held that all agreements pertaining to the entire disputes are to be settled by a composite reference. The case in hand stands entirely on a different footing. As discussed earlier, all 5 different packages as well as the corporate guarantee have separate arbitration clauses, and they do not depend on the terms and conditions of the original package number 4 TD, nor on the MOU, which is intended to have clarity in execution of the work. Duro Felguera, being a foreign company, for each of the disputes arising under package number 4 and corporate guarantee, International Commercial Tribunal, Arbitration Tribunal are to be constituted. Duro Felguera has nominated justice, the name justices are there. Along with the above 2 arbitrators, Mr. Justice R.M. Lodha is appointed as presiding arbitrator. There was international arbitration was held separately and the domestic arbitrations were held, the references were held separately in this case, ultimately, not a composite reference. There were 2 parts of the contract. One is an international arbitration and the other the domestic arbitrations. Maybe the arbitrator can be the same. The references have to be separate. And in this case, in the case in our the facts is that there is no principal or mother agreement involved. There are purchase orders. Each purchase order contain a different and separate arbitration clauses. So they have to be looked into separately. There have to be claims distinct from each other. It does not depend upon the supply in respect of the other purchase order involved. That is my only objection. There has to be separate invocation. There has to be separate section 11. Even if the invocation is composite, but the section 11 had to be separate. There is also a line of judgment, my lord.
Section 11s are separate.
No, section 11s are not separate, my lord.
Here there are 2 purchase orders.
Yeah, there are 2 purchase orders involved.
Oh.
There is a line of judgment which say that the invocation notice can be combined, but you have to file separate section 11. I am not saying that the invocation is not maintainable. I am only saying
this particular this section 11 is pertaining to 2 purchase orders.
2 purchase orders. Yes, your lord.
Shall direct them to put in the additional court fees.
Yes.
Why these technicalities?
Absolutely.
My lord, the only thing is it should not set a precedence because the
Why not a
difficulty is,
precedence?
my lord, yes.
Why not a precedence? Because I'll have to then clarify that they'll have to put in the additional court fees for 2 matters.
We'll do that.
It will boil down to the same thing.
Yes, your lordship.
Unnecessary wastage of time of the
because
court
this-
is saved, of all the other litigants are saved.
Fine, my lord. But I don't have a problem with that because they
We
ultimately
should move
had to
forward,
file-
Mr.
Yes,
Chair,
your
not
lordship.
backward.
Yes, your lordship.
I
They had
will
to file
segregate that
separate-
these technicalities.
2 separate references.
Definitely,
against
you
the
are
Act
right on
file.
that. 2
Yes.
references had to be made.
Yes,
I
yes.
thought it was only on one section.
No, my lord. there's 2
Definitely, they had to make 2 section 11
Yes,
applications
your
and treat this as 2.
Yes, your lordship.
Why not a precedent? I want this to be a
I leave
precedent
it to your
so
lordship, my
that
lord.
future composite applications are dealt with in this
Well,
manner.
it might inure to my benefit also in some other case. My lord, fine, my lord. I leave it to your lordship.
Not
my lord.
financially maybe, but otherwise. Yes.
Otherwise,
As
my
an officer of the court, definitely.
Yes, your lordship.
I'll do that.
Yes,
I'll record this.
yes.
Yes. Anything else you want to worsen your case?
No,
Yes.
nothing, Lord.
Learned counsel, sorry.
Lord,
Learned counsel for the petitioner contends that in view of the specific arbitration clauses in the 2 purchase orders in question, comma, which arise from the single composite work, comma, an arbitrator ought to be appointed, comma, as the invocation under section 21 of the Arbitration and Conciliation Act 1996 has failed to evoke any agreement between the parties on the arbitrator. First up, next para. Learned counsel appearing for the respondent submits that the present composite application under section 11 of the 1996 Act is not maintainable in law. Full stop. First, comma, it is submitted that the invocation was common for different purchase orders, comma, which were independent and distinct on point of time. Distinct on point of time. Stop. It is further submitted that the composite applications cannot be clubbed together, comma, since there are distinct and different purchase orders. Full stop. In this context, comma, learned counsel for the respondent places reliance on the judgment of Duro Felguera. Please take down from the constat. Reported at 2017 9 SCC 729. Full stop. By placing particular reliance on paragraph number 22 of the said judgment, comma, learned counsel contends that if there are separate subject matters and separate and distinct work covered by the separate contracts, comma, each containing separate arbitration clauses, comma, there cannot be a composite invocation under section 21 and stroke or a single application under section 11 of the 1996 Act. Full stop. Next para. Learned counsel further places reliance on paragraph number 42 of the judgment, where the Supreme Court took into consideration the judgment of Chloro CHLORO Controls India Private Limited and distinguished the case at hand from the said report in the line that in Chloro Controls Supra, comma, there was a principal parent agreement, comma, under and in connection with which the subsequent agreements were entered into. Full stop. Next para. It is submitted that unless there is a parent agreement, comma, the arbitration clauses in distinct and different agreements cannot be clubbed together. Full stop. Next para. Learned counsel for the respondent reiterates that, comma, in the present case, comma, there is no parent agreement as such. Full stop. Next para. Learned counsel appearing for the petitioner opposes such contention and submits that the purchase orders, comma, although separate, comma, refer to the same contract number. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it transpires that although the different purchase orders clubbed together are distinct and different in identity, comma, both the said purchase orders pertain to the same work. Full stop. That apart, comma, although issued at different points of time, comma, it cannot be said strictly that the subject matters of the two are dissimilar, or they contemplate separate and distinct works. Full stop. Although proceeding on a hyper-technicality, comma, the purchase orders contemplated different bulks of orders, comma, in effect and for all practical purposes, comma, the said orders went to aid the same work process. Full stop. Next para. Moreover, comma, there is no specific bar in a composite invocation under section 21 of the 1996 Act being issued in the statute itself. Full stop. Even if there are distinct and different arbitration clauses, comma, if the bundle of action, the bundle of facts which give rise to the same chain of cause of action is the same for all the said agreements, comma, there is no reason why arbitrator ought not to be appointed for dealing with and deciding the disputes arising from all such connected agreements. Full stop. Moreover, comma, in the present case, comma, the language of the arbitration clauses in all the purchase orders are similar. Rather, they are almost identical. Full stop. Next para. In view of the above discussions, comma, there cannot be any reason to hold that the invocation under section 21 of the 1996 Act was vitiated by any illegality or irregularity. Full stop. Next para. However, comma, learned counsel for the respondent is justified in submitting that at least for the purpose of the records, comma, separate applications under section 11 ought to have been filed by the petitioner. Full stop. Although agreeing in principle with such suggestion, comma, I am of the opinion that unnecessary technicalities, comma, mandating the petitioner to withdraw the present petition and file separate applications under section 11 of the 1996 Act would inure to the benefit of none of the litigants. Full stop. The said defect, comma, if any, comma, is curable, comma, to say the least, by directing the petitioner to deposit the additional court fees as would be deemed fit for separate applications under section 11 of the 1996 Act. Full stop. Next para. In such view of the matter, comma, AP 83 of 2023 is disposed of.
This is 86.
I'm sorry.
86 is.
AP 86, thank you. AP 86 of 2023 is disposed of, thereby appointing Mr. Siddhartha Banerjee, mobile number, please take down from here, an advocate practicing in this court as the sole arbitrator to resolve the disputes between the parties pertaining to the purchase orders referred to in the present application under section 11 of the Arbitration and Conciliation Act 1996, comma, subject to obtaining his declaration stroke consent under section 12 of the 1996 Act. Full stop. Next para. However, comma, as a precondition for this order to take effect, comma, the petitioner shall deposit the additional court fees equivalent to that of separate applications under section 11 of the 1996 Act for the different purchase orders referred to in the application. Full stop. Such deposit shall be made by the petitioner within an outer limit of April 21, 2023. Full stop. In default, comma, however, comma, this order shall stand automatically revoked, and the matter shall be placed in the list for further hearing. Full stop. Thank
My lord, only one line, my lord,
Yes.
where the contract number is mentioned, that particular contract number is for identification between my principal and the respondent.
No, I've recorded their submission. Contract number is same and the work process is
The
same.
contract number is the same because it relates to the work of Cochin Shipyard. That's the reason.
Has to be.
Obliged, my lord.
Thank
Item number 3,
you. 3 years
Pooja Roy versus Sri Pranab Kanti Roy and others.
আগে appear করেছে। None appears for the parties when the matter is called on for hearing. Full stop. It is seen from the order sheet that on March 2, 2023, comma, the applicant had sought time to place on record the notice under section 21 of the Arbitration and Conciliation Act 1996 along with a supplementary affidavit. Full stop. However, comma, even after such order of the coordinate bench then taking up the matter, comma, the matter was called on for hearing on April 18, 2023 by this bench when none appeared for the parties. Full stop. Next para. Hence, it transpires that the petitioner is no longer interested to move his matter. Full stop. Accordingly, AP 92 of 2023 is dismissed for default without any orders to costs. আছে আচ্ছা সিন করে দিতে হবে, তাই তো সিরিয়ে দিচ্ছি। কালকের লিস্টে করতে দেবো, কিন্তু যা যা বাকি আছে সব দিয়ে দেবেন একদম। তারপর 2024 গুলো হাত দেবো। হ্যাঁ হ্যাঁ, আপনার শুনে হতে পারে। তাদের এত সহজে ছুটি দিচ্ছি না আমি। Thank you. এবার appellate side তো? Now the appellate side matters will be called on. Thank you.
Appellate side, to be mentioned item number 3.
কিছু তুই মেনশন এসেছিল মনে আছে?
I am appealing for the petitioner. my lord.
You mentioned the matter.
Yes, Lord.
Yes, what do you say?
I am for the respondent, my lord, for WBACDC.
No, you said the matter had previously been disposed of or something like
No,
that.
my lord, actually, I have not,
Please use the microphone.
actually, I not got the notice of this matter.
That is not a ground, simply said. You said something else also. You said yesterday when you mentioned the matter
Yes, my
that
lord.
there was a previous or it was previously disposed of.
It was a transferred matter. He already informed, actually,
How is that relevant?
that matter was at the time of the corona. On that period matters, my lord.
Yesterday was not the corona period.
No, my lord.
It was taken up in the list. It appeared in the list.
Notice was duly served and
Notice was also served. No question of recall of this order.
No,
An impression was given yesterday, comma, after the order dated April 18, 2023 was passed, comma, that the respondent had not been given any notice prior to mentioning the matter for inclusion. Full stop, next para. Such contention is disputed by learned counsel for the petitioner who submits that the affidavit of service filed in court indicates that service was effected with regard to the writ petition on the respondents. Full stop, next para. An impression was given further by the learned advocate for the respondent yesterday that a prior order had been passed in the present matter. Full stop. However, comma, on query of court today, comma, it is submitted that that there was no prior order, but only that the notice of mentioning was not given to the respondent. Full stop. The listing of the matter itself appears as a public notice. Full stop. Next para. Upon being satisfied regarding service from the affidavit of service, comma, the matter had been taken up for hearing and decided in the absence of the respondents, comma, since the respondents chose not to appear at the time of call. Full stop. Hence, comma, no further order of recall of the order dated April 18, 2023 need be passed. Full stop. Hence, comma, since the writ petition has already been disposed of, vide order dated April 18, 2023, comma, no further order is being passed in the present matter. Full stop. Let the file be sent to the concerned department.
Item 4 for correction.
Lordship, I'm for the petition. I'm praying for correction. For your
What
lordship's
is the correction?
convenience, a pencil corrected copy.
Right.
On page 3, your lordship.
Oh, the private response will be petition. The reverse.
Yes, sir.
Apart from this, anything else?
No, your lordship.
Very good.
There are 3 corrections, your lordship.
In the same page?
Yes, your lordship.
Yes.
Mr. Naik is for the WBCDC lordship.
No, 7-7-2.
Learned counsel appearing for the petitioner points out that 3 mistakes had crept into the order dated April 5, 2023, passed in the present writ petition. Full stop. At page 3 of the said order, comma, in the penultimate paragraph and the paragraph before that, comma, the expression petitioner within single inverted was printed instead of the expression private respondent. Full stop. Again, comma, instead of petitioner, comma, in the penultimate paragraph, comma, the expression ডাবল ইনভার্টারের মধ্যে প্রাইভেট রেসপন্ডেন্ট had been transcribed. Full stop, next para. It is evident that it was a bona fide mistake on the part of the court. Full stop, as such, comma, in the third paragraph of the second page of the order dated April 5, 2023, comma, it
Your
would,
Lordship, third page,
third
page, last para, Your Lordship.
no, two paragraphs.
Yes, Your Lordship.
There are
The
two.
6th line and the 14th line.
Very well. Third paragraph now the in the 2, 4, 6. In the 7th line from the top at page 3
Sorry, Your Lordship.
and
8, 9, 10, 11, 12.
and the 14th line from the top in the same page, comma, the expressions petitioner, comma, appearing twice in the 6th line shall be replaced by the term within double inverted private respondent in both cases, and the expression within double inverted private respondent shall be replaced by the expression double inverted with the petitioner in the 14th line. Full stop, let this order be deemed to be a part of the order dated April 5, 2023. Full stop, the latter order be deemed to stand corrected accordingly. Later na kintu, latter.
Grateful, Your Lordship.
Thank you and sorry for the mistake. Yes. Thank you. Call on the next one.
New motion, new motion,
I'm for the petition.
new motion, item 5.
Yes.
Lordship
You are for
would
the
kind
state.
enough to see your lordship's last order.
Yes.
My lord, a sketch was, my lord, produced by the learned advocate
What is the
representing.
dispute, Mr. Bhattacharya?
No,
Just
my lord, a
revert me.
new connection of electricity, they are objecting, my lord, that's the whole dispute.
Right.
Now, my lord, kindly see, my lord, the sketch map which was handed over by the learned advocate for the added respondents in this
Yes, yes.
writ petition. Kindly see.
One sketch map was annexed to the report.
No, Lordship,
No, my lord,
one
this was
sketch map I have already submitted. Lordship.
handed over, it was.
Just check. এই sketch map বার করো।
Single page.
রিপোর্টটা একটু আলাদা করে দাও। Sketch map আরেকটা, there will be another sketch map.
That was single page.
Let us find out from the records. Right. No. This was by the private respondents.
By the added
Added
respondents.
I am for that respondent.
Now, my lord,
Yes. That's
kindly.
what do you say regarding that?
Yes, kindly see, my lord. They say that this is RS plot number 17, tag number 1749 is their land. Now, my lord, kindly see on the bottom, RS tag number 1750. On the right hand side, RS tag number 1748.
Yes.
On the, my lord, top 1746.
Which is yours?
Yes, that I come. Now, my lord, kindly comes to, my lord, the writ petition kindly comes to, my lord, page 3, paragraph 3. Your page 3, paragraph 3.
Yes.
Your petitioner states that your petitioner has been residing in his property and has been categorically enumerated in the schedule below for the time immemorial without specific interference or objection from any authority or any person. Schedule is District Howrah, Moujas, Bipranopara, Khotian number 3190, jail number 27, PS Jomdu, LR plot number 1792. That according to their own schedule, LR 1792 is nowhere in the vicinity. Therefore, they have no right to object.
Lordship, they want to take the
Anything
connection.
else, Mr. Bhattacharya?
My lord, this is their sketch. And my lord, they do not show, they have not shown any alternative route, whether there is any,
I'll come to you, please. Yes.
whether there is any, my lord, pole in the alternative route, my lord, nothing has been stated.
Very well. Yes. What is your submission?
Lordship, the passage written that white private passage is our passage, our private passage. Here in this arrest tag number 1749, we are residing. I am only residing in this property. We are having the partition suit pending between our brother and sister. They are not staying there, so I am the only person who can raise the objection. I only raising objection not to take the connection over my private land, and they can take otherwise anyway, by any way. Let the authority inspect and give them connection. I have no objection against that.
Yes, Mr. Rai, what do you say?
Now, we want to give connection, the objection, due to objection, we can now.
So
only
joint
the-
joint
from the
inspection.
sketch map,
Yes.
it appears that it is LR tag number 1791.
1792 is nowhere there as
Now, 1791 at sketch map, it is LR tag 1791. And the petitioner's plot is 1792 LR tag.
That is just behind my,
these are RS references.
They have given to RS and also LR. On
Oh,
the-
LR is also
At the
Yes, on
top, my lord.
at the top I've seen. Yes, yes.
RS and LR, they have, therefore, it adjacent plot. Now, the exact location of our existing pole and the new connection where it will go, that is, my lord, my instruction, there is no alternative way. Therefore, if they, my lord, allow us to give underground cable connection, then we can provide, the petitioner will provide.
They say it's a private passage, Mr. Rai.
That will be,
So how long will it take to use that passage? I mean, to lay underground cables? Approximately, I mean,
I think within 7 days it can be.
if there is
These
no
days-
alternative, what can be done? If the WBACDCL says there is no alternative,
Lordship, there is a panchayat pathway in RS Dag number.
you have not
174.
shown or is LR Dag number, his Dag number 1792 in this map. Where is that?
That
In
I
your
don't
map,
have.
there is no mention of there.
Lordship, that
So
is
how do
not
we
there.
know which is their plot? Why should we unnecessarily direct another inspection by the WBACDCL? They'll give connection over wherever possible.
Only my private passage is.
Private passage will remain private, no equity will be created, but underground connection,
Connection will be,
Domestic,
not high tension.
Domestic.
High tension for the litigants, but not high tension power.
This is domestic connection.
Domestic violence is the maximum high tension thing. Anyway, but this current, this electric line will not be high tension. Domestic connection. Yeah, I'll pass that order only. Learned counsel for the petitioner contends that in the within single inverted site plan, single inverted clause produced by the added respondent, comma, there is no mention of LR Dag number 1792, comma, of which the petitioner is the owner and at which the electricity connection in question has been sought. Full stop, next para, learned counsel for the added respondent, comma, however, comma, contends that the electricity connection sought to be given to the petitioner is intended to be taken over the 6 feet wide private passage of the added respondent as indicated in the site plan. Full stop, it is submitted that if such connection is taken, comma, it will adversely affect the safety and security of the added respondent. Full stop, next para, learned counsel appearing for the WBACDCL points out that the numbers shown in the site plan are RS Dag numbers, comma, whereas the LR Dag number is 1791 as indicated in the caption of the site plan. Full stop. Hence, comma, it may very well be possible that the petitioner's plot is adjacent to the plot of the added respondent. Full stop, next para. However, comma, it is further submitted by the WBACDCL on instruction that the passage over which the connection is being sought to be taken for the purpose of giving supply to the petitioner is the only feasible alternative for giving such connection, comma, keeping in view the existing electricity poles and other arrangements of the licensee. Full stop, next para. The primary concern, comma, as it appears from submissions of learned counsel for the added respondent, is that there would be drawal of high tension overhead line, which will affect the user of the private passage of the added respondent. Full stop. However, comma, it has been fairly suggested by learned counsel for the WBACDCL that underground connection can be given below the said passage. Full stop. Moreover, comma, both the WBACDCL and the petitioner point out that the connection will not be a high tension line, but is merely a domestic connection to be given to the petitioner. Full stop, next para. Keeping in view the lack of any other alternative and the surrounding circumstances as indicated above, comma, the petitioner's right to get an electricity connection in his name at his property cannot be prevented merely because the line has to be laid under the property of someone else. Full stop. If the land is otherwise land bound, comma, there is no other option but to supply electricity over the passage of some other neighbor, no, some neighbor or the other. Full stop, next para. In the present case, comma, however, comma, the apprehension of the added respondent can be alleviated if the WBSEDCL lays underground line to give connection to the petitioner, comma, beneath the claimed private passage of the added respondent, full stop. Hence, comma, WPA 4812 of 2023 is disposed of by directing the WBSEDCL to give a new electricity connection to the petitioner, comma, if necessary, under the passage claimed to belong exclusively to the added respondent, full stop. Such connection shall be given subject to compliance of all formalities by the petitioner in that regard, comma, preferably within 4 weeks from the date of such compliance of formalities. Full stop. It is, comma, however, comma, made clear that the WBSEDCL shall make all endeavor to do the work of digging the private passage at the most within 7 days. Full stop. Next, that apart, comma, and notice of the work shall be given by the WBSEDCL to the added respondent before commencing the work. Full stop. Next para. That apart, comma, during the work being undertaken, comma, the WBSEDCL shall take care that at least a strip of a passage is left open for the added respondent to use as a pathway for ingress and egress. Full stop. Next para. In the event any obstruction is offered by the respondents in the WBSEDCL personnel in giving such connection, comma, it will be open to the WBSEDCL personnel to approach the respondent number 6, that is the officer in charge of the Domjur police station, for adequate police assistance, comma, which will be given by respondent number 6 at the cost of the petitioner by acting on a server copy of this order. Full stop. No order has to cost.
Only one thing, my lord, the additional cost in respect of the digging underground.
Whatever cost.
No, that will be bear by the petitioner, because
I need not specify that, Mr. Rai. That will create a problem. If I specify, they'll have to bear. If that is the, yes. If that is the law, they'll bear.
Lordship has stated subject to compliance.
Subject to compliance of formalities, and only after 4 weeks from that compliance, you will do it to it. Within 4 weeks, rather. Great. Thank you.
Item 6.
I am for the petition.
Yes.
This is new electric connection of submersible pump set, my lord. Last occasion, your lordship directed
I
to
beg to appeal
file
before
report.
the WPH. There was a direction.
Quotation has been issued and
Then how many submersible pumps in West Bengal are left not yet connected with electricity within your district? So file the applications together. I'll treat them separately, pass separate orders. But do them in at one go, then there'll be more disposal for the court, and then you'll get several orders on the same day. You can purchase a house and.
This is from Malda. I am in Birbhum.
Oh, very.
The day before yesterday only we were having a talk, Manad. He is saying that Malda district, Manad, there are around 500.
There is much parent territory now. Yes, I was wondering.
But
Anyway,
I have
Mr.
complied.
Mukherjee, any difficulty?
I have complied. I've given the
Quotation has been issued. I have deposited quotation amount.
So what is the difficulty? Don't press
No,
this.
no.
Very well, I'll dispose it of. Learned counsel for the petitioner submits that in the meantime, comma, the WBSEDCL has raised a quotation, comma, pursuant to which the petitioner has deposited the due amount for getting a new electricity connection to operate his submersible pump. Full stop. Such stand is corroborated by learned counsel for the WBSEDCL. Full stop. Hence, comma, nothing further remains in the present petition full stop accordingly, WPA 7897 of 2023 is disposed of by directing the WBACTCL to effect the new connection to the petitioner as expeditiously as possible, positively within a fortnight from this date.
I'm grateful.
No address to cause urgency.
I'm grateful. I'm
7.
Time for the petitioner, my lord.
Yes, please.
appear for the respondent.
Right.
CSC.
Yes.
I'm for the private respondent, my lord.
My lord, I am an occupant and tenant in respect of ground floor of the premises.
Can you please come a bit closer to the mic?
My lord,
Yes, thank you.
I am an occupant and tenant in respect of the ground floor of the premises. My connection was there and subsequently on due non-payment of electricity, my lord, the connection was disconnected. Subsequently, I paid the remaining the bills and subsequently the CSC approached for restorations. CSC was registered by the private respondents. Accordingly, I filed 144 applications and learned executive.
Registered in giving the restoration of connection.
Yes. So subsequently, I filed an application under section 144 of criminal procedures asking for restoration assistance to the CSC authority for restorations. And accordingly, direction was made directing the concerned OC to render necessary assistance. Even though, my lord, in spite of having directions
Who
specifically
gave the direction? 144.
144 executive magistrate.
Right.
In spite of that, my lord, CSC was unable to restore the connections. When my lord CSC people comes, the private respondents against with my lord a dispute is pending between me and the private respondents, they are resisting the objections.
What is the dispute?
My lord, I am saying
According
that
to you.
yes, according to me, my lord, I am a tenant because I have a agreement with one of the respondent and suddenly one,
Saditya is vehemently moving his hand, shaking his hand. So anyway, let us hear them. Yes,
My
Mr.
lord.
Aditya, what is
My
it?
lord, there is a checkered past history of this in this case. My lord, this petitioner
Yes.
is a maid servant of this octogenarian senior citizen
Hmm.
in the year 2020.
Hmm.
And during the time of lockdown,
Hmm.
this petitioner asked this petitioner opposite parties to allow them to run a hotel. That means in the rock of this building. Subsequently, what happened? They make an agreement that she will use only one floor, one room, and the toilet commonly. But what happened? In the meantime, this petitioner make an application before the CSC authority in the name of a dead person who by obtaining a consent from a dead person and obtain this line.
Who is the dead person? Really? How is he?
Deepak,
Who is he to you? I mean, how is it related?
he is one of my elder brother.
Very. Then
Deepak,
whatever. Your elder
Deepak
brother.
Kumar Rai. And there was a objection raised before the CSC authority. Subsequently, this agreement was a leave-in license agreement for 11 months, which ends in the month of 5th May 2021. And during that period, just to make the possession, forceful possession, he make an application, title suit before the Alipur court.
Declaration of tenancy.
Yes, declaration of tenancy and permanent injunction. Injunction has been refused, and it was also observed by that court that she was running a bar, an illegal bar in that room. And what happened? Subsequently, she took possession of the whole entire ground floor. This person are living in the first floor, and water connection, which is from the authority, this Calcutta Municipal Corporation, they disconnect the motor pump. This lady, and with help of one Prashant Agarwal, she is trying to grab that property. Prashant Agarwal is the developer. And with the help of that lady, with Prashant Agarwal, she is making one after another FIR before the authority, and all the FIR has been dealt with.
All of you are octogenarian?
Yes, all of our 80 plus. This Pinaki
All
Rai.
all three?
Yes, Pinaki Rai.
Your wife and?
His wife and the Shikhar Rai. Shikhar Rai's husband is expired, and Pinaki Rai and Shikhar Rai's husband are the brother. These are all living in there, and there is no other person, young person living there. And this lady taking the advantage of all this.
All of you are dependents in the suit?
Yes, man.
Your dependents?
No, man. This person is not. This Shutabara is not the dependent in the suit. Pinaki Rai and Shikhar Rai.
Actually, what happened now, this Pinakira and Shikhar Rai, they have transferred their property to their nephew. That is Orijit Rai, and he has not been made party here. Man, all these are going on and making all these things, he want to grab the property.
But one difficulty is there, Mr. Aditya, irrespective of illegal, as you know, irrespective of the legality, illegality of the occupation. If somebody is in occupation is.
My lord, his occupation. I mean,
Have you filed a counterclaim for eviction?
Yes, my lord. Man, I want to put everything on the record. That's why I want to file a written objection, my lord.
Ballot up.
My lord, our stand is very clear.
Use the microphone, Mr. Chaudhary.
No, our stand is very clear as it appears from Annex P8 and P9, Lordship. And we are repeatedly going there to restore the connections.
Obviously, there is.
Since they have paid the amount, Lordship, unless the padlock is break open, otherwise we are not getting access, Lordship. And Lordship, kindly, my instruction is, last minute instruction, we provided supply in favor of Sri Deepak Kumar Roy at the above premises in the year 2015. Thereafter, on 20th April 21, petitioner Shumita Das submitted online application via Annexure A disclaimer form and Annexure 2 forms for transfer of supply, which was standing in the name of Sri Deepak Kumar Roy. On good faith, we issued fresh security bill in favor of the petitioner on 24th April 21 for transfer of supply. Subsequently, on 4th May 2021, petitioner has paid a fresh security bill and thereafter supply was transferred in favor of the petitioner from Sri Deepak Kumar Roy. Thereafter, on 15th September 22, we received various objection letters from the relative of late Deepak Kumar Roy, the erstwhile consumer. In the meantime, the petitioner had stopped making payment of regular monthly bills. As a result, we disconnected the supply for non-payment of outstanding dues of rupees 11,000.
Dispute regarding the transfer remained.
Yes. And thereafter, on 26 September 22, after disconnection of supply, petitioner approached us and paid the outstanding dues, fresh security deposit and reconnection charges for reconnection of the disconnected meter in her name. And ultimately, we deputed our main on 27 September and 28 October 22 and 17 January 23 for reconnection of meter number such and such at the above premises, but were unable to restore the supply because meter room was locked by the private
Mr. Chaudhary, you did not decide on the objection raised by these people. You did not decide on that objection because you had transferred the name. You are trying to revalidate that by restoring. They are entitled to electricity otherwise as occupants. But these factors cannot be brushed aside, Mr. Chaudhary. Why didn't you resolve this dispute raised by them? If the transfer is bad, Deepak Rai was their elder brother. She has no connection with Deepak Rai. How can it be transferred in the name of a third party?
Taking an object.
No, let me hear him.
Since it is a private disputes and litigations are pending between both of them,
No, not
we
that.
are under impression.
I'm not about the private dispute at all. A suit is pending. That's the domain of the civil court.
Yes.
But Mr. Chaudhary, when somebody applies for a transfer of name,
Yes.
there has to be some connection between the two, either heir or some transferee or something. Now, X is the previous erstwhile consumer. He dies or she dies, and I apply. I am a complete outsider. Suppose I may be a complete outsider. There is no modality of ascertaining that. This transfer is bad. If the transfer is bad, you cannot reconnect. Subject to hearing, I'll hear you.
Lordship.
So how do you deal with this? I mean, I don't get you. Yes, how do you deal with it?
Detailed instruction I shall take, Lordship.
But let me clarify my position first. My lord, it is alleged that I have no nexus with that property. My lord, for that reason, your lordship kindly come to Annexure P2, page 23. The rent receipt, my lord.
These all are fabricated, my lord. There is no such rent receipt issued at all.
My lord, kindly see my lord, the date, February 2022. So who has issued this, my lord?
This you are also, this you have also filed in a suit.
Yes.
Must be.
Yes. And second thing is,
Why was injunction refused?
but it was not properly moved, my lord. I asked the learned
Did you
advocate.
properly move an appeal against that?
So, my lord, this is also pending.
If
Appeal
the
was-
civil court has rejected prima facie your right regarding the property, how can we say you are in settled occupation?
My lord, difficulty is that the junior division refuses.
Have you got a copy of that order? I'll look into a copy of that order once.
Please go through the second page, my lord. From second page onward.
When appeal is pending before district judge, my lord, it was transferred to subordinate coordinate bench, but it is not still, my lord, here out.
Scheduled property does not match with the tenanted portion. That is a finding of the prior facie, not binding.
Hiroshi is claiming that he is owner.
So how can I say that you are in settled possession for the purpose of electricity even?
So, my lord, I am not saying, my lord, the document saying that. Your lordship,
At best, I can do this. I
Hello.
can direct this WBACDCL to
CSC, my lord.
CSC to decide this objection first
Lordship,
before restoring connection.
lordship,
If that objection is decided in your favor, then restoration will be given without any prejudice to the rights and contentions of the parties in the suit and regarding the property. And if it is decided against you, then no connection will be given at all.
my lord, may I put this question to myself, my lord? Even
Yes,
though, my
absolutely.
lord, my liberty is always there, my lord, asking for, my lord, fresh electricity connection.
If you are in settled possession of a property, only then occupier or owner, I am brushing aside, leaving aside owner, occupier is entitled. A special bench of our court has said settled possession, which you know, all of you know.
Yes, yes, yes.
So settled possession has to be there.
Yes.
So we are on settled possession now. You have no prima facie case in the civil court.
My lord, on the contrary, my lord, what my lord, the executive magistrate says and the police report says, you'll also kindly have a look at it.
Civil courts is more binding.
lord,
Magistrate's order is not binding on your prima facie possession even.
My lord, your lordship will, can you consider the police report, my lord? He says that I'm in possession.
Police is the worst judge probably in this city.
My lord, even my lord,
Regarding the
they say
possession
that I'm not
person-
paying rent. Even though, my lord, this aspersion can be drawn up that without paying rent, I am
For the
occupied.
time being, let us suspend the adjudicatory powers of the police officers for the
Lordship,
time being,
lordship,
until that is vested in them by the legislature.
what else?
They cannot decide who is in possession, who is the tenant. No.
My lord. Very well.
You have gone before the court with folded hands.
Yes, my lord.
Must have gone before the magistrate also with folded hands. It's recorded in the order, not my statement.
My lord.
Anyway, no, the objection has to be. I'll dispose of the writ petition. I'll refuse you the right to file a written an affidavit in opposition, but I'll record your submissions, and this has to be decided first by them.
Lordship, lordship.
Don't manage them.
Obvious, my lord, I do not have any access to them.
No, not you. I mean, you're.
My
But
lord,
even my client, my lord, what can do, my lord? What he can do?
That is.
my lord also indicate after taking payment, we attempted to restore the connection. Lordship.
Learned counsel for the petitioner contends that the petitioner is an occupant of the premises and is a tenant in respect of the same. First up, initially the electricity supply of the petitioner, please all of you take your seats. Initially the electricity supply of the petitioner was disconnected due to non-payment of electricity charges. First up, however, comma, upon clearing all the dues, comma, the CSC Limited has attempted to restore the electricity connection of the petitioner. First up, however, comma, due to active resistance by the private respondents and their men and agents, comma, the CSC personnel failed to do so, comma, for which the present writ petition has been filed. First up, learned counsel for the CSC Limited contends that the petitioner has actually deposited all the outstanding dues, and upon such deposit, comma, the CSC Limited went on several occasions to give the connection, comma, but could not do so in view of the resistance put up by the private respondents and their men and agents. For sub next para, learned counsel appearing for the private respondents submits that all the private respondents are octogenarian persons. First up, it is contended that the petitioner was in service at the residence of the private respondents, but ultimately took leave and license regarding only one room. Full stop. Next para, however, comma, subsequently in a bid to grab larger portions of the property, comma, the petitioner has encroached upon the same. Full stop. At the present juncture, comma, it is submitted that the petitioner has also filed a civil suit before the competent court. Full stop. However, comma, upon an injunction being sought by the petitioner before the civil court, comma, the same was refused and the temporary injunction application was dismissed. Full stop. Next para, hence, comma, the petitioner's prima facie possession in respect of the disputed property has not yet been established. Full stop. It is further contended by the private respondents that the petitioner had not applied for a new electricity connection, but had sought a transfer initially of the name in respect of the meter standing in the name of the erstwhile consumer, who is now deceased. Full stop. It is alleged by the private respondents that the transfer was obtained by indicating consent of the deceased person. Full stop. Moreover, the petitioner had no locus standi to seek such transfer. Full stop. Next para. The private respondents have also raised objection with regard to such transfer, which has not yet been decided by the CSC Limited. Full stop. Next para. Of course, learned counsel for the petitioner denies the allegation made by the private respondents and submits on instruction that the petitioner is a tenant in respect of the property, and a suit in that regard is now pending before the competent civil court. Full stop. Inasmuch as the refusal of injunction to the petitioner is concerned, the said order has been challenged before the appellate authority, which is now pending. Full stop. Next para.
I have not been informed about the appeal from you.
It's their submission. I've recorded as their submission. Full stop. So file the 340 next if that is wrong against your learned friend.
That is on my not instruction.
I've recorded, that's why, on instruction. These you are never sure unless you see the order. So I've stated on instruction, submits. Next paragraph. A perusal of the copy of the order dated September 20, 2022, passed by the Third Additional Court of Civil Judge within bracket Junior Division at Alipur, District South 24 Parganas in title suit number 549 of 2022, which is handed over in court by learned counsel for the private respondents, clearly indicates that the trial court refused to grant injunction and dismiss the petitioner's application for injunction upon a finding that no prima facie case was found in favor of the plaintiff stroke petitioner. Full stop. Next para. However, it is well settled that such finding is tentative for the purpose of deciding the injunction application and cannot be conclusive as against the parties. Full stop. However, as on date, there is a finding staring at the face of the petitioner, by a competent civil court at that, which indicates that the petitioner failed to prove her prima facie case before the civil court. Full stop. Next para. Although learned counsel for the petitioner has sought to rely upon the police report filed in connection with a connected proceeding under section 144 of the Criminal Procedure Code, the said document cannot be relied on as a conclusive proof of the possession or title of the petitioner. Full stop. Next para. Be that as it may, what is evident from the submission of parties is that there is a positive dispute as regards the portion of the property where the electricity connection is sought by the petitioner. Full stop. A suit is also pending before the civil court where the petitioner has failed to establish prima facie as regards her possession with regard to the said property. Full stop. In the teeth of allegations of encroachment made by the private respondents, it would not be proper to hold at this premature stage that the petitioner is in settled possession within single inverted settled possession of the property, which would entitle the petitioner to get electricity connection in her own name or restoration of the same, under the provisions of section 43 of the Electricity Act 2003. Full stop. Next para. More so, since the petitioner's locus standi to have the transfer of the electricity connection in her name, without allegedly having any nexus with the erstwhile consumer, is still pending decision before the CSC Limited. Full stop. Next para. Hence, in view of the above discussions, WPA 7992 of 2023 is disposed of by directing the CSC Limited to decide on the objection raised by the petitioner to the locus standi of the petitioner to seek transfer of the electricity meter previously standing in the property in the name of a deceased person. Full stop. Such decision shall be taken by the CSC Limited in accordance with law and upon giving opportunity of hearing to the parties and not their representatives. Full stop. Next para, such decisions shall be taken as expeditiously as possible, comma, preferably within 4 weeks from date. Full stop. Next para, in the event the CSC Limited is ultimately of the opinion that the petitioners, that the transfer in respect of the petitioner was otherwise valid in law, comma, the electricity connection of the petitioner shall be restored by the CSC Limited, comma, however, comma, without prejudice to the rights and contentions of the parties in the pending civil suit and or before any other competent forum. Full stop. In the event, comma, however, comma, the CSC Limited is of the opinion that the initial transfer was bad, comma, the CSC Limited shall not restore the electricity supply of the petitioner and shall refund the deposits, comma, if made by the petitioner solely for the purpose of such reconnection. Full stop. No rest to cause urgency.
I took my lord instruction from the lower court advocate, my lord.
Yes.
My lord, he said that no appeal is preferred.
That's why I'm telling you.
My lord, very, very innocuous, my lord. I'm extremely.
What innocuous?
To make submissions, my lord, that I have preferred an appeal. No appeal was preferred. That's very, my lord, innocuous.
I'll have to trace out that portion. At a jagah bolichi, the third paragraph in Australia. That appeal has been preferred on the instruction. Why do you do this post facto after the object? Should not have submitted.
But he said right now, my lord, he says that I prepared an appeal and yet to file. My lord, this kind of things, my lord, I'm extremely sorry.
No, you are not responsible, maybe.
I made this submission to your lordship.
হ্যাঁ, কিন্তু ওরম ভাবে তো ভুলভাল পোর্শন বাদ চলে গেল।
মানে
একটু এই জায়গাটা পড়ে দিন, যে জায়গাটা দেখছি না। ওই সিভিল কোর্টের অর্ডারটা প্রডিউস করেছে ওইখানটা। তার একটা সেন্টেন্স পড়ে, হ্যাঁ, তারপরে না, তারপরে একটা জায়গা আছে যে কাউন্সিল ফর দি পিটিশন, হ্যাঁ। না, অর্ডারটার পরে yes. This sentence will be struck out. In as much as the refusal of the injunction is concerned, an appeal has been filed, which is appellate authority, which is, please score that through. No appeal has been, I mean, at least not filed yet. The rest remains. Thank you. Thank you.
Greatly, my lord. Greatly obliged, my lord. Highly obliged.
Thank you. Please. আপনি যেতে করে দিয়েছেন, মেনে করে দিয়েছেন। Yes, call on the next matter, please.
Item 8.
I'm
I appear on behalf of CSC manner.
on the last occasion, Lordship, they took time to get
there
instruction
was a
whether
block
meter
meter.
in the name of the petitioner can
Is
be.
it possible otherwise?
Individual name, it is not possible, my lord. It can be Mohammed, Naushad and others.
Lordship.
But my lord, they have to make an
Then others have to make an application.
they have to make an application and subject to compliance of all formalities.
So
my lord.
petitioner can alone make that application
No,
in the name of others.
they have to make the application.
All the persons have to
Yes.
apply.
And my lord, there are two more things, my lord. My lord, will kindly see the paragraph C.
where there are already 11 meters, 9 of them are commercials and 2 are domestic meters, my lord. Moreover, it is also found that there are multiple commercial established at the above premises without having individual meters in their favor, and all are deriving supply through the above existing commercial meters. Paragraph D. During inspection, my lord, the said godown has been found without electricity connection, but old electrical wirings with a switchboard has been found inside the godown.
How is that relevant?
Because we have already rejected earlier on the ground of splitting. There was already, now when we have inspected, but upon notice, my lord, we have seen that there are wirings and all. Earlier, my lord, we have rejected on the ground of splitting of load because he was deriving supply. But now, if he wants
The
the
block meter will not be an issue for you. I mean, you can give. if
Yes,
they-
we can give money. It has to be in the name of Mohammed Naushad and others. And subsequently, a minimum of 6 kilowatt load has to be given. It may be more, it may be less. But he has to apply for.
So if the other previous applicants agree,
There are already 11 application pendings. My lord.
Lordship, if they do not agree at
And
this
he
point
has
of time, I will be without
And my
electricity.
lord, he has to, my lord, do an affidavit also.
Separate
you are asking for a commercial connection also.
commercial connection.
The previous applications have to be allowed first. Why will you jump the queue?
Lordship, I am
Because
without
they filed a
electricity. It
petition.
is clear from the report of the CSC Limited.
Previous applications are pending. If those could not be given, you
Not in
cannot
my
be-
name, Lordship. In different persons.
different persons. That is what is striking.
They are
me.
different tenants, and I am also a separate tenant of
Those
the
people
premise.
have not been given electricity,
been
Mr.
given.
Halda.
Yes,
On the same ground, your application should be rejected, also rightly refused.
Lordship. Lordship,
Unless you can, I'll give you that liberty to apply for a block meter
Lordship.
jointly with others.
Lordship.
6, what is the unit?
6 kilowatt, man.
6 kilowatt load has to be applied for
Yeah,
in total.
minimum.
Minimum.
It may be more. So then, we have to assess and we will give the. We have to make a 3-phase meter there, for that.
Technically, I don't know. Very well. I'll give you that liberty, but cannot pass any order right now.
Lordship. And the meter will be in the name of Mohammed Naushad and others as the.
Maybe may not be.
Lordship, they have some.
Maybe may not be.
Lordship.
He has to apply, then.
X and others.
Lordship.
X may not be Mohammed Naushad also.
I will apply, Lordship.
X may be the first applicant to apply it also.
It will be X and others block meter.
Learned counsel for the petitioner contends that the petitioner has sought for electricity supply, but the same has not been given by the CSC Limited. For sub next para, learned counsel appearing for the CSC Limited, by placing reliance on the report and annexed photographs filed by the CSC Limited, submits that there are previous 11 applications for commercial connections pending at the same property. However, the same could not be given because of the technical difficulty and consequential electrical hazard if multiple commercial establishments are connected with electricity from the constrained place in the meter room. Next para, that apart, it is submitted that an inspection of the godown revealed that there was a previous electrical wiring and switchboard inside the godown of the petitioner. Next para. Be that as it may, on instruction, learned counsel for the CSC Limited submits that there is no difficulty on the part of the CSC Limited to give a block meter and connections from the same to the applicants. Therefore, provided a minimum of 6 kilowatts load is applied for jointly by the said applicants. Next para, that apart, other formalities have also to be complied with by the applicants. On instruction, it is further submitted by learned counsel for the CSC Limited that a block meter cannot be given in the individual name of a person, even if he applies for more than 6 kilowatt, then also.
No, it cannot be.
Individual name of a single person. Next, in such view of the matter, WPA 8/222 of 2023 is disposed of by granting liberty to the petitioner to apply jointly with other applicants, for taking a block meter at the property in question. If such an application is filed, if such an application is made jointly by the petitioner and other proposed consumers, and the said application fulfills the modalities of law and regulations, comma, subject to compliance of all formalities by the applicants, comma, the CSC Limited shall give such connection to the petitioner and the other applicants as expeditiously as possible, comma, preferably within 3 weeks from the date of compliance of all formalities by the joint applicants. Full stop. However, comma, it is made clear that this is not necessary. No rest to cause urgency report.
Grateful.
Grateful.
I'll come back in 10 minutes and take up the rest of the matters. Yes,
And I'm for the petition.
yes. What is the matter?
My lord, I have applied for electricity connection in my premises. I have paid the quotation money.
Any objection from any?
My lord, in this matter,
Please use the microphone, Ms. Gay.
at the time of installation of the service connection, some local people raised objection, my lord.
Unless you give names, they cannot implead.
My lord, in presence of petitioner, my lord, and signature.
Can you give a copy to him also? He is entitled to a copy. Whose
At the-
handwriting is this? At the bottom?
At the- And then informed to the petitioner, my lord.
No, this is the official of the WBSCTCL wrote this.
Yes, ma'am.
So the names have been mentioned.
Yes. 4%, my lord.
You have to give a copy to him. He has to
My
implead
lord,
them.
after.
I'll return this to you right now. Or file a copy in court also during the course of the day and give a copy to your learned friend. Please implead these persons. I'll put it in the order. Learned counsel for the petitioner submits that despite compliance of formalities, the WBSCTCL has not yet given a new electricity connection to the petitioner. Next para, learned counsel appearing for the WBSCTCL submits on instruction that when the WBSCTCL personnel went to give such connection, they were registered by several people of the locality, who have been named in a document, a copy of which is sought to be handed over by learned counsel for the WBSCTCL. However, since such question has been raised, the objectors are required to be impleaded as party respondents to the writ petition. So accordingly, the learned advocate for the WBSCTCL shall file a copy of the document sought to be relied on and hand over another copy thereof to the learned advocate for the petitioner in order to enable the petitioner to implead the objectors as party respondents to the writ petition. The necessary consequential amendments to the cause title of the writ petition shall be carried out by April 21, 2023 by the learned advocate on record for the petitioner. Service of the writ petition shall be effected on the added respondents at the earliest, and an affidavit of service in that regard shall be filed on the next date of hearing. When should I keep it? You'll have to ascertain the addresses and
My
implead
lord,
and serve.
by 21st, I'll serve, my lord. Let it be.
Serve, but it will come back. Then I'll keep it on, say, 8th May.
First week of May.
My lord, first week of May.
Won't help you.
Very well, my lord.
We'll again have to adjourn them.
My lord,
Yes, the matter shall next be listed under the same heading on May 8, 2023.
I'm ready.
Item 10.
I am appearing for the.
I beg to appear for the
Yes.
private officer.
What is the matter?
For the petition.
Oh, for the petitioner.
Yes. Your Lordship, in this matter, I am a tenant.
How are you?
I'm fine.
Yes.
Only
tenant?
because of the heat, the muscle is cramping. That is
You
the
have to take
difficulty.
fluids,
Yes.
preferably water.
Yesterday I had a talk with the doctor. They said it is because of the dehydration.
Yes.
The muscle is cramping.
Right. Please take care of that. And what is your matter? Yes.
Your Lordship, what happened?
You are a
is-
tenant not being given electricity connection.
No, I am a tenant.
Right.
The electricity which I was getting for my commercial showroom was from the landlord through a submitter. Now dispute arose between the parties, landlord tenant.
Suit
I
filed.
filed a suit. Injunction has been granted not to disturb my possession except with due process of law. Thereafter, my electricity connection was being interpreted. I applied before the company. They have said that because
Splitting of load. What is the objection taken by?
Yes. Page 42, Your Lordship. The objection is made, Your Lordship will see, feasibility of segregating the existing line.
Mr. Rai, electricity
Now,
connection, I'll come to you.
Your Lordship, similar, my neighbor tenant, he came up with this.
Have you stated that in the writ petition? No.
No, I'm handing over the order passed by your lordship.
No, keep that with you. I mean, you
That
cannot be assured of the facts of that. Let us inquire from Mr. Rai, is it possible to give a new metered connection to him from a separate, from the same meter board position?
Now, it appears from the my lord, sketch map at point that
There's a little more to this.
No, I'll definitely come to you. I'm just ascertaining the contours of the objection. Yes.
at
Now, can it be done or can it not be done?
No.
If not, why?
the meter board position, my lord, for installation of meter.
Use the microphone, Mr. Rai.
Installation of meter, there is some problem as I came from the report, my lord, annex here, my lord. That moreover, there is a suitable meter position found at the site. Further processing related to approval of the application cannot be done. Now in earlier, my lord, if your lordships kindly peruse the sketch, the meter room is in distance place and already he is enjoying electricity on that particular plot, that is stripe.
Grateful.
your lordship, I'll bring the.
And that's why, my lord,
That
we are-
meter, that connection is in his name, the petitioner's name,
no,
No, not in my name, in my landlord.
not in the petitioner's name.
no, it is in the name of,
Designated
Please
submitter.
sweltering it outside. Please take your seat, Mr. Sivas. You also take your seat. For the timing, I'll call upon you. And you'll learn, Mr. Shukant
It
also will take a seat. Yes.
it is in the name of Bhagavan Das Vehicle Test Service Private.
So in the name
Limited.
of a different entity.
Yes, but this line also.
They are enjoying, you are saying, but from a very well. Let us hear the private. Yes.
My lord.
Yes, ma'am. What is your case?
My lord, first objection is he's not a tenant. My lord, he's just a licensee.
Very well.
Now, my lord, this agreement, my lord, this premises is Yuva Bharati Krirangan premises.
Excellent.
Then, my lord, my client has he is a lessee.
That belongs to a private person now.
My lord, he has a lessee of a portion where he has his taxi meter correction center.
Very well.
Well, that he had a right to sublet. He has sublet a little portion to him,
He means you.
to the petitioner.
You have sublet.
I have sublet a
Yes.
portion to the petitioner,
Right.
my lord, in the year 2021 January. That was, my lord, till 2023 December. However, with a clause that if there is any default and other clauses, my lord, that were there, well, that it's going to be terminated. My client has terminated this agreement in the year 2021 May for default. And, my lord, subsequently, he has filed a suit. The suit, my lord, he has obtained, my lord, an order of injunction that
Your entire
was
family is in
only,
court. Your entire family is in court now.
my lord,
Anyway.
oh.
Yes. Whatever. Please continue.
So, my lord, now, my lord, they have filed before the suit court. They obtained an injunction, my lord, only till December 22. That has not been extended after my filing of an
If they are in
objection.
occupation, they are entitled to electricity connection.
Now,
What
my
do you say
lord,
to this?
now, my lord. Admittedly,
Yes.
he is enjoying electricity connection provided by me.
There's a dispute. Suit is pending.
Well, the suit is pending. I still provide him connection and he is enjoying it. Electricity meters bill is being raised. I am paying with out of my pocket every month.
But he should
Now,
be
my
given a
lord,
separate connection. You're disturbing his
well,
position.
he has, my lord, submitted to his use. My lord, only to his use he has been given a submeter.
Suppose a
and
new
my
meter is
lord,
given to him, but without creating, without creating any special right or equity in his favor or prejudice to your rights in the suit. What can be your objection to
well,
that?
my objection is, my lord, there is an arbitration clause. I have gone in for an arbitration. This entire thing is, my lord, is under a suit court and, my lord, also before an arbitrator. Now, my lord, at this, my lord, if any new right is being, my lord, accrued in
No
his
right will be
favor,
accrued. That will be specified in my order. That has to be.
well,
Electricity Authority or the writ court sitting in jurisdiction under Electricity Act cannot create a new right, and it will have to be mentioned in the order also.
now, my lord, one
Otherwise, you cannot have
only,
it.
my lord, one final
Electricity is
thing.
a basic right.
My lord sees his document at page 42.
42 years.
My lord, this, my lord, sees what is the objection.
Hmm.
According to site inspection, there is no physical as well as electrical separation between the existing connection and your defined office premises as shown at the time of inspection. That is, my lord, What he is asking for is a separate connection, and there is no separation from the
Can you show me
existing connection that is
the
there.
previous deed with him?
Yes,
The lease agreement.
Leave and license.
Was
Clause
it a leave
5.
and license agreement?
Clause
You
5.
said subletting, that's why I'm asking.
My lord, this is, my lord, leave and license.
It is defined here.
My lord.
In the schedule, it's defined. All that said commercial space containing an area of 500 square feet superbuilt, whatever, little more or less on front portion of the ground floor of the building.
My lord.
So it is an ascertained portion.
My lord, it
So
is.
this objection is frivolous.
My lord, may kindly
This
see.
objection of the distribution license is frivolous. It's an ascertained portion. Only in that respect, in respect of that premises, you will get.
My lord, what they are saying is there is already existing connection. That
Already
is why.
existing connection given by you.
Yes.
But why should they be dependent on this in view of the strained relationship? Litigation is pending.
Well, litigation is pending.
Then-
So, Malad, if Malad, they are entitled, Malad, may I submit, Malad, may I just Malad file an objection, an affidavit in
No, you have to
opposition.
clarify on what point.
When an
Record
affidavit
that
in
point and then refuse the objection. The electricity matter cannot wait.
well, he is enjoying, Malad, one more thing,
His
Malad, may I
only
show you?
thing to be looked into is his possession. Only thing. What is this?
Malad, this is, Malad, what I am paying, Malad, every month, Malad, for the electricity being used by him.
He won't be paying because now he will be paying his own
He's
meter.
paying my rent. Now, Malad, if he is not
Exactly.
paying my rent,
There is
I
no
think-
lien on his electricity connection right for the area rents.
Malad, now he
Now you have come to the real point, the crux of the matter.
But
You
so
cannot
he
do that.
stated, now we are before the courts. Now, Malad, what he is possessing is an illegal possession. He's an illegal occupier.
Even if he is illegal occupier, then also he is
Only
entitled.
one thing, well, let him show an order, my lord, of the suit court, where, my lord, his interim order has been extended.
Irrespective of a suit, even if there was no suit, suit is only relevant for the purpose of showing that there is a strained relation. There is an allegation that you are not giving electricity regularly or disrupting in whatever manner. May be true, may not be true.
My lord.
But there's an allegation, relationship is strained, you are contesting the suit.
That
They have
is
an
there.
independent right. They have an independent right. I'll record your submission. You are wanting to use affidavit in opposition, but I'll refuse that. I'll give the grounds.
My lord, without giving him any right, my lord,
Definitely. I'll have to specify that in my order.
Only one submission.
Equity, Your Lordship.
Even if you claim, I won't give you. How dare you claim equity?
What will
Yes, Mr. Rai.
Only that extent should be protected rather than not splitting of load. That
No,
because-
I'll put that in my order. Why it is not splitting of load, I have to deal with that.
Yes.
Definitely.
And because
I'll
there is
deal with
already-
that. I'll deal with the right to file opposition, why I'm refusing that, and also deal with his right to get electricity connection.
Only we are concerned that we are main objection for splitting of load.
Very.
If it is not, we have no objection.
Learned counsel for the petitioner contends that the petitioner is allegedly a tenant in respect of the premises in question, but is enjoying electricity, has been enjoying electricity connection through a submeter from the meter of the landlord. Full stop, next para. However, comma, as of late, comma, dispute has cropped up between the petitioner and the private respondent stroke landlord, comma, for which a suit has been filed by the petitioner claiming the petitioner's tenancy rights and consequential injunction. Full stop. In such suit, comma, it is submitted that a temporary injunction order was passed for a limited period, comma, protecting the possession of the petitioner, which cannot be disturbed by the private respondent except in due process of law. Full stop, next para. As such, comma, it is argued that the petitioner has an independent right as an occupier to get electricity connection to the premises and seeks such connection, comma, which has been refused by the WBSEDCL. Full stop, next para. Learned counsel for the WBSEDCL submits that as per the objection of the WBSEDCL, comma, given in writing on March 15, 2023, comma, there is no physical as well as electrical separation between the existing connection and the defined office premises of the petitioner as shown at the time of inspection. Full stop. Moreover, comma, it is alleged by the WBSCDCL, comma, there is no suitable meter position found at the site. Full stop, next para. Learned counsel appearing for the WBSCDCL further indicates that there is an apprehension of splitting of load due to the above circumstances. Full stop, next para. Learned counsel appearing for the private respondent opposes the prayer for giving a new electricity connection to the petitioner, comma, primarily on the ground that the petitioner is an illegal occupier of the premises. Full stop, it is submitted that previously there was a leave and license agreement between the private respondents and the petitioner, comma, which was ultimately terminated by the private respondent in due course of law. Full stop, thereafter the petitioner had filed a suit, comma, which is now pending. Full stop, however, comma, it is disputed as to whether the interim injunction granted to the petitioner is still continuing. Full stop, next para. That apart, comma, the petitioner is already enjoying electricity at the premises, comma, as also endorsed by the WBSCDCL, comma, which is being given by the private respondent through the latter apostrophe meter. Full stop. It is also argued by learned counsel for the private respondent that the petitioner has huge area dues with regard to rent of the with regard to occupation charges of the premises, which is payable to the private respondent. Full stop. In a bid to avoid such liability, comma, the petitioner is seeking the independent electricity connection, comma, to establish an equitable right in favor of the petitioner, which is not there in law. Full stop, next para. Upon hearing learned counsel for the parties and query of court, comma, learned counsel for the private respondent has handed over a copy, I'll keep this on record, has handed over a copy of a leave and license agreement dated January 1, 2021. Full stop, although there is dispute regarding the validity till date of the said agreement, comma, in view of efflux of time and subsequent termination by the private respondent, comma, the same is an indicator as regards the specific portion of which the petitioner had been granted leave and license originally. Full stop, next para. To ascertain such exact location, comma, the schedule of the license agreement is looked into, comma, which specifies that the portion regarding which possession was handed over to the petitioner is all that commercial space containing an area of 500 square feet super built up approximately, comma, which is a little more or less on front portion of the ground floor of the building complex situated and lying between gate number 1 and 2 of the Salt Lake Stadium, comma, Salt Lake, comma, Kolkata 7,98,000, comma, along with furniture and wooden partitions. Full stop, next para. Hence, comma, it can very well be ascertained from the original agreement, comma, without going into the validity of the same, comma, as regards what portion was allocated to the petitioner, comma, to which the petitioner's right to enjoy electricity is restricted. Full stop, such right is conferred on the petitioner by nothing else than the statute itself, that is section 43 of the Electricity Act 2003, comma, read in conjunction with Article 21 of the Constitution of India. Full stop, next para. Although the legality of the possession of the petitioner has been contested by the private respondent and such dispute is pending before a civil court, as well as an arbitration has been sought to be referred to as per learned counsel for the private respondent, comma, the dispute in such pending matters is regarding the legality and validity of the possession of the petitioner, as well as the rent and other dues from the petitioner to the private respondents primarily. Full stop, next para. However, comma, the however, it is well settled that a person in settled possession of a property is entitled to get electricity connection at the said property in his or her own name. Full stop, next para. Such right cannot be fettered by whatever dues are claimed by the added respondent from the petitioner, comma, which falls within the domain of the civil court and, comma, if there is any arbitration clause, comma, the arbitrator. Full stop, next para. In such view of the matter, comma, the petitioner is entitled to get an independent electricity connection in petitioners in their name. Full stop, next para. Accordingly, WPA 8892 of 2023 is disposed of by directing the WBACDCL to give a new electricity connection to the petitioner from the existing meter board position at the premises as defined in the purported leave and license entered into between the petitioner and the private respondent on January 1, 2021, comma, by adhering to the schedule of the same, comma, which is a part of this record. Full stop, next para. Such connections shall be given as expeditiously as possible, comma, preferably within 3 weeks from the date of compliance of all formalities by the petitioner. Full stop. However, comma, it is made clear at this juncture that such connection, comma, as and when given to the petitioner, comma, shall not create any special right or equity in favor of the petitioner, comma, which the petitioner otherwise does not have, and such connections shall be entirely without prejudice to the rights and contentions of the private respondents as well as the petitioner in the pending suit and arbitration proceeding, comma, if any, comma, as well as other disputes pending before other legal forums. Full stop. In the event any obstruction is offered by the private respondent and or its men and agents in such connection being given, comma, it will be open to the WBACDCL personnel to approach the local police station for adequate police assistance. Comma, that is respondent number 4, comma, the inspector in charge of the Bidhannagar South Police Station. Full stop, if so approached, comma, such assistance will be given by respondent number 4 by acting on a server copy of this order at the cost of the petitioners. Full stop, next para. In the event any padlock or other hindrance is put up to giving such connection, comma, it will be open to the police personnel to remove such hindrance or padlock for the limited purpose of giving access to the WBACDCL personnel to give the electricity connection to the petitioner. Full stop, no rest to cause urgency.
As regards splitting
in this matter, he has made lots of allegations against me.
Since no affidavits have been invited,
Keep it open. Don't question, he's saying use dues and all these things, your lordship.
My lord, it was
I'm
not even his
admitting-
prayer for a separate electricity meter. My lord, may kindly see page 17 once. The prayer, my lord, may kindly see, my lord, once.
Yes, let us
Page
see.
17, my lord, sees the prayer. Prayer B. Effect separate new electric petitioners.
as regard my lord, splitting of
There was no
that
prayer
they-
for a separate meter at all.
as regards splitting of load, which we are my lord suspected, because
line last line যেখানে বলেন তার আগে একটা add করি। It is relevant to mention here that such new connection, comma, if given to the petitioner shall not tantamount to a splitting of load in view of the dispute already pending between the petitioner and the private respondent, which has also been dragged to courts of law and to arbitration, comma, which itself shows that the relation is sour talk between the petitioner and the private respondents. This was productive.
11.
Yes, 11.
I'm for the.
Yes, Mr. Kutubuddin.
This
Which
is also-
district? Malda?
Malda.
What is the
Award for the distribution company, my lord.
Right. Malad, quotation has been issued since long in the year 2016 and
What is the
I have
difficulty?
deposited quotation amount.
No pump found. What instruction? Mr. Kutubuddin is appearing, you're not taking instruction. How dare you?
I just got the brief.
Come back tomorrow with instruction.
Tomorrow I have a personal.
Day after tomorrow.
Not yet. Then my lord, there is a Eid will be
Give me a date. I am convenient, available on every date.
2nd May, my lord.
2nd May. Very well. Affidavit of service filed today be kept on record. Full stop. However, learned counsel for the WPACTCL seeks an adjournment to take appropriate instructions in the matter. Full stop. Accordingly, the matter is adjourned till May 2, 2023, when it will be listed under the same heading.
I'm good. Well, every service kept on record.
No, no. How can it be kept on record?
Well, every service.
No, definitely not. প্রথম লাইনটা একটু অর্ডার পড়ে দাও। The first line of the order.
I'm good.
12.
Petitioner or respondent?
I'm appealing for the respondents.
Oh, DVC, yes.
Certain mistakes are crept
Take the microphone closer to you. You're too tall for the microphone.
My lord, it was switched off. My lord, certain mistakes have crept in both the writ petitions. My lord, I would praying for leave be granted so that I can withdraw and file afresh. My lord, Mr. Chakraborty had already apprised my lord of this yesterday and leave was already granted to file it.
I'll do that. On the prayer of learned counsel for the petitioner, leave is granted to the petitioner to withdraw WPA number 9192 of 2023 and refile the same upon effecting the necessary corrections to the same. Full stop. Accordingly, WPA 9192 of 2023 is dismissed as withdrawn with liberty to the petitioner to file a fresh writ petition on the same cause of action. Full stop. No rest to cost.
My lord, 13 same order.
This was 12. 13 ta board show karo. 13 same order. Mr. Chakraborty's name, I hope, is not there. No, give it there. Why? You're there.
No, my
On
lord,
next one. Yes.
Application, item 14.
Petitioner.
My lord,
No.
I'm appearing on behalf of the petitioners.
Yes.
I'm opposing this.
Yes. What is the matter?
It is a restoration application, my lord. The petitioner had preferred the writ petition
Yes.
as a demand of penalty.
Restoration of the writ petition.
Yes.
It's a restoration of
Restoration of a
application.
restoration,
Then-
my lord. My lord,
So-
what happened here is
Normally, my lord, I do not oppose restoration.
Everybody says that before opposing. Everybody. Everybody says normally I don't oppose, but this is an abnormal situation.
This is a,
So on what ground you are opposing? Restoration of restoration. That's why.
this is really.
if I may, my lord.
Yes, please.
The writ petitioner here had filed the writ petition on the ground that a demand of penalty was levied on them by the respondent authorities.
Right.
The matter was taken up by Dasar Dipankar Dotto and an order was passed staying the demand of
Now, do I have determination to take up the matter?
Yes,
It is not an
yes, my
electricity
lord.
matter. It's an electricity matter.
Essentially, it's a group one matter because it relates to a land.
Unless I have determination to hear the main writ petition, I cannot take up restorations in connection with that. There is probably some other bench who is taking up these matters.
My lord,
You have to go before the bench having
my
details.
lord, matter was mentioned before, my lord. It is thereafter listed.
If it's not an electricity matter, you have
It's
to
not
go.
an electricity matter,
Then
my
whatever
lord.
matter it is, which group? Group 1.
Group
It
one, my
should
lord.
be group one because it relates
is,
to action challenge.
I'll
and
release it on my for lack of determination. You'll go to the appropriate place.
and the present. I think the writ petition has been filed under group 9.
Residue.
Group 9, I don't have blanket determination. Only the electricity matters and cases.
I think so, my lord.
But this is regarding KMC, Kolkata Municipal.
KMDA.
KMC, then I don't have determination, ma'am. Sorry. In view of lack of determination, the matter is released from my list and be sent to the appropriate bench having determination, subject to being mentioned, liberty for which is given to the parties.
Grateful. Grateful, my lord.
Please guide her who is appearing, which court is taking up this determination, so that they can go there and mention the matter.
The presentation form she may check if it is mention group 9, then it will.
My lord, it was a changed brief, my lord.
So what?
thereafter,
No
so-
difficult. You have argued, tried to argue very well, but unfortunately could not be taken up. Yes.
My lord.
Next matter.
Item 15.
15, who is there? Who is for who?
I'm for the
Mr.
applicant.
Chattopadhyay is for the petitioners.
I'm
Oh, you are
hearing for the respondent, your lordship.
responded, right? What is the matter?
Your lordship, only one humble submission, your lordship. My learned friend can start, but I have not received full instructions.
Come back on some other day.
So he
What is the
can-
use of piecemeal hearing?
It's nothing to start. It's a very short matter.
Yes.
Lordship had
We'll
disposed of
start
it.
at, it will end at the time of start. So let us come back whenever suits you. Tell
It's a
me.
very short matter.
Cannot be very far off. Some date which
I'm
is
bullish.
not.
I'm led by Mr. Banerjee, Shiv Shankar Banerjee. He's appearing.
How is that
Any
special?
day. No, I am just saying that. Your lordship.
When should I keep it?
Your lordship can keep it tomorrow or Friday, whichever it is.
Friday then, whichever date suits Mr. Mitra and Mr. Chattopadhyay.
Tomorrow, my lord, I think is a safer day.
Very well. On the prayer of learned counsel for the respondents, the matter is adjourned for the day and shall next be listed tomorrow under the same heading. Please come.
Very grateful.
I'm grateful.
Thank you.
Old matter, item
Yes,
16
old
and
matter. What is
17.
the matter?
Lordship, I'm appearing on behalf of the petitioner.
Move the matter, move the matter. No time.
Lordship, in item 17, I'm appearing on behalf of WB.
Use the microphone.
On behalf of WBERC led by Mr.
Not being used.
I'm appearing on behalf of WBERC in item number 17 led by Mr. Pratik Dhar.
So what? Who is for the petitioner?
Petitioner.
Move the matter, start the matter. What is the matter about?
I'm
When should I
waiting
keep
for
it?
not today.
Kindly keep it out after 25th,
After 25th?
Lordship.
Choose a date, I'll keep on that date.
Any day after 25th.
You choose a date because you are praying for time.
Lordship, after 25th.
An adjournment is sought by learned counsel for the petitioner. Full stop. Accordingly, let the matter stand adjourned till April 26th, 2023. 26th April. Thank you.
Oh. 18.
I'm for the Kolkata Municipal Corporation. I was
Use the
supposed,
microphone, please.
my lord, I'm appearing for the Kolkata Municipal Corporation. I was supposed to file a report, my lord, in this matter.
Please.
May I?
Well, I appear on behalf of.
So Ghosh is for the petitioner. Where
Yes,
is
Mr. Shanali is leading me. Well, let a copy of the report be handed over to us. Let us
I'm
come
hearing
back.
now,
also hand over a copy to the petitioner, sir.
my lord, I'll send it.
A report is filed by the KMC through council as per previous direction. Full stop. Next para. A copy of the same is also handed over to the learned advocate for the CSC Limited. Full stop. The learned advocate for the KMC is requested to serve a copy of the report to her counterpart appearing for the petitioner as well by tomorrow. Full stop. The matter shall be listed on April 24, 2023. Next under the same heading.
My lord, if it can be on 25th or any day, 24th.
25th, the 24th, not 25th. 25th, some matter you must have here, Mr. Mukherjee. Some electricity matter, some small matter for the court.
Obliged, your lordship.
Yes, thank you. Call on.
I'm grateful, madam.
19.
Yes, Mr. Sheth, what is the matter?
19, my lord, I am appearing on behalf of the petitioner, my lord. My lord, last occasion on 12th of April 2023, matter was taken up before your lordship, my lord. Your lordship was directed to serve notice upon the learned advocate appearing.
Not
on
served.
Yes, my lord, I have served.
Proper service. What
By
is the
hand.
matter?
My lord, matter is that, my lord.
No, you are satisfied with the service.
Yes, by hand.
Hand it over. On the advocate.
On the advocate.
Very well. Yes, what is the matter?
My lord, the writ petition is against.
Use the microphone, Mr. Sheth. With such a good voice, you should. Yes.
my lord, this petition is, my lord, challenging the order passed by the Fisheries Department.
By the Fisheries.
Fisheries Department. Right. Facts of the case is that the classification of land in CS and RS record was Bastu. Thereafter, my lord, unfortunately, the said land in question has slowly been artificially converted into a depressed land due to excavation of soil from the said plot in question, my lord, by the local people. Thereafter, my lord, the said plot of land does not retain water for a period of 6 months in a year, my lord. My lord, the said plot has never been used for pisciculture. Thereafter, in the year of 2012, the petitioner purchased the said plot of land. If your lordship kindly...
There never was any conversion from Bastu to something else?
No, my lord.
There was never any conversion?
My lord, still now, my lord, the plot in question has been recorded as Bastu.
Bastu, very well. Please continue.
I am inviting your lordship, kindly come to annexure P3 of my writ petition.
Give the page.
Page 43. Page 40, schedule of the property, my lord, page 41.
Page?
Page 41. Schedule
41,
of the,
all right, yes, yes.
Schedule of the...
Got it.
জেলা দক্ষিণ 24 পরগনা।
Yes.
জেলা দক্ষিণ 24 পরগনা, মাগুরা রেজিস্ট্রি অফিস আলিপুর, সাবেক থানা সদর।
This is your purchase deed, Mr.
Yes. This is my purchase deed.
Yes.
টালিগঞ্জ হাল রিজেন্ট পার্ক বর্তমানে কলকাতা মিউনিসিপাল কর্পোরেশনের 111 নম্বর ওয়ার্ডের এলাকাধীন। অত্র জেলা কালেক্টর 14 নম্বর তৌজিভুক্ত রেজিস্ট্রি নম্বর 200 জেল নাম্বার 49 মৌজা কামডহরি গ্রামের বর্তমান মালিক পশ্চিমবঙ্গ রাজ্য।
Need not read the entire thing. I've seen it. Yes.
My lord, at the time of there was a
ছাউনিযুক্ত ঘর।
200 square feet নির্মিত ইটের দেয়াল ছাউনিযুক্ত। There was a structure. My lord, subsequently, my lord, after purchase the said plot of land, the petitioner made an application before the block land and land reforms officer for, my lord, filling up the said plot of land. On the basis of the said application, on inspection was held. And after inspection, the block land and land reforms officer, who is the respondent here in my lord, directed the petitioner to deposit the
The state a party?
Yes, my lord.
You have served on the state also, this notice?
Nobody appeared.
Anyway, then after
My lord, on the basis of the said application, my lord, application made by the petitioner, and inspection was held. After inspection, the petitioner was directed by the BLRO to deposit the amount of rupees 72,337.
Yes.
In pursuant to the said direction, the petitioner deposited the said amount. I am inviting your lordship, kindly come to annexure P5, page 67.
Yes. Receipt is there.
The petitioner deposited the said amount. Thereafter, my lord, suddenly the Fisheries Department, who is the respondent number 4 hearing, my lord.
Fisheries Department.
Lord, I am here for the state led by
Very good, yes, yes. Please continue.
Last occasion, my lord, you are directed to file, my lord.
File what?
Opposition, my lord. Opposition. has
Did
been
I?
made.
Where is that?
This is my lord.
No copy has been served.
No copy has been served.
I'm giving here. Though my lord belated stage, my lord. I'm trying. Apology, my lord.
File a reply.
Yes, my lord.
After commencement of hearing, the learned counsel for the state appears and files an affidavit in opposition as per previous direction. Full stop. Next para. A copy thereof is handed over here and now to the learned advocate for the petitioner. Full stop. In such view of the matter, such opposition is accepted and the time for filing affidavit in reply is extended for 1 week.
1 week.
Extended till April 26, 2023. Full stop. The matter shall be listed for hearing under the same heading on April 27, 2020.
Grateful, your lordship.
Great.
A copy of the receipt of notice on the learned advocate for the state be also kept on record.
Grateful, your
Thank
lordship.
you.
Item 20,
Lord, I am for the respondents. My lord, last three occasions, they had it.
Oh,
It didn't appear, my lord.
can you give a notice to the other side? Or have you given previously?
Yes, my lord, previously, but
No, only difficulty, Mr. Kole, which we are, I mean, a predicament we are facing, because advocates have to run from between three buildings.
yes,
now.
yes, that's
That is the difficulty.
that I am admitting.
I mean,
No, because last occasion also your lordship's matter is taken up, they didn't.
yes, on two occasions they're not
Ha,
applicable. I'll
that
dismiss
is
it
why,
for-
my lord, I am submitting.
While taking up the
Otherwise,
restoration, I'll fix them.
otherwise I am not submitting.
Very good. No, you are right on that. This is the third occasion when none appears for the petitioner at the time of call. Full stop accordingly, WPA 31600 of 2014 is dismissed for default without any order as to cost. Interim order, if any, stands vacated.
Grateful to you.
Thank you. Once inform Mr. Sannal or somebody of his, I mean, whoever was appearing, so that they can take steps if necessary.
As your lordship.
Inform tomorrow so that they cannot pray today for restoration. You're nodding your head.
As your lordship.
Anyway. No, I don't please that. You can inform him anytime. Call on the list.
21.
21. This is the second occasion when none appears for the parties at the time of call. So as a last chance to the petitioners to move the matter. The same is adjourned till April 24, 2023.
Lordship, Mr. Kishore Mukherjee is for the petitioner. He has not been able to come to court due to some personal difficulty.
Where is your file?
Lordship,
Take my file, move the matter. What is the dispute about? Now? Tell me what is the dispute.
Lordship, actually, I am not.
What is your length of practice?
It's been 5 months.
5 months is sufficient. Start the matter. Tell me the reliefs. Show the prayer. I mean, see the prayer portion. I don't have another copy. See the prayer portion. What is the relief sought? What is your name?
Ahitagni De, Lordship.
Pardon?
Ahitagni De.
Ahitagni De.
Yes, Lordship.
Very well. Yes.
Lordship.
Come prepared the next day. Learned counsel for the petitioner, Mr. Ahitagni De, seeks an adjournment. Full stop. Accordingly, let the matter stand adjourned till May 24, 2023 to enable Mr. De to take appropriate instructions and move the matter on the next occasion.
Lordship.
আমি কি বললাম? না না April, sorry. 24th April, not May.
Part heard matter, item
Yes.
23.
Same predicament. Oh, you're appearing for that.
Yes, madam. Mr. Shengupta.
Oh, that part heard better. Mr. Shengupta, yes.
The notes of argument, your lordship.
You have already filed your notes of arguments. Take some time, file after some days so that there are too many CV matters.
No, we have not filed till now.
Excellent. When do you want to file it? May, June? Whenever.
I'm
He's ready with
very sorry. Ready আছে দিয়ে দাও ready থাকলে দিয়ে দাও
No, take your time because I'm hard pressed with CV matters.
No, my lord.
No, this is just for joke. You can hand over.
দিয়ে দাও
No, check up whether you can actually file. Ready? Very well.
ready
Read.
but to be very frank, I have not gone through entirety in
Whatever
that
you
way.
choose, Mr. Paja, whatever you say.
Any day I will
Go through it today. I'll take it up tomorrow then.
yes
I'll record that they are filing their petition, their written notes.
so lordship.
Anything want to?
No, I have filed, my lord.
Yes.
Mr. Shengupta may make some submissions. That is the only, he is at court number 1 only.
Oh,
That is the only thing. Otherwise, it is settled by him and
The written notes of argument filed by the writ petitioners be kept on record, full stop. On the prayer of learned counsel for the WBACTCL, the matter is adjourned for the day to enable learned counsel for the WBACTCL to take instructions in the matter and to file their written notes of arguments. Tomorrow.
Tomorrow. Lordship, I am very sorry that inconvenience for this court.
No, no, not at all, Mr. Pan. No question of that. Yes.
24.
Item number 24, Mr. Shubir Shanal is appearing in this matter, because of his personal difficulty. He had come to court. He had left, my lord. Kindly-
I appear for Milord State.
When should I keep it? Tell me.
After 25th. If that,
Yes, yes, I have no difficulty. Yes, Mr. Naik.
Milord, I have obvious.
Very well. On the prayer of the petitioner, the matter is adjourned till 26th, till April 26, 2023.
grateful, my lord.
For hearing. Item 25.
My lord, this matter, my lord, I appear for the writ petitioners. My lord, no, please.
In this matter, my lord, my station manager, my lord, told me, my lord.
Please use the microphone. Please use the.
Time, my lord. My lord, in this matter, my lord, please give me 3 weeks time, my lord. They are, my lord, going to sort out the problem, my lord.
It is submit. Yes.
No.
It is submitted by learned counsel for the WBACTCL on instruction that efforts are going on the part of the WBACTCL to sort out the dispute between the parties. Full stop. Accordingly, let the matter stand adjourned and shall next be listed on May 11, 2023. 11th May,
My lord.
after 3 weeks.
My lord, affidavit in reply to be taken up.
Opposition they have not filed probably. They have.
Opposition, my lord, I have filed, my lord.
You have already filed?
Yes, my lord.
Let us just check. Position টা থাকলে তখন। Well, affidavit in reply filed today be kept on record.
Matter is with regard to my shifting of a high tension line, my lord.
If it can be sorted out, that's the
Yes.
best
Yes, my lord.
possible.
For that reason, my lord, I
Hence-
have
hence I
filed,
As
my lord.
usual, good office. Thank you so
Yes.
much. Yes.
Grateful, my lord.
I'm trying it. After, my lord, 3 weeks, my lord, I will.
11th May.
Grateful.
11.
26.
I'm for the petition.
Yes, Mr. Bhattacharya, what is the matter?
I don't know.
My lord will kindly come to
Today there is no paucity of time. We can continue after the, on the last occasion, it was adjourned due to paucity of time.
my lord, 2 p.m. No, my lord.
Why not?
Lord, there is a specially fixed matter before the division bench presided over by Justice Arijit Banerjee. Specially fixed.
Very well.
matter.
Start the matter.
Yes. Now, my lord.
Take the microphone, Mr. Bhattacharya.
Yes, my lord. Kindly comes to my lord, page 18.
Finish it before recess. Page 18, yes.
Yes, my lord.
If you can.
My lord, after my lord, provisional assessment was done. Now, my lord, we have filed my lord objection against that. This is the order of final assessment. Kindly, my lord, let me place it. And
Your challenge is against this?
against the appellate authorities order also.
Yes.
An inspection was made on 22nd April 2016 when unauthorized use of electricity was detected by passing the energy meter from village transformer at your premises. Kindly marks these few words. Electricity was detected by passing the energy meter from village transformer at your premises.
By
The-
bypassing.
by bypassing. Yes, sorry, my lord. The unauthorized line was disconnected, removed, labeled, and seized on 22nd April 2016, and necessary complaint was lodged before the OC was at local PS on that date. Provisional bill was raised under Section 126 of Electricity Act 2003 upon receipt of objection submitted by you. Hearing of final assessment was held on 15 June 2016 at the chamber of the undersigned in presence of you. After threadbare discussion, the undersigned has reached to a conclusion that the final bill raised as
1,57,870 with the direction to pay the amount 1,57,870 within 15 days from the date of issuance of this memo to this customer care center. My lord, this amount was deposited by me as a condition to obtain bail in the criminal case. This may be appealed before the appellate authority if aggrieved by either of the
The
parties.
entire amount was paid.
Entire amount was paid.
Very well. Then
Under 127, I was given the liberty to prefer appeal. Now, my lord, kindly see, my lord, page 19, the appellate authority's order.
no, you deposited the money as condition of bail.
Bill, yes. And
So
so,
what about the deposit regarding the appeal
my lord, appeal, my lord,
that you put in separately?
my lord, I have deposited it, my lord.
Anyway, not sure. Yes.
I'm not
Let us
sure.
continue. Yes.
But this, it is recorded, my lord, it's deposited. My lord, kindly comes to the third paragraph, second paragraph, on hearing the oral submission. The first paragraph is only, my lord, submission record. On hearing of oral submission, examine the written submitted documents, I come to the conclusion that the assessment against pilferage of electricity for illegal use may be achieved by considering the average run as 12 instead of 14 hours per day for the period as assessed by the assessing officer. Nothing much could be, my lord, made out from this. Accordingly, it is hereby ordered that that revised energy bill for pilfer loss of electricity is to be preferred by the assessing officer and station manager Almagora Customer Care Center WBSEDCL in terms of section 126 of the Act and corresponding clauses of WBERC notification number such and such. The revised bill to be served to the appellant within 7 days from the date of this receipt of this order. The amount of energy charges, etc., already paid by the appellant for the same period is to be adjusted as per rule. Now, my lord, kindly comes to, my lord, section 126 of the Act.
There was an allegation of theft also.
Theft also. My lord, in criminal case, my lord, I've been acquitted.
126, yes.
Yes, my lord. Kindly comes to, my lord, 4, subsection 4 onwards. Any person served with the order of provisional assessment may accept such assessment and deposit the assessed amount with the licensee within 7 days of service of such provisional assessment order upon him. Then, my lord, 5, if the assessing officer reaches to the conclusion that the unauthorized use of electricity has taken place, the assessment shall be made for an entire period. Now, this is where I am harping on. Entire period during which such unauthorized use of electricity has taken place, and if, however, the period during which such unauthorized use of electricity has taken place cannot be ascertained, such period shall be limited to a period of 12 months immediately preceding the date of inspection. My lord, this is the calculation which is given in the, my lord, statute. My lord, can't be ascertained either from the final assessment order or the appellate authority's order, my lord.
Let me see the provisional. Not annexed. Must be there in the provisional order of assessment. It is generally in the provisional order of assessment.
My lord,
Final assessment heard you, was gracious enough to reduce it a bit.
My lord, and my lord, in the, my lord, now, my lord, kindly comes to, my lord, the order of the, my lord, page 25, the special court order, my lord.
Acquittal.
Acquittal. My lord, a few, my lord, portions I would be placing, my lord, before your lordship. It starts at page 25. The order dated 13th March 2019. Now, my lord, kindly comes to, my lord, page 28.
Yes.
Now, my lord, kindly see paragraph 11. What was the submission of the, my lord, ACDC? Par contra, the learned defense counsel has submitted that the prosecution has failed to prove the case that there is no evidence that the accused used the electricity illegally by direct hooking for his wrongful purpose. The learned advocate has contended by referring to the evidence of the prosecution witness that there is no evidence that the accused was consuming electricity illegally. He has prayed for acquittal of the accused in the present case. On this paragraph is very important. 12. On scrutiny of the record, it appears that the official PW1 of WBSEDCL being the electricity distribution licensee under the Electricity Act 2003, did not state who was the owner of the place of occurrence. The independent witness did not state anything regarding the involvement of the accused in committing the offense of the offense as complained of. It is the specific case of the prosecution that the accused was using electricity by bypassing the energy meter by direct hooking from the electricity source of WBC. But this is also stated, Lordship kindly recollects, in the final assessment, or that's why your Lordship marked that portion. They have seized the hooking arrangement by preparing the seizure list in presence of the other officials of the company, but the same has not been produced. PWs have failed to identify the place of occurrence which allegedly belonged to the accused herein. There is no document to show that the place of occurrence where the theft of electricity took place belonged to the accused. The officers of WBSCTCL and the investigating officer of the case have failed to disclose who are the owners and the consumer of the premises in question. No electrical appliance or gadget was seized by the police at the time of investigation. No MRI test has been conducted by, on the energy meter to ascertain that the non-sue of the same while electricity illegally by way of hooking. There is no explanation as to why the energy meter has not been seized at the time of inspection. Now, my lord, judgments are cited. They are dealt with. Kindly comes to page 30, paragraph 18.
Yes.
The second proviso to section 135(1) of the Act enables the shifting of burden of proof only on the initial burden being discharged by the respondent. The initial burden is on the prosecution to prove that any artificial means or means not authorized by the board or licensee exists. Unless it is so proved, the presumption of dishonest abstraction does not get attached. It is in the present case, the prosecution has failed to prove the initial burden in view of the evidence of the on the record as discussed above. No one made any attempt to ascertain the quantum of units of electricity which has been illegally used by the accused in determining the civil liability in terms of section 154(5) of the Electricity Act 2003. At the time of evidence, the officer PW1 of WBSCTCL did not state any single word as regards to the quantum of electricity in units which have been used by the accused illegally. Similarly, the accused also did not dispute and challenge the final assessment made by WBSCTCL under section 127 of the Electricity Act 2003. Well, this is true because this writ petition has been filed after this. This is true. This I cannot deny also.
No, 127 challenge was filed.
127.
It says that
no, appeal was preferred. Appeal was preferred.
It is stated here. Similarly, the accused also did not dispute. Challenge the no, you did not dispute or challenge the final assessment under 127.
No, but I have
is wrong.
This is wrong. This is wrong.
Very well.
The accused has paid the entire theft bill on 13 July 2016. Therefore, this court is not in a position to determine the civil liability in absence of any evidence in this regard. And ultimately, kindly see the ordering portion. I have been acquitted. At the bottom, my lord, I have been acquitted. My lord, this is the sum and substance of the case.
You can't come after to come back tomorrow then.
Tomorrow.
Learned counsel commences the hearing, but prays for an adjournment after recess. Full stop, next para. Accordingly, let the matter stand over till tomorrow.
Tomorrow. Great.
Regarding item number 27, my lord,
27 what?
my lord, Mr.
Use the mic, use the mic.
My lord, Mr. Kaustubh Chatterjee is appearing for the petitioner. My lord, he has left for his parent house, my lord. I'm praying only not today.
He left for his parent house after his marriage.
No. I mean, he went to his...
given, my lord.
I board show kore do. Call kore do 27 ta.
Last chance was given, my lord.
Last chance was given. I'll take it up after 2. You do the matter.
I don't have the brief,
We
my
have
lord. I do not
completed
know
all
anything. Just today morning.
Give the brief to her during this is.
Well, just today morning, he has requested me to...
After 2, no.
I see.
হ্যাঁ
বলো হ্যাঁ
Yes,
27, my lord.
last chance was given
Yes, my lord.
to move the matter.
First page, last line, my lord. First page of the order.
Yes. Yes, what is that?
My lord, pursuant to your lordship's last direction, my lord, connection has already been given.
That was on an ad hoc basis. That was recorded in the order dated for
Yes, yes, my lord.
ad
And
hoc basis,
my lord,
subject to result of the writ.
yes, my lord.
Move the writ finally.
My lord, opposition reply all are exchanged. My lord, I am filing my affidavit in reply on behalf of the petitioner.
My lord, I have not received any opposition, any reply. They have not.
Position you are to file.
Private
My lord, the
respondent.
private respondents, they have filed their opposition, my lord.
File. দেখে নাও আমি দিচ্ছু কি আগে দেখে নাও অপোজিশন আছে কিনা
তোমাকে দিয়েছে।
হ্যাঁ, I have received my copy.
you may have received, court may not have. তাইনি তো? Take it back. There is no opposition on record. Yes, what is the matter about? Tell me. Yes.
My lord, the petitioner,
Yeah, please take your seat. Yes.
my lord, the petitioner, he obtained a property by dint of a gift deed from his father. And thereafter, my lord, he applied for electric connection to his portion of the property, my lord. And the private respondents, my lord, they are the brothers of the petitioner, my lord. And to get the electric connection and other common other purpose for ingress and egress to their
Sona
respect,
Pradhan is
my lord.
respondent number 7 is not the brother, cannot be the brother.
No, no, she is not the
Either
brother.
sister
but-
or some brother's wife. Or
Yes, my lord, that I don't know the respondent number
Anyway.
7, how she is related with the
Very good.
petitioner.
So you got it by a gift deed from your father.
Yes, my lord.
You are the exclusive owner as per the gift deed.
Yes.
You applied for electricity. It was refused.
Electricity, it was initially refused, my lord. Thereafter, after moving this writ petition before your lordship, on prima facie satisfaction, your lordship directed to erect the pole on the common pathway as the petitioner asking for.
So what is the objection of the private respondent?
My lord, the private respondent, my lord, they objected to that there are some other portion or some other passage. The WBSCDCL, they could have erect the electricity pole and they could have give the connection to the premises of the petitioner from that part, not with the common passage, my lord. But in the common passage, my lord, I have annexed from the writ petition. I
Is
have,
there any civil suit pending between the parties, private parties?
yes, my lord, a civil suit is there, my lord.
Who filed?
My lord, one Basudev Pradhan. He is the private respondent.
Husband of private respondent number 7. As per the cost.
Yes, yes, my lord.
As per your cost title.
Yes, my lord.
What is the suit about?
Suit for, it is a suit for
You are not a party there.
my lord, I have got a very short time to go.
Let me
through.
hear Ms. Rai on this. Yes. What is your objection to give electricity connection?
My lord, we have given connection. We have no objection to.
Now, that was on an ad hoc basis. That is what we see. Anyway, otherwise there is no objection on your
No.
part.
2 poles were installed again. It was broken by some miscreants. And again, 2 poles were broken and huge expenditure was made.
Achha.
And finally, connection was given on 14th December as per your lordship's direction.
Very good. Then I'll dispose of the writ petition on this. Then at counsel for the petitioner submits that the petitioner became an, you are for the state.
Yes.
Oh, very, yes. Then at counsel for the petitioner submits that the petitioner became the owner of the premises by virtue of a gift deed executed by the father of the petitioner. Full stop, next para. Subsequently, comma, when the petitioner sought an electricity connection at the property, comma, the private respondents obstructed such connection being given. Full stop, next para. Learned counsel for the WBACDCL contains that the previous electricity poles were broken by some miscreants, comma, for which new electricity poles had to be installed upon incurring huge expenditure. Full stop, be that as it may, comma, at the time of call, none appears for the private respondents, although all the other parties are represented through counsel, including the state. Full stop, next para. The premise of the objection raised by the private respondents, comma, as it appears from the records, comma, was at best regarding a private dispute between the private respondent and the petitioner with regard to the title of the property over which the connection is given. Full stop. However, comma, since the private respondents choose to remain unrepresented continually when the matter is being called on for hearing, comma, there is no further scope of keeping the matter pending. Full stop. It was recorded in the order dated March 31, 2023 that electricity connection was effected as per the court's order on ad hoc basis to the petitioner's premises on December 14, 2022. Full stop. As of today, comma, the WBACDCL does not have any pending claim or grievance against the petitioner so as not to give electricity connection or maintain the ad hoc connection already given. Full stop. In such view of the matter, comma, since the grievance of the petitioner has already been redressed and there is no contention with regard to such electricity connection on the part of the licensee, comma, the said connection shall be maintained in the petitioner's property, subject, comma, of course, comma, to the petitioner going on paying electricity charges regularly. Full stop. Next para. Accordingly, WPA 4741 of 2022 is disposed of with the above observations, indicating that the electricity connection given on ad hoc basis by the WBACDCL to the petitioner shall now permanently remain in favor of the petitioner, comma, subject, of course, to the petitioner otherwise complying with law and making regular payments of electricity charges. Full stop. It is made clear that such electricity connection shall not create any special equity in favor of the petitioner, which the petitioner otherwise does not have in law. No rest to cause.
I'm deeply
Grateful.
obliged, Your Lordship.
28.
My lord, Mr. Advocate, Pradeep Palis went at his native
Mr.
place.
Who is appearing?
Mr. Pradeep Pal is went to his native village for his Mother Vatsarik ritual. I'm praying for
Mother?
Mother Vatsarik ritual. I'm praying
When should
for
I keep it?
1 week time.
On the prayer of the year for the petitioner.
Yes.
On the prayer of the petitioner, the matter is adjourned and shall next be listed on April 26, 2023. Thank you.
$29.
My lord, item number 29, Mr. Sanjay Mukherjee is appearing on behalf of the petitioner. My lord, this matter relates to the petitioner before your lordship is the auction purchaser of the property. After purchasing, he applied for commercial electric connection. His application was turned down only on the ground that there was a previous due of the Oswell company, my lord, from whom the petitioner purchased the. On the last occasion, Mr. Sanjay Mukherjee advanced his argument, my lord.
Yes, Mr. Naik, what is your stand in the matter? What is your contention? It was adjourned for you initially to argue. What is the nexus?
Nexus is not
Auction purchase?
No, not auction purchase. The condition in the auction purchase is this, my lord, all liabilities regarding, my lord, this claim for electricity and any other dues, that would be the responsibility of the purchaser.
Show me that portion from the deed. It must have been annexed. List of encumbrances was indicated as nil. That was pointed out by Mr. Mukherjee on the last occasion, page 19. So with that nil, whatever else was entered in.
And my lord, here in this particular case,
Yes.
the difference is this. My lord, this is the
So first, let us see that clause where
Yes.
it has been stated with the encumbrances. Rather, I find the opposite in 3 places at least, which are placed by Mr. Mukherjee. Page 17, 19, as well as somewhere else I saw, yes, page 41.
Darshak, can you bear me 1 minute?
Yes, yes, absolutely.
My lord, kindly, my lord, come to my lord, page 37. That's the e-auction sale notice.
37?
Page 37 of the
Yes.
read petition. They have
Right,
annexed.
right.
Here, my lord,
As
page,
is where is
page 40, my lord, page 40 is the total area of the land, 30 acres. That is there. Now, my lord, page 41, terms and conditions of the e-auction sales are as under. My lord, kindly come to 3. To the best of knowledge and information of the authorized officer, there are no encumbrances on the property. However, the intending bidders should make their own independent inquiries regarding the encumbrances, title of the property, put on auction, and claims and rights, dues affecting the property prior to submitting their bid. And the e-auction advertisement does not constitute and will not be deemed to constitute any commitment and or representative of the bank. The property is being sold with all the existing and future encumbrances, whether known or unknown to the bank. And the authorized officers and secured creditors shall not be responsible in any way for the third party claims, rights, dues. No claim or whatsoever. Nature will be entertained after submission of this. So this is the condition, my lord, of their own. They will have to make an inquiry, and the bank, they will take liability only up to their, my lord, demand the loan amount. And, my lord, they are not aware of any other encumbrances. That is to be independently inquired by the party concerned. And this is not, my lord, as is where is basis. It is a sold case. Therefore, here the difference I want to make is, my lord, here they have specifically said that all the liabilities of their own they will have to incur, whether there is dues or not. But so far as there is no known encumbrances of the bank. Bank is only interested for their own, my lord, loaned amount, which is to be recovered.
When was the erstwhile consumers supply disconnected, Mr. Naik?
Just long before, lordship.
So 180 days is over after that.
It's a permanent disconnection. Yes, yes.
It's a permanent disconnection,
Yes,
right?
that was there. That was there. Now, my lord, another point is this, my lord, they have purchased the property by paying lordship 4 crores and odd, where they have of their own disclosed the value of the property is, my lord, 7 crore 85,042, page 59.
Yes.
They say that this is the value, so in a very lesser price, they are knowing fully well they're purchasing it. They know they have disclosed the value of the property and they are purchasing the property at, my lord, 4 crores and all that. So 2 points what I'm taking here, that if somebody purchase the property knowing fully well that there's a very lesser price of the market. And that's not the, my lord, that there is a condition precedent that they will have to be aware of the other claims of the property also. The auction sell only with regard to the bank's claim. But so far the other claims are concerned, bank is not taking any responsibility, they have floated, my lord, the. Therefore, in these two clauses, my lord, my full submission is this. Since, my lord, they have purchased the property in a very lesser price of their own, they have disclosed. And as per, my lord, clause 39 of 46, regulation 46, where if somebody benefited by the, my lord, sell or enter into the property.
Clause
13.9, lord.
13.9.
13.9 or 46.
But there has to be a nexus which you have to show.
No, that is the nexus, because I am saying 13.6, 13.9 says, kindly, my lord, once for.
Yes, benefited. Benefited from non-payment of the aforesaid outstanding dues. So they say you say that they have purchased in a lesser price.
And they admitted.
So therefore that is the benefit.
They've admitted it.
They have admitted due to electricity dues not being there.
No, they have admitted that this is the value of the property. And, my lord, the.
Where have they admitted?
At page 59, lordship.
59 years.
Yes. The different, my lord, plots they have purchased with 32 acres. And, my lord, total value they have disclosed is, my lord, 7 crore 85,042. 85 lakhs 42,784. And, my lord.
That is not the total value, market value. That is the market.
That's the market value.
Right.
That's the market value. And on this, my lord, they have paid, my lord, the revenue also.
Right. So these are the two grounds, Mr.
Only 2 points I am taking, we are trying to distinguish the entire fact, because they know it. Valuation they know. They are knowing fully well they're purchasing the property in a very much lesser price. And that's the benefit they're enjoying. Therefore, and also, my lord, in auction sell, it is very clearly stated in terms of the condition that all other liabilities you will have to incur of your own. That's a precise, my lord, clause.
So I'll pass my order now. Learned counsel for the petitioner.
And I am also not relying on other decisions, because my lord is pleased to distinguish those decisions in number of
Learned
judgments.
counsel for the petitioner contends that the petitioner, a purchaser by way of auction sale of the property in question, sought for a new electricity connection. However, the WBACDCL refused to give such connection unless the petitioner pays alleged outstanding amounts left due by the erstwhile consumer stroke previous owner, Messrs. Amrit Bioenergy and Industries Limited. Next para. The plinth of the submission of the WBACDCL is that it is clear from the auction notice itself that the property was sold on as is where is basis. It is further submitted that the property was purchased at a reduced price by the petitioner, which is admitted. In such context, learned counsel for the WBACDCL places reliance on the total market value of the property mentioned at page 59 of the writ petition, as compared to the actual price paid by the petitioner. Next para. That apart, learned counsel for the WBACDCL places reliance on clause 3 of the terms and conditions of the e-auction, which, inter alia, clearly mentioned that the property was being sold with all the existing and future encumbrances, comma, whether known or unknown to the bank. Full stop. Next para. It was further stipulated there that the authorized officer stroke secured creditor shall not be responsible in any way for any third party claims stroke rights stroke dues. Full stop. No claim of whatsoever nature would be entertained after submission of the online bid regarding property put for sale. Full stop. Next para. On the other hand, comma, the petitioner relies on certain other portions of the documents in question. Full stop. It is seen from the sale certificate issued upon the auction purchase of the petitioner that in internal page 5 of the same, comma, it was stipulated that the sale of the scheduled property was made free from all encumbrances within double inverted known to the secured creditor, double inverted clause, listed therein below on deposit of money demanded by the undersigned. Full stop. Next para. Such list given therein does not include the electricity use. Full stop. Next para. Moreover, comma, at internal page 7 of the sales certificate, comma, under the head within single inverted list of encumbrances, L capital, E capital, list of encumbrances, single inverted clause, comma, the encumbrances were shown to be within double inverted capital N, NIL, nil, double inverted clause, comma, except the bank's charge and State Bank of India within bracket consortium member bank. Full stop. Next para. That apart, comma, although it is mentioned in the first page of the e-auction sale notice that the property was being sold on within double inverted as is, where is, whatever there is, and without recourse basis, double inverted clause, comma, in the details of encumbrances over the property known to the bank, comma, as disclosed in item 9 of the column contained in the said sale notice, comma, the encumbrances were again shown to be nil, except the charge of the bank and the State Bank of India within bracket consortium member bank, bracket closed. Full stop. Over and above such provisions, comma, clause 3 of the terms and conditions of the e-auction, comma, which has been relied on by the WPACDCL, comma, in its initial part, comma, also indicates that, comma, to the best of knowledge and information of the authorized officer, AO capital, comma, there are no known encumbrances on the property, full stop. However, comma, the intending bidders were to make their own independent inquiries regarding the encumbrances, comma, title of property put on auction and claims stroke rights stroke dues stroke affecting the property, comma, prior to submitting their bid. Full stop. The basis of the case of the WBSCDCL is that the bank disowned its further liability with regard to other claims of third parties, comma, within which broad head the WBSCDCL apostrophes claims are also included. Full stop. As such, comma, it was the duty of the petitioner, comma, prior to purchase, comma, to inquire into the dues in lieu of electricity charges. Full stop. Next para. However, comma, such allegation cannot be sustained, comma, since admittedly, comma, as revealed from inquiry of court by learned counsel for the WBSCDCL, comma, the previous electricity supply to the erstwhile consumer had been disconnected much earlier, comma, thereby attracting the statutory provision of automatic termination of the contract between the WBSEDCL and the erstwhile consumer after expiry of 180 days of the disconnection. Full stop, next para. Hence, comma, even if the petitioner did inquire into the claims and dues with regard to the property, comma, befitting a prudent person, comma, it could not have been possible in any manner to ascertain the previous dues of the erstwhile consumer with regard to the same premises. Full stop, next para. Hence, comma, it cannot be said that the petitioner was liable as the auction purchaser, comma, by default, comma, to pay the outstanding charges allegedly left by the erstwhile consumer. Full stop. Another component which has to be considered in the present case is clause 13.9 of regulation number 46 of the WBERC of 2010. Full stop. The said provision indicates that for getting new connection for supply of electricity from a licensee, comma, an intending consumer shall be required to pay all outstanding dues to the licensee in respect of any other service connection held in his stroke her name located in the area of supply of the same licensee, and shall also be responsible for payment of outstanding charges calculated in a prorated manner, comma, if it is established that he or she has had a nexus to italic seven, nexus with the previous consumer within bracket S, bracket closed, including the purchaser, stroke, the new lessee, stroke, the new tenant of a property or a portion thereof, in respect of which there are outstanding charges, and stroke or who has stroke had benefited from non-payment of the aforesaid outstanding dues by the previous consumers to the licensee. First of one of the limbs of the arguments of the WBACDCL is that since the petitioner admittedly paid much less than the market value of the property, comma, it is required to be deemed that such concession was provided on the premise that the petitioner was liable to pay the previous dues and claims in respect of the property, comma, including the area dues of electricity payable to the WBACDCL. Full stop. However, comma, as is well known and a common practice of regular commercial transactions, comma, an auction sale does not necessarily fetch the market value. Full stop. The minimum price at which the auction sale was fixed has to be covered to sell a property in favor of a third party. Full stop. As such, comma, the market value itself cannot be an indicator of the actual price payable by the purchaser in an auction sale, comma, provided the minimum fixed price is paid by the purchaser. Full stop. The peculiar feature of an auction sale, comma, as opposed to a direct sale is that the market value need not be paid by the auction purchaser. Full stop. Merely being the highest successful bidder would entitle a third party to purchase a property by way of auction purchase. Full stop. As such, comma, it cannot be said that the petitioner, comma, as an auction purchaser, comma, by default had the liability to pay electricity dues or had any nexus with the erstwhile consumer simply because the purchase price paid by the petitioner was less than the market value. Full stop. Next para. Inasmuch as nexus is concerned, comma, which is a mandatory requirement of clause 13.9 of regulation 46 for the purpose of fixing liability to pay outstanding dues on a subsequent purchaser, comma, No such nexus has been established in the present case. Full stop. There is nothing on record to show that the petitioner benefited or enjoyed the electricity connection when the supply was existent in favor of the erstwhile consumer. Full stop. That apart, comma, since the property was purchased by way of auction sale, comma, it cannot also be said that the petitioner had any other nexus than purchasing the property with the erstwhile consumer, comma, who was the borrower. Full stop. Next para, it was the bank which sold the property in auction sale as per law to recover the amounts due from the erstwhile consumer. Full stop. Hence, comma, since the burden of proof of nexus is on the licensee, even as per clause 13.9, comma, there is no scope for the WBA-CDCL to fix such liability on the petitioner, comma, and auction purchaser. Full stop. In the absence of proof of any nexus in the present case, comma, as evident from the above discussions, comma, there is no scope of refusal to give new electricity connection to the petitioner, comma, subject to compliance of all other formalities by the petitioner. Full stop. Accordingly, WPA number 10671 of 2022 is allowed, comma, thereby directing the WBA-CDCL to give a new electricity connection to the petitioner at the property in question, comma, subject to compliance of all other formalities by the petitioner, semicolon. However, comma, the WBA-CDCL shall not claim the outstanding dues allegedly left by the erstwhile consumer from the petitioner in giving such electricity connection. Full stop. It is expected that the connection shall be given to the petitioner by the WBA-CDCL as expeditiously as possible, comma, preferably within 3 weeks from the date of compliance of all formalities by the petitioner. No rest to cause urgency to autopsy. Thank you.
Grateful, Lordship.
Thank you.
Add middle one minute. Instead of 3 weeks, Lordship, can it be?
3 weeks is all right. Grateful. Thank you.
Item 30.
30.
Item 30, well, on behalf of the respondent number 1, I am praying for not today only.
Not today?
Petitioner today.
I'm petition, you have to file your reply, Mr. Naik.
Lordship.
File that.
Lordship.
When should I keep it? Not today only.
Only not.
Very well.
But it has been served, Lord.
Opposition nahi?
Opposition, I think, well, opposition is ready. Well, he has not come today.
An adjournment is sought by the petitioner, by the respondent number 1, when the matter is called on for hearing. Full stop. Since the petitioner is ready to file its affidavit in reply, comma, but no opposition has yet been filed by the respondent number 1, comma, the time for filing affidavit in opposition is extended till tomorrow. Full stop. Reply, if any, shall be filed also tomorrow, comma, since a copy thereof has already been served on the respondent number 1. Full stop. The matter shall be shall next be listed tomorrow for hearing under the same.
Tomorrow, Lordship, kindly fix it on 26th.
Come back tomorrow. You have already served a copy of the reply to him.
Yes. I have served it, but obviously not within the time after expiry of the time, Lordship.
They are also liable now. Very well. Columns.
31.
31.
Petitioner, my lord.
Petitioner.
Well, on
Private
the last occasion, your lordship directed me to serve upon the private respondents.
appearing. Yes.
There is the affidavit of service.
Yes, Ms. Ghosh, what is the problem?
My lord, the petitioner and her sister-in-law, namely Annapurna Nandi, she is a private respondent here. They are joint owners of the property. My lord, the petitioner's husband, Ashok Nandi, died on 14th February 2022. My lord, just after his death, during the mourning period, the private respondent number 5, Sushanto Sutar.
Six.
Oh, sorry.
Yes,
Sushanto Sutar, he is a tenant of one shop room in the ground floor.
he started encroaching the other portion of the outside his tenancy portion, my lord. My lord, here, yeah, it is pertinent to mention.
You are
here
for
that-
respondent number 6.
6 and 7, is sole proprietor.
My lord,
Yes.
my lord, the petitioner's husband was the only male member of landlord's family. After his death, the petitioner is a childless widow, and her sister-in-law, married sister-in-law, is the other owner. Taking that advantage, the Sushanta Shuta started encroaching the other portions. Anyway, my lord, the civil suit is pending for that. I'm not going into it.
Civil
My
suit for eviction regarding
civil-
the other portion.
No, for injunction, because he was encroaching the other portions. My lord, thereafter, my lord, on 21st, on 14th, the husband of the petitioner died. On 21st, Sushanta Shutar made an application before the CSC that the electric meters are in dangerous condition. It may cause harm anytime. My lord, on his application, my lord, the electric meter boxes were within a restaurant run by the petitioner's husband, namely New Monmouth Cabin. It is beside his tenanted portion, adjacent to his tenanted portion. My lord, the meter boxes are within that restaurant since long back. It's a very old restaurant. My lord, during COVID period, the restaurant was closed. When the restaurant was closed, he for the first time discovered that the electric meters are in a very insecure position. So he made an application, and it is admitted by the CSC in their
Restaurant was yours.
yes,
Right.
landlord's restaurant. Within that, all the meter boxes are in a
Yes,
portion
yes.
of the restaurant.
Sorry.
My lord, the CSC has admitted in their affidavit in opposition that only on the application of Sushanta Shutar, without any consent of the landlords, without any signature from the other tenants, only on application of Sushanta Shutar, on the next day, they were very active. On the next day, they made an application and they found that the electric meters are in insecure condition within the covered.
So what happened after that?
And thereafter, they shifted the meter box to an open space. I have annexed the photograph. Lordship may kindly see. It is annexed in the reply, by reply. My lord, within, it's an open space, my lord. Beside,
A new meter box position.
Photograph which page?
my lord, it is annexed in the affidavit in reply. Lordship may kindly
Right.
see.
Yes.
A photograph is there.
No, I don't find it. Maybe my mistake. I'll try to find it. This is the affidavit in reply on behalf of the writ petitioner to the affidavit in opposition affirmed by the respondent number 6 and 7.
Page-
Or
No,
the other
no,
one.
no, other.
Page 8, annexure R1.
তোমায় দেবো কেন? ওটা ঠিক
I don't have a copy of that one.
বলে CSC রিপ্লাই করবে।
CSC
CSC অপোজিশনের রিপ্লাই তোমায় দেবো।
একটা রিপ্লাই রয়েছে ওদের অপোজিশনের রিপ্লাই, সেটা নয়, এটা উপরেই রয়েছে, মানে 6-7 এর রিপ্লাইটা নয়, affidavit রিপ্লাই অপোজিশন সব কটা দেখতে পাচ্ছি, রিপ্লাই ওদেরটা পাচ্ছি।
My lord, that second one was filed later on. My lord, on the first day I filed that is
অপোজিশন না, রিপ্লাই দুটো অপোজিশন পাবে, দুটো অপোজিশন আছে, একটা রিপ্লাই আছে, যে রিপ্লাইটা উনি বলছেন সেটা নেই। ফটোগ্রাফ দিয়ে খোঁজো তাহলে ইজিয়ার হবে।
ছবিটা দেখুন। এই ছবিটা, এই ছবি।
You are sure it is not with you, the main reply? The
No,
original,
my lord, I have filed.
you have filed. Check করো তাহলে। এটা তো এফিডেভিট অফ সার্ভিস।
আমার ডেটটা কেটে গেছে, কত তারিখ, এটা ডেটটা কেটে গেছে।
পেয়েছো? থ্যাংক ইউ। মুশকিল আছে। Yes.
Lordship may kindly
Not
see
open
the,
space, there is a shed, tin shed over that, or asbestos or whatever.
fiber shed is there beside a bathroom. In an open space, only asbestos, only fiber shed is there. The meter boxes are shifted there. It was within a covered area, only to encroach that portion, my lord. Thereafter, he demolished the in between partition wall, etc. I'm
That
not.
is the subject matter of dispute.
No, I'm not going into it. But
Yes.
my lord, the CSC on application of a tenant only, without any reason, they found that within that room, the meter boxes are
Safety
insecure.
security
So-
measure, they can suo motu also do it. I mean, it's their liability under the law.
My lord, it is in insecure position. Lordship may kindly see in an open space, only a fiberglass is there at any time during storm and thunder, the accident may
We
cause.
don't know how insecure the previous connection was.
No, my lord,
We
it
don't
was,
have any proof of that.
it was
This may be less insecure than the previous insecurity.
no, my lord, because
We cannot decide that
lordship,
from
lordship
here.
may
Petition-
lordship may kindly say, my lord, lordship may kindly appreciate, my lord, it was for long back, the meter boxes were there. Only during that mourning period, when the petitioner's husband died, only that within
The
7 days they
activity
found.
is obviously surreptitious, but what relief do you pray for this to be removed again and put in the original?
Yes, my lord, because it is insecure. It is insecure, my lord.
CSC is responsible for
It is-
this. Insecurity, CSC will be responsible.
But the accident may cause to the landlords also. My lord,
Accident will be cost to the landlord also, not the CSC.
Yes.
But they are liable for the security. So if they say that it's secure, bit more secure than the previous
My lord,
gas burner
my
and all,
lord, may I submit
we cannot
one thing?
decide that in it.
Lordship, where the meter boxes will be placed, the consent from the
True.
landlords are
Definitely.
required. Where is that consent? Lordship may kindly ask them to produce that. My client is also a also a co-owner. My lord, lordship may kindly ask them to produce that.
And your meter is also there,
Yes,
separate meters.
yes.
Which is enjoying connection.
Yes, Mr. Ghosh, only one thing, before shifting the meter, you have to take either consent
Your
or
lordship
notice to.
kindly comes to my affidavit opposition. Page 2, paragraph 5. May I read it out? Previously the meter was inside a eating room, beside a kitchen where there was a gas burner and constantly the fire was on. Milord, be that as it may, Milord. May I read it out? Milord?
Para
5.
Para 5, yes.
That on 21st to 2022, Sushanto Shutor, the private respondent, number 6 herein, submitted online application so and so for shifting of the existing service at premises number so and so. That on 22 to 2022, the answering respondent, upon inspecting the premises, found 9 live meters and 1 disconnected meter, and thereafter selected a technically suitable place for shifting of service existing meter. Subsequently, offer letter dated so and so was issued in favor of the private respondent number 6 for the payment and compliances. That on 5/3/2022, upon necessary compliance and payment of charges, the payment of charges from all the parties.
No, my lord.
The answering respondent shifted the service meter by removing the existing service room from an eating house to a safe and suitable common area. That on 4/4/2022, New Aditya Jewelers, the private respondent number 7 herein,
Yes.
submitted an online application, A1 number for a commercial.
Suppose I can't find any notice to them.
Not-
I can't find any notice to them. It's your unilateral statement backed by theirs that it was beside a gas oven, whatever.
Not admittedly, it is in an eating room. Admittedly.
They are not admitting anything, Mr. Ghosh. Let us be clear on that.
Monmoto cabin is an eating room, and in the writ
Maybe,
petition-
maybe.
in the writ petition, they've admitted that the meter box.
Just merely because the meter box is inside a and whatever, that cannot entitle you to shift the meter to another portion of the owner's property without the owner's consent. You are encroaching upon another portion without their consent. How can you do it?
As far as the technicalities are concerned, Milord,
You have to give notice to them.
Milord, according to instructions, Milord, notices were served.
No.
No, it is not there in your opposition. If you had instruction, it will be there in the opposition.
In my.
No, I'll come to you.
Milord, the question regarding issuance of notice has never been raised.
They should not raise it.
Twofold, that respondent number 6 and 7 are enjoying 2 meters.
I'm coming
Which
to
is
that.
not, which is
I'm
not
coming to
because
that.
the respondent number 6 has surrendered one of their meters, and the
Right.
total amount has been refunded.
Achha.
And the second issue was that it is in an unsafe location. But Milord, it is technically absolutely safe. And Milord, we have shown admittedly meter, the earlier meter was in a eating room. behind.
My lord, not within the
beside-
kitchen of the
gas-
restaurant,
no,
not
beside-
within the kitchen of the
beside the
restaurant. It's a,
gas
it's,
burner. Now
it's
it
in a
is
corner.
now it is in a common space and technically suitable, safe and secure.
But it is encroaching another portion of their property without their consent. Cannot be done.
That has not been an encroachment, my lord. It's a
Yes,
absolutely
so
a
much
common area.
so much area has been
Common
taken.
area.
They could have used it otherwise.
Common area, my lord, but that area has been indicated by.
That's beyond his tenancy. He cannot apply and pay for that shifting.
No, my lord, that particular
right.
area is a common space, not belonging to the solely for the landlord.
Yes.
Even then,
Yes, it is.
landlord is the owner, even if it's a common user.
Kindly allow me to come back whether there any notice has been served or not. Or
No
whether the
question. If
consent-
it's not in your affidavit, this is the hearing stage, Mr. Ghosh. I cannot give you further opportunity.
My lord, a supplementary
It will have to be, no, not at this stage. After hearing is over.
My lord, if they want a further shifting, my lord, and if upon compliance of all the formalities.
You will shift at your cost because Mr. Ghosh, your client has done this without notice to the owner. This has been done. No mention of notice anywhere in the opposition, your opposition. Opposition is exchanged, affidavits are exchanged. We are hearing them at now finally. Now I cannot give you liberty.
My lord, as far as I know, my lord, the notice has been given.
No, you don't know. If you knew that, it would be reflected in your opposition. Where is it in the opposition? Not at all.
The notice has never
Disputed.
No, my lord. Averment তো নেই ওরা শুধু বলছে যে 6,000 একসঙ্গে 2 মিটার ইঞ্জিন
Notice may have been given. If there is no averment in the writ petition, then you are right.
Now, my lord, I'm coming.
No, let me hear them.
I have another.
Yes, what do you say?
Just background. Initially in 2019, I was a tenant of one room. Subsequently, in my opposition, I have annexed another tenancy agreement, which is 1st of January 22. I have given the tenancy of an adjoining portion. Initially, the electric meter is given in my name, Sushanto Sotu, respondent number 6. Respondent number 7 is a sole proprietorship is mine. My lord, I have surrendered that electric meter already to the executive committee, and the only electric meter which is in my name is of the firm, the proposition.
What gave you the locus standi to exclusively apply for shifting of the meter without their consent?
Kindly come to page 23 of my opposition. One of the landlord.
23
of my opposition, my lord. The one of the landlord giving permission to get electricity connection.
No, I'm not on.
Performance respondent.
No, my lord,
He or she is not a party here. You are for that owner. It's 23 years.
my lord, it is, he is
And my
showing the,
agreement is in page.
he is showing the consent for electricity connection. Your lordship is asking for reshifting. My lord, I have not.
You will pray for necessary orders, Ms. Ghosh, in the civil suit.
Lordship.
This cannot be decided from here.
Now, lordship may kindly, lordship, I have another argument, my lord. Another point is there. Another 2 points are there. Lordship, my Sushanto Sutar is a tenant of one shop room. My lord, it is in the tenancy agreement. It is clearly stated that he can take one electric meter in his name. He took the electric meter. I had no objection in the name of Sushanto Sutar. Then, my lord, after death of the petitioner's husband, he applied for an electric meter in the name of New Aditya Jewelers. New Aditya Jewelers. I objected because he is enjoying his meter in his name. How can he take another meter in the name of New Aditya Jewelers? Now, in his opposition, he has annexed a tenancy agreement where he has said that the husband of the petitioner, Ashok Nandi, executed a tenancy agreement in the name of New Aditya Jewelers. Lordship may kindly have a look into the new tenancy agreement. He has stated, lordship may kindly hear me, he has stated in his affidavit in opposition that one shop room is in the name of Sushanto Sutar and the another shop room is in the name of New Aditya Jewelers, not the same shop room. It is stated by him in his affidavit in opposition. My lord, I admit that there is one shop room in the name of Sushanto Sutar. It was, the tenancy agreement was executed by Gorachad Nandi and others. Now,
Please, Bholanath Nandi.
Gorachad Nandi,
Don't know.
earlier landlords, they have died. But at that time, the tenancy agreement was made in between Sushanta Sutar and the earlier landlords. I admit that I have annexed that tenancy agreement in my petition.
What is your other point, please?
Lordship, I'm coming to that, my lord. My lord, the new Aditya Jewelers, he has said that another shop room has been executed, tenancy agreement in his favor by Ashok Nondi, Annapurna Nondi, and others. Lordship may kindly come to that tenancy agreement.
Page 11,
Lordship,
madam. Page
Lordship
11.
may kindly come to.
In my opposition.
Lordship may kindly hear me, then if your lordship may pass any order as your lordship please. My lord, this
What
is
am I doing now?
first day.
Ms. Ghosh, what am I doing now?
Yes, my lord, your lordship.
Please continue.
My lordship may, I know that I'm wasting court's time, but
No,
lordship.
you are
may
not
kindly-
wasting court's time at all.
Lordship,
If I
kindly bear
felt
me
that,
for-
I would have stopped you.
Lordship.
Be assured on that.
Lordship,
Yes.
first day of January 2022. First day of January 2022.
Yes.
My lord, on that date, Ashok Nondi was in hospital. He was not in a position to. I know what your lordship will say, my lord. I know.
I can pay a personal visit to the hospital, but it won't help. probably.
No, my lord, he was not
Can
in
the
a
RIT
position.
court decide all this here? A
Yes.
civil suit is pending.
Yes, but my lord.
They have just shifted the portion
Then-
to a safer portion.
Then I'm coming to another point. My lord,
Well, I'll observe that this will not create any right or equity in favor of the CSC limited.
my lord, other formalities are to be complied with. Other formalities.
If the CSC said it has been complied with, they have paid, they have shifted.
How should
And
serious?
as
My
far
lord,
as the enjoying 2 meters are concerned, my lord.
So you are complicating matters, I'm telling you.
Look,
Yes.
my lord, he has annexed the consent letter for electricity connection from the landlord. That is from Annapurna Nandi, not from Pritha Nandi. Joint property only from Annapurna Nandi. That also, in that also, lordship may kindly come to that that letter once, my lord.
Yes. Which page?
23, madam.
Page
23. The
Oh,
concept.
that one. Yes.
Page 23.
Yes.
Page 23. He has annexed 4th May 2022. No objection regarding installation of new electric meter at 99A Vidhan Saroni in respect of the shop room. Which shop room it is not mentioned, but in the body, my lord, this is to inform you that I, Srimati Annapurna Nandi, along with brothers, namely Gorachad Nandi and Ashok Kumar Nandi and others, this is the earlier tenancy agreement in the name of Sushanta Sutar, not in the name of New Aditya Jewelers. My lord, this is also, my lord, in that there is no whisper of new tenancy agreement in between Ashok Nandi, Annapurna Nandi and Sushanta Sutar. It is Gorachad Nandi and Ashok Kumar Nandi jointly inducted Sri Sushanta Sutar. This is the earlier agreement which I admit, which I have annexed.
You filed an eviction suit against them.
Yes.
My lord, for
You said there is a suit for permanent injunction.
declaration and permanent injunction.
No eviction sought.
No, there is a status quo order is there.
Yes, obviously.
Mm,
So let the status quo be maintained.
Status quo order. No, my lord, status quo order, in spite of that status quo order, it was communicated to the CSC. Then also it has.
This is not bound by that status quo order. You know every answer before you are submitting even, Ms. Ghosh. You do civil matters regularly.
Yes, my lord.
What else?
But my lord, your lordship has seen from that the other formalities are to be complied with. Before shifting,
Obviously,
all the formalities should have been complied.
They have complied.
Before-
That is the stand of the CSC.
They have not complied. CSC, what CSC is saying, my lordship may kindly see the affidavit in opposition filed by the CSC.
Naturally,
No,
Mr.
no.
Ghosh has drafted.
No
Must
notice.
come.
No notice has been annexed during when the electricity connection is taken, consent is taken from the
Very bad case.
from the landlord.
For interference in this writ petition, it's a very bad case. Maybe in your civil suit, you have got a much better case.
My lord, when he's
Actually, I'm telling you.
when he's taking, my lord, I'm what my submission is that
I
this, my lord,
gather, I understand your submission.
and my lord, the other formalities are to be complied with. CSC is saying verbally, but where is that notice? Where is the consent letter from the landlord? So in
It's not an RTI application. that they are required to produce the notice. Why should they?
My lord, when
They are not agreed. They are saying the CS formalities have been completed. They have been paid some way or the other. They have received the payment. They're admitting they received they have received the payment. So what is your difficulty?
what is his Lucas trying to, my lord, why he pay for shifting, my lord, he is merely a tenant of one shop room. The other tenants are not objecting, landlords are not concerned. He is saying that it is because it is on the eastern side of his tenancy portion, he is encroaching that.
You have a point there. I'll deal with that.
Madam, much for my satisfaction, my lord.
Don't satisfy yourself. Come. Learned counsel for the petitioner contends that the petitioner is one of the co-owners of the property, full stop, after demise of the husband of the petitioner, comma, who was the only male member of the family according to the petitioner, comma, taking advantage of the mourning period after such demise, comma, the private respondent number 6 and 7 applied before the CSC Limited for shifting of the electricity meter meter board position from its original location, comma, which was within an eatery owned by the petitioner, comma, to another location in the premises of the petitioner, comma, without any consent being given by the petitioner or any notice to the petitioner. Full stop, next para, it is further argued that such shifting is patently illegal and was without complying with all formalities, comma, including a prior notice being given to the petitioner, comma, who is one of the co-owners. Full stop, learned counsel further submits that the petitioner, that the private respondent number 6 and 7 claim their rights with regard to a new tenancy, comma, which has not yet.
Not 7, my lord, only not 6.
Only 6. Private respondent number 6 has right with regard to a new tenancy which was allegedly granted to the said respondent by some of the other co-owners. Full stop. However, comma, the same is not borne out by the records. Full stop. It is further submitted that a civil suit is pending at present at the behest of the petitioner, which has been filed for declaration and permanent injunction, comma, in which a status quo order is at present subsisting. Full stop. It is further argued that the private respondents, comma, in this manner, comma, have sought to encroach upon the other portions of the property than included in their tenancies. Full stop. Next para. Learned counsel appearing for the CSC Limited, comma, by placing reliance on the opposition filed by the CSC Limited, comma, categorically insists that the shifting was done in due process of law upon full formalities being complied with by the petitioner, by the private respondent number 6 or 7. By
Same, basically.
6,
and
6,
Same
6.
proposition.
by the private respondent number numbers 6 and 7.
No, my lord, it is,
Six, six, six.
no, my lord, it is recorded in their affidavit in opposition only by 6. Only by 6, not 7.
6, yes.
6.
6. भूले गए।
7 is one of the co-owners, so he is saying 7. He only by 6.
Why with the phone? I mean, 7 is the property firm whose proprietor is.
ওরা শেষ করে নি, বসুন, আপনি বসুন। Yes, what else?
No, I said that 7 is the firm and 6 is the proprietor of the.
Oh, is that so? I thought otherwise.
No.
Anything else?
Oh,
Please take your seat.
Status
Take
quo.
your seat. Behind you, there's a seat. Mr. Ghosh, you also have a seat behind. Mr. Ghosh, Ms. Ghosh, all of you, yes. Please take your seats. I'm feeling intimidated,
Yes, yes, my lord. Yes, my lord.
particularly by Mr. Ghosh. Please take your seat, Mr. Upon all formalities being complied with by the private respondent number 6, full stop. Next para. It is further submitted that the shifting was done solely keeping in view the insecurity of location of the meter board in its previous situation, comma, where it was placed inside an eatery and there were adjacent gas burners located in the same eatery. Full stop. Next para. Learned counsel appearing for the private respondent number 6 and 7 submits that respondent number 6 is the proprietor of respondent number 7 concerned. First up, the said respondents are tenants with regard to two different tenancies in respect of the property, comma, it is submitted. First up, it is further contended that some of the co-owners inducted the petitioner, inducted the private respondent number 6 and 7 in the said property, and the said private respondents, comma, for safety and security reasons, comma, in order to avoid electrical and fire hazards, comma, made the application for shifting, and the same was done in due process of law. Full stop, next para. What transpires from the submission of the parties and the materials on record is that a civil suit is at present pending before the competent civil court at the behest of the present petitioner. Full stop, in such suit, comma, an order of status quo is apparently subsisting. Full stop, next para. Be that as it may, comma, the rights and disputes between the private parties, comma, including the petitioner and the private respondents, comma, shall be undoubtedly decided in the civil suit, and it is beyond the domain of the present writ court to enter into the merits of such disputes. Full stop, yet, comma, the petitioner has made out a point in contending that the CSC Limited ought to have taken the consent of the petitioner as a co-owner, comma, while shifting the location of the electricity meters. Full stop, although the allegation of non-service of prior notice is disputed by the CSC Limited, comma, nothing has been placed before this court to indicate that any consent was given at any point of time by the petitioner. Full stop, next para. However, comma, within the contemplation of the Electricity Act 2003, comma, it is for the distribution licensee to ensure and take all safety and security measures for their apparatus. Full stop, since the distribution licensee, that is the CSC in the present case, comma, is the owner of the electricity apparatus installed at the premises and is the licensee in charge of the safety and security, comma, it is not fatal to the shifting for the CSC to do the same even suo motu, comma, if any electricity or fire hazard is anticipated or apprehended by the CSC Limited. Full stop, hence, comma, on merely on such ground of no consent of one of the co-owners being taken, comma, the said shifting itself cannot be vitiated, comma, particularly since the CSC Limited is of the specific technical opinion that it would be more hazardous if the meters were located in their original position than the present one. Full stop, next para. That apart, comma, it is the incumbent duty of the licensee to ensure that safety and security measures are maintained. Full stop, hence, comma, such apprehension on the part of the petitioner cannot be anticipated at this stage. Full stop, next para. Inasmuch as the allegation of encroachment made by the petitioner is concerned, comma, the same is a subject matter of the civil suit pending between the parties, and it would also be prejudging the said issues in this writ jurisdiction, comma, if any finding is rendered on the merits thereof. Full stop. Hence, comma, there is no scope of interference in the present writ petition. Full stop. However, comma, it is made clear that all points are kept open to be argued and decided by the civil court, comma, including the allegation of encroachment by the private respondent number 6 and 7 and the private respondent's objection thereto. Full stop. WP 822328 of 2022 is disposed of accordingly in the light of the above observations. Better luck in the civil suit. Thank you. Next one.
Correction, take a correction.
যেটা হলো তো সেটা কম্পিউটার ফর্মে কি লেখা আছে? না না, এটা এটা এর উপর ওরা একটা লিখে দেয় যে ওরা একটা কম্পিউটার ফর্মের উপর নাম্বার লিখে দেয়। কম্পিউটার ফর্মটা কি? এই তো এইটাই 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 এইটা টুটুই হবে। সে তো হয়ে গেছে। হুইচ আইটেম এটা? কোন আইটেম?
8 number.
Item 8, Mr. Haldar, you are there. 8222 has been written everywhere.
Yes, it is also showing in the CIS 8222.
Everywhere except in the writ petition itself. On the writ petition, it's written 8225. Dispose of হয়ে গেছে?
Dispose of.
What? Yes, leave it.
Great.
Yes, colonel.
32.
I am for the CSC.
Yes.
Well, on last occasion,
yes,
the previous report filed by the CSC, which I thought was not correct, was
yes, right.
Lordship desire was to make.
Even fairness was also recorded probably.
Lord, I appear for the private respondents.
The new report.
For a change and
yes.
Well, the new report I have given to the writ petitioner and the private respondent.
What does the report say? What is the crux of the dispute?
Can be done.
Can be given.
Well, I have taken an exception to the report.
Achha.
We have not been served as of
Yes,
now.
it was just prepared. May I?
Was any liberty given? Then otherwise I'll give you liberty and take it on record.
Well, Lord, since it was Lordship directed for a advance
Copy to-
circulation, so we
Very well, circulate the copies of the exception, then I'll take it up whenever. When should I take it up, Mr. Das and Mr.
Well,
Banerjee?
anytime, any Lordship.
Tomorrow?
Yes, yes.
Tomorrow.
well, Lord, instead of tomorrow, can it be next week?
Next week, which date? Tell me.
Well,
Give me a
Monday.
date, all of you.
Monday itself.
Monday.
Any day 7 except 26th.
Can it be on Somangalu?
Acha.
Can it be
Tomorrow
on-
goes,
Well,
26th goes.
Well,
What
any day 7
other
except
date remains?
26th. Any day.
So,
You, any exception date?
25th, not on 25th.
so 27th.
26th. You?
My Lord fixes a
Happening
date.
with the
This
record.
is too much. This is too much, my Lord.
Why
fixes
too
up
much?
any date.
25th, 26th are excluded
No, 27, no one has any difficulty.
till now. Till now, unless I fix the date.
Yes.
As soon as I fix the date, there will be the difficulty. Very well. An exception filed to the report of the CSC Limited submitted by respondent number 6, 7 and 8, comma, be kept on record, full stop. Copies thereof are circulated amongst the learned advocates for the other parties.
We haven't got a copy.
He will give right now. Full stop. The matter is adjourned on the prayer of learned counsel to enable learned counsel to take appropriate instructions on such exception and the report. Full stop. Let the matter stand adjourned and shall next be listed on April 27, 2023. আরেকটা লাইন অ্যাড করে the exception filed today be kept on record. The report and the exception filed today be kept on record.
Thirty-three.
33, Lordship, I appear for the respondent.
My Lord, I am
distribution
for the-
company.
My lord, I am for the
Matter-
petitioner, Mr.
My lord,
Parthasar.
my lord, may I submit, Lordship?
My lord, I am
Before
paying
my
for
lordship,
accommodation.
my lord, may I
For
submit?
accommodation for this week.
matter, Distribution company is suffering a lot. There was a direction for filing affidavits. Accordingly, we filed our affidavit. Thereafter, filed our supplementary affidavit. On the last occasion, my lord directed to intimate them. We have also intimated them. Till today, they have not used any affidavit. My lord, challenging the policy decision of the ACDCL, they have filed the writ petition. There was
Policy decision of ACDCL.
there was a interim relief given to them, Lordship. But till today,
What relief was given?
my lord, kindly see the first order. That's it.
Give me the date of that order just.
The first order, Lordship.
Easier
It's
to
not-
refer.
Yes.
There are several order
Yes,
sheets. I mean,
Lordship, but
the date of the order, what interim order?
my lord, the very second.
Very first,
I can't.
without any date.
No, Lordship.
12th December.
12th December. Order of 12th December, Lordship, kindly see.
My lord, I am not in
My
this
lord,
matter.
there was
I
direction
I have
to
been,
deliver
I have
to
been
use
requested.
Appearing in this matter.
My lord, I have been requested by Mr. Clerk of Mr. Parthasarathi Devbarma. He is not in town, my lord. I'm paying accommodation for this week only.
My lord, they are not using any
Not
evidence.
in this matter, my lord, I have been
Specific
requested.
direction. Kindly see. On the last occasion, I have intimated them by giving a letter. They are not using it. On the next day, they will come again. They
What
will
was the office order amounting to? I mean, which office order was stated? State
Yes, yes.
dated July 28th. What is that office order? What are you restrained from doing? You're vehemently arguing, Mr. Chaudhary, you are
No,
suffering. Why are you suffering? Tell me what is that office order? Why you are suffering? The WBSCDCL is suffering so much. Yes, Mr. Panja?
Yes.
Milord, in this policy decision,
What is the policy decision? July 28th, it
I'm
was
coming.
state.
I'm coming. The policy decision for the benefit of the people. So
Of the people, for the people, by the people.
no, no.
But what
I'm
is the policy decision?
policy decision to save the people from electrocution?
From WBSCDCL?
Yes.
Save the people from WBSCDCL?
People of the state from the they are the contractor. They are not with the following the principle laid down by us as a
Oh, this is that gear safety equipment being given to the.
yes.
Yes.
Yes. Why for that time?
My lord, I am not in this matter. I have been requested by the.
Why are you not in this matter?
My lord,
Why are you praying for time then?
My lord, Mr. Clerk of
Page
Mr.
56.
My
lord.
my lord, the
No,
clerk of
this
Mr.
concerns the interest. He is absolutely correct.
My lord, kindly bear.
I
me
should
for-
not have
My lord, kindly
cut
bear
a
me
joke
for a
on
mo-
this.
My lord,
This is very serious. No.
My lord, kindly bear me for a moment, my lord. My lord, he is not in town, my lord. Mr. Parthasarthi Dev Barma.
What can be done?
My lord,
Food
I'm
cannot
paying,
wait for no.
my lord, I'm paying for a accommodation for this day only, my lord. My lord,
Tomorrow he'll be coming.
my lord is not inclined to give accommodation for this week, my
Your
lord.
prayer is suited to my inclination.
No, my lord, my lord is. My
If he
lord,
does not come back tomorrow, what is the fun of adjourning it for
My lord,
two?
I am not in this matter. I shall request the advocate on record to come before your lordship tomorrow, my lord. Thereafter, I am not in this matter, my lord. His clerk requested me to refer accommodation for this week only, my lord. That is my request, my lord.
Would your lordship kindly take the trouble to come page?
Mr.
56?
Panja, what should I do? I mean,
Yeah, I know.
I'll record your objection and refuse the adjournment prayer, and I'll proceed with the matter.
As well.
I'm recording your submission. Yes. At the outset, an adjournment is sought for a week on behalf of the petitioner on the ground that learned counsel for the petitioner is out of town. However, learned counsel for the WPACTCL vehemently oppose such prayer for adjournment, particularly on the ground that the impugned office order pertains to security of the personnel who are engaged in electrical work. Full stop. Next para. It is further contended by the WPACTCL that in view of the subsistence of the interim order obtained by the petitioner in the matter on December 12, 2022, the the office order in question cannot be given effect to, which is causing severe prejudice to the people at large as well as the WPACTCL. First up, since such objection is taken by the WPACTCL, the prayer for adjournment is refused. First up, the matter is taken up for hearing.
Madam, one kind indulgence, madam, if it can be taken up tomorrow, the affidavit in reply can be given. That is the only.
I'll give you 5 minutes time. I'll come back in 5 minutes. Get ready in the matter. Do the matter.
I'm for the petition, man. I'm sorry, man.
What is your case?
Man. I will kindly be with me for a moment, man. My lord will kindly come to page 44, my lord. It's an office order, my lord. This is not very legible, my lord. That is the
In my copy, it's very legible.
my lord.
Copy is very legible.
My lord.
Actually legible. I mean, indemnity bond. Page 44.
My lord, my lord.
Yes.
My lord, I have challenged this and I have challenged another notification which is at page 56. My lord.
You are the advocate on record in this matter.
My lord, I am not the advocate on record.
Who are you?
My lord, I'm being engaged in the matter, but I'm not
Engaged
the-
right now.
My lord, a few days back, but my lord, it was
You are usually prepared in your matters.
at least. And that is why I was humbly praying if it can be taken up tomorrow. That is the only.
Sir, Paja, you move their case on their behalf and answer them.
Might will kindly not do.
No, I've already refused.
Might will.
I've already refused adjournment. No question of further contracting back on that. Yes, Mr. Paja, what is their case and what is your reply to that?
Yes, my lord.
If I can give a reply to them at least. At least that is my only humble submission because I'm today I'm.
Mr. Paja, valiant effort. You must appreciate that. Valiant effort.
Very embarrassing. My lord, only thing my lord, I'm
What
saying-
is their case actually? What is the matter about?
My lord, they are,
Please take your seat, Beth. Yes.
my lord, in one word, if you lordship kindly peruse once page 56.
Mr. Paja, please use the microphone. Yes.
Yes.
Microphone.
Oh.
Yes. Page 56.
56 only. Page 56, first 2-3 lines, my lord, that will purpose. Serve the purpose. 56. Annexure is P11, my lord. Annexure.
I don't know the annexure number. Page
Huh?
56 I have opened.
Page 56 is
Office
P11.
order number P by 71.
P is missing in my copy.
My goodness.
The entire P is missing. P 1 to 11 probably missing. Anyway, page 56.
My lord, dated 28 July 2022.
That is undated. Now I must be on some other wrong copy. I mean, there are so many readings. Let me come. My mistake. Was looking at the wrong pleading.
May I place it if my lord deems fit? May I
No,
please?
alternatively, he will place one line, you will place another line.
And
Yes,
it will-
Mr. Paja.
May I read, my lord? Only
First
two-
paragraph you will place, then he will place, then I'll like this. I'll
My lord will.
That's an
I
interesting
was-
proposition. I mean, new method. Let us try that out. Yes, Mr. Paja, the first paragraph, your turn.
The recent, my lord, subject, administrative action against contractors in case of any fatal work accident. My lord, the recent incidents of electrical accidents have become a great cause of concern to the company management and other stakeholders. Besides the accidents involving general public, many cases of work accidents are happening involving the contract laborers, which they are, my lord. Contract laborers of various agencies, contractors of WBSC. PCL. Well, this is their whole, Miller, the case that they are stopping now, and they have been able to stop that. Now, Miller, there are so many. Oh, yes, come.
Sir, Deborman, you were out of station a few
No.
minutes back. That was
I
submitted on your behalf.
From Saturday in midnight,
It was submitted actually by somebody.
Yes.
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 No, I was not here. My lord,
It was submitted categorically. Time was
tender-
short. I have refused time on that ground.
Unconditional apology, Lordship.
Mr. Deborman, you're junior. Where is that person? Please call him.
কে কে বলেছে তাকে দেখো
Please call him.
তাকে তাকে আমি যেটা বলছি সেটা শুনবে তুই যা বলছিস সেটা আমি শুনবো না
They were not expected from your chamber.
Yes, this is not my chambers. That's the problem.
And you
I
can
am told that it was
vehemently opposed.
adjournment was short for on the ground. I am not here.
You are out of station.
Out of station.
That language is used. I quoted that in my.
Yesterday I returned back. From Saturday I was out of station. That definitely.
That is already a part of the order. I have dictated a part of the order. I refused adjournment and started taking up the matter on merits. After giving a learned friend who was very valiant in his efforts 5 minutes to get prepared. Mr. Debarma, please move your matter anyway. Let us.
Lordship. Malad, our case is that we are the supplier of person. Now, Malad, there are so I will show to your lordship from the annexures. There are so many obligations of my clients.
This is that PPE
Yes,
kit
yes,
matter.
yes, yes.
You say it's not your liability. You're
No,
trying
no,
to
my liability, lot
up
of
to an
liabilities
extent.
are there.
Yes, not this
I
part.
am just distinguishing up to what stage.
Yes, yes, absolutely. Right.
I will show to your lordship from their different orders that the liabilities to keep equipments, that PPE kit, all are our liabilities. Liability to maintain the required standard of superintendence up to reaching the spot, my liability. But when our person will reach to the spot, it is their specific case. No work can be done without the supervision of their officers, and only their officers are liable for any shortfall of the work. Accident is far for any other. Now, a question involved here that I will show to your lordship, there was a decision of the board itself that in spite of our different resolution, the steps are not being taken for minimizing the
Risk factor.
accident and risk facts. That's why they are issuing a circular. Overruling that circular, only the two officers, personnel department, I believe, the director personnel or assistant director personnel and other officers, they are going on issuing the directions that none from, because liability to compensate for any accident, loss of life is accepted by them. Now they are trying to shift the liability to the contractor, my clients, who are supplying the labors. That this is the decision of two officers. But Malad, I will show to your lordship, Malad, when Malad, this problem was going on for few years, there was some agitation on behalf of the Malad supplier of the Malad staffs. Now, Malad, there was a bipartite meeting, bipartite decision that we are constituting a special committee. Unless the report comes from, nothing will be happening. In spite of that, without having any report till date, 2 or 3 meetings were held, no Malad effective result till date. Malad, they are imposing Malad penalties upon my clients for the accident occurred out of the electrification. But with that grievance, we approach your lordship. I have at this stage of the motion hearing, I have satisfied your lordship that this is not our responsibility and there is no statutory provision empowering them to realize the compensation from my clients. Rather, there is a insurance policy coverage. They are getting the amount reimbursed from that insurance. What they are paying to the parties affected, they are getting the reimbursement of that amount.
Is there any provision in the contract, Mr. Debarman, regarding this?
Well, then I am not getting any contract. Only the office orders we are accepting. I have not, that can be disclosed. Even their opposition, they have not disclosed any contract. So we are proceeding, accepting that there is no contact between my clients and the SCB. But ACB's orders, one by one, I'm showing to your lordship. Lordship, kindly. ওই যেটা সাপ্লি করছে মানে problem is that in the writ petition with your they annex the relevant some portion. That's why with your lordship leave, I have prepared that মানে disclosing the মানে এটা কি কোনটা
এটা ওদের সব
হ্যাঁ আমাদেরটা কথা যেটা আমরা সব ডকুমেন্ট দিলাম না না দিয়েছি রেডি হওনি এই কপিটা এটা লিখটা Lordship, kindly come to it. Page number মিলবে তো তোমাদের সঙ্গে first one page 27
The writ petition.
writ petition
মানে এটা
R1
R1 এটা ওদের সব
R1 টা ওদের আমাদের writ petition sorry Mala, that is there in that is also in my writ petition 24 টা First one, Lordship, kindly come to page 38. This is number 24. There are two. One is for higher power and one is for the lower power. High tension, no? High tension and low tension. This is dated 28 April 2030.
2000 what? It is not clear from the.
It's not clear from that. ওদের কপিতে দেখো দেয়া আছে 14টা পড়া। ওদের 17 দেখো না 27 This is 2013 because of Lordship kindly they come to page 39, 40. This is the office order number 25, dated 17th May 2013. The subject is device rate contract for engagement of mobile van with driver fitted with tools and mobile phone of outside agencies for the service of LTVs for low tension consumers. And what I was going to show you to Lordship from page 38, that is for the HTVs high tension.
Yes.
33 above. Now, I'm showing to Lordship from 38, the clauses.
Yes, Mr. Panja, this is 2013.
Milord, I have annexed all
Your
the
document.
all the
What is the year?
Yes, Milord, it is 17th May 2013.
That is page 40.
Office order number 24.
No, page 38. Page 38. What is the date? What is the year? It's your circular. Your office order rather. Office order number 176. What is the date? Full date. Anyway, Mr. Deborn, let us proceed with the office as you were placing. Yes.
Page 40, I'm placing that 17th May. Same, it is high tension, it is low tension.
No, you can place 38.
38.
Yes. This is high tension. Your present dispute regarding? Yes. So let us see 38.
Lordship, kindly come to the bottom. 12, this is 1.2.2. The repair and maintenance in respect of the above job shall not include theft of.
It's illegible, the last portions.
No, I have given a fresh copy to your Lordship. This was the child.
If it is office order number 24,
yes.
If it is my land fair spelling, then Milord, this is very clear with the copy of annexed.
No, this is office order number 176.
Page 27 of my office.
Office order number 176 he is placing, not 24.
176.
No, 24, 175, 76 is, I will show later on. 24, Lordship, I prepare a.
Mr. Deborn, come back tomorrow. You go through the records once. Ask him to go through the records, tally the documents, come back.
I have prepared those.
Tomorrow you will be in station.
I have to.
Learned at the juncture when the matter is substantially heard, it transpires that certain documents are apparently illegible. Full stop, next para. Hence, learned counsel for the parties are requested to supply legible documents. First of the matter shall be taken up for hearing tomorrow. First. Please ask your learned junior to check the person who said that you are out of station. Ask him to go through the records and check up whether Mr. Debarman, whether the documents.
I'll do at my home. Get full to loss, but I'm sorry, really.
No, it's all right. Yes. Come back tomorrow, Mr. Pajay. In this way, the other matters will suffer unnecessarily.
Yes.
Will not reach anywhere. Will not reach anywhere. Call on the next matter.
And only thing, my lord,
Tomorrow I'll hear you at length.
No, I'm just one sentence I will use. All the office orders my learned friend is supposed to annex. Yes. I have annexed all those office orders in my office.
Except 176.
No, it is also there.
Place that when I come, we can come back tomorrow.
As well as.
Yes. Thank you. Call. আগেরটা হাফ আছে মেঘনাদের কাছে হাফ তোমার কাছে ওটা নিয়ে লিখে তারপর এটা অ্যাড হবে ওখানে লিখেছে যে রিফিউজ করেছে সেই জন্য তারপর এটা লিখে একটা অর্ডার হবে
34 to 36.
These relates to the DPS matters.
Again DVC.
Yes, sir. These relates to DPS matter. We are filing our opposition matter. The matters can be adjourned till the appeal is heard or the appeal. Till the appeal is heard.
Use the mic. Use the mic. I want to keep it on record.
The appeal is fixed sometime in June, my lord. 26 June, my lord. Any day, my lord can either adjourn it, my lord, sanitize with liberty to mention.
Han is appearing in this matter.
On that matter, today, my lord, there's a direction for restoration of electricity. Areas have been stayed.
By
division bench. But that was challenged. DVC had challenged. But we had challenged the dismissal of multi-year, single year, and DVC had challenged that disconnection notices. My lord had quashed those. Then both the appeals, areas have been stayed, and in that case, Mr. Saini's client has been asked to restore. DVC
So he is not here.
That matter is different.
20. When should I keep it?
In the monthly list of July, or my lord can adjourn it till the appeal is disposed of with liberty to mention, my lord. Anyway, my lord.
Adjourn, I may die.
Sign it.
I may die.
On the prayer of learned counsel for the parties, comma, in view of pendency of an appeal from a connected issue, comma, the writ petitions are adjourned sine die with liberty to the parties to mention for inclusion in the list after the appeal is after the said appeals are decided. Full stop. The matters may go out of list for the present, subject to the liberty given above. The appeal numbers. Do you have the appeal numbers? Several appeals.
One of the appeals, my lord, I'll mark to 207.
Item number.
No, I need not.
I'll indicate one of the appeals, my lord, MAC 207 of
2022. Including MAT
207 of 2022. 22, my lord.
207 of 2022. Including MAT মানে হচ্ছে appeal গুলো
20.
Yes, call on that.
February 22.
Appeal affidavits হয়েছে ওটা বলতো
My lord, affidavits.
Affidavit একটা line after the affidavits in only one matter.
Opposition, my lord, and reply.
Opposition reply, 3 matters.
All the 3.
Affidavits in opposition and reply filed in all the matters today be kept on record.
Deeply.
37.
Lordship, I am appealing on behalf of private.
Like to appeal for the petitioner.
Right.
For the CESC.
Right. Please take your seats, both of you. I'll hear Mr. Jha. Take your seats. Yes.
Lordship, prior to initiation of arguments, Lordship, I want to file a supplementary affidavit, Lordship.
That has not
given
been served
copies to
upon.
Yes, I'm just serving them right now.
What for? I mean, regarding
Lordship, this is very
Opposition and reply have already
been
filed.
exchanged, Lordship. The thing is that, Lordship, the first annexure P1 of the writ petition is the enlistment certificate. The KMC, I went before the KMC seeking an RTI application and seeking for the documents on the basis of which the enlistment certificate was issued. Subsequently, I was handed over the documents which were submitted by the petitioner, on the basis of which the enlistment certificate was issued. Lordship, it has been strangely found that the rent receipt which has been submitted before the KMC authorities has been issued by a deceased person.
All these points will be
They're not there in
extraneous.
the meetings, nothing.
Lordship, this is a very subsequent event, Lordship. This has been recently found. Lordship will find the date also in the supplementary affidavit, that is on 27th March. Immediately upon finding, I have,
What is the bearing of that fact on this issue?
because they are claiming that they are the lawful tenants, and
That,
we,
that rent receipt. No,
Yes.
that question can
Even if I am a trespasser.
So what is the subject matter of dispute here? I mean,
dispute is they are seeking for a connection. Pardon me.
yes, so we cannot decide on the veracity of that.
My lord.
We'll only go on prima facie things.
Yes,
In
Lord.
electricity matter, what else can we do?
Yes,
This is not German. This is not a civil suit.
Lordship, I bowed
At
on
this
before.
stage, probably not. No.
I bowed on before Lordship, but the very basic document on the basis of which they are seeking for the electricity connection, that is annexure P1 of the writ petition, that is a fraud document that is obtained by forgery, Lordship.
At this stage. I can record your objection to that on this score that it's a fraudulent document. I'll record that, but I cannot go into the merits of that inquiry.
The
So in any
veracity
event,
of that
by
document
perusal
cannot
of
be
that,
ascertained.
whatever you are submitting, that won't help you. I cannot decide whether it's a fraudulent document or not without a proper inquiry, without evidence.
Lordship, this is an RTI document. There is an endorsement of the and of the
RTI
case.
document per se may not be, I mean, anyway, let us not go into that. No, not at this stage. Moving on.
My lord. Well, the petitioner had made an application.
Yes.
For a new connection, my lord. On 10th of October 2022, my lord.
Yes.
Pursuant to which the CSC authorities, they wanted an inspection of the room where the meter has to be installed. Now, in view of the fact that the meter board is in the possession of the private respondent, it could not be opened. There was resistance from them. And the CSC authority, they could not come up.
You claim to be a tenant in respect of
I claim
private
to be a
respondent as the landlords.
They are the landlords. They have said that we are not in occupation, and that was the main crux of the entire issue.
Yes, yes.
Now, my lord, in the writ petition, I had annexed the enlistment, the trade license, which was issued in favor of the petitioner, as well as one of the receipts, the rent receipt, which was issued by the private respondent, my lord. Now, in the opposition, which was filed by my learned friend, they have come up with a number of issues where they have stated that a civil suit is pending. They have got an injunction in the civil suit, and that is against the Roys, some Roys. Now, way back in 68, the picture of Roys were off. The Bargs had entered into the partnership at some point of time. Rather, the partnership dissolved. The firm was dissolved. One of the Bargs, he became the proprietor. Subsequently, once again, a partnership was constituted, and these Bargs have all throughout since 68 been in possession and occupation of this particular premises, which will be established from the various annexures which I have put in my reply. I'll take your lordship first to my reply. The lordship will come.
Then the possession is disputed.
That was disputed. They blatantly denied that Bargs were no one. It were the Roys who were the partners. Tenancy was given to the Roys. And
then why not give them an opportunity? They have obtained a document subsequently.
But
I mean,
even
if they dispute the very basis of that possession,
what is falling from your lordship, I bow down to that. But that document is not germane to adjudication of this particular list, my lord.
Say that because the possession is denied, you are saying.
Well, all the documents that I have annexed.
Other documents are there.
The government documents are there, where I have received documents in the name of Barg. Your lordship kindly peruse that, my lord.
Yes.
My lord may come to page.
So you'll have to make out your case independent of the rent receipt also.
My lord.
At least for prima facie purpose.
My lord. My lord may come to page 9. The document might not be very legible because the one that I had received was not legible, but I can read it out for your lordship. Page 9 of the reply, my lord, filed by myself. Page 9, annexure P5.
Yes, 9.
My lord will find at the bottom of the page, it dates to 3/7/1968.
Right.
Well, this has been issued by the Office of the Assistant Commissioner of Commercial Taxes, and this is issued in the favor of R.N. Roy and Company. And in the next line, your lordship will find that the proprietor is Shutish Chandra Bagh. So from 1968, Bagh is in possession of this particular premises. Your address is also mentioned, 211 Acharya Prafulla Chandra Road.
What is this Bagh Roy conundrum?
The thing is that petitioner is one Tulsi Das Bagh, who is the proprietor of this particular,
Bagh is proprietor of Roy and Company.
Bagh is one of the partners of the petitioner firm. Now,
Yes.
what was contended by the private respondent was that they don't know Baghs. Baghs are not in possession. It were the Roys.
Yes.
The next year, your lordship will come. This is at page 10. It's also a letter issued by the Assistant Commissioner of Commercial Taxes, my lord. It dates back to 70, where also Bagh, Satish Kumar Bagh, Satish Chandra Bagh's name is there, my lord. Thereafter, the next page, page 11. This is a license issued by the West Bengal Baby Food Licensing Order, 1966. It was issued in the year, lordship will come to the
address is this, 211 APC.
211 APC Road. At the bottom of the page, your lordship will find the date was 81. And the last renewal, what I find is at the top of the page, just behind the, below the serial number, it's 1993. It has been renewed from time to time. And names, your lordship will find Messrs. R.N. Roy and Company and Shopun Kumar Bagh, Topun Kumar Bagh, Guru Das Bagh, Tulsi Das Bagh, they are the partners. So subsequently, perhaps that partnership, the proprietorship was converted into a partnership and they had become partners and they were running business from this particular premises.
They have the deeds, partnership deeds also.
Recently, the two of the persons, Tulsi Das Bagh and one of the partners, they reconstituted the firm and a new partnership was entered into by them. A deed was prepared that is annexed to my reply. But these partnership of these document of the firm of 1981, I don't have a document of that. Thereafter, your lordship will find at page 12. This is the license issued by the Office of the Commissioner of Police. This is a police license, my lord. It was issued in favor of Krishanu Bagh, and that was issued in the year 2016. And all throughout, I have been in possession. It is not that that I am not in occupation of that particular premises. And one of the contentions which was raised by the private respondent was that an electric meter was disconnected. Your lordship will come to the next page, that is page 13. My lord, I had cleared the dues in 2016-15 when it came to my knowledge that the electric meter has been disconnected. I paid the entire amount which was due.
Meter was in the name of the firm.
It was in the name of firm. So she R.N. Roy. It was in the name of R.N. Roy.
R.N. Roy.
R.N. Roy. So 5,484 amount was paid by me. I even made an application for reconnection, but the situation was such that no access was given and it was just lying like that. But the thing is that the property, I mean, the shop room has all throughout been in my occupation and possession, and that has not been denied by them at any point of time.
Did you assert it? What is the scope of their denying?
Well, from the opposition that they have filed, I do not find anywhere that they have said that I'm not in occupation of that particular premises. And my lord, considering the fact that they have disputed my possession, and I am in possession as has been disclosed with all the documents since 1968, I don't find that the objection which my learned friends are posing for installation of a new meter should stand in the way.
Very well. Let me hear them then.
My lord.
Yes.
Lordship, first of all, the affidavit in reply, the documents are completely illegible. I asked them to give a fresh copy. Subsequently, I asked them to give me a inspection of the documents because what they have annexed, I found that the copy was of the rent receipt has been forged. So I cannot rely. These documents also can be forged, but till date it has not been given to me. Lordship, at the very beginning, I'll state that there is a title suit pending in regard to this dispute in regard to the possession of the,
Have you annexed the plaint or anything?
yes, yes, Lordship, in the
Your
opposition. Yes, yes, in the opposition, Lordship is there. The actual Lordship, I'm being led by Mr. Shin.
Oh. Yes, Mr. Shin. Start from after refusal of the supplementary affidavit.
Okay, বলা হয়ে গেছে?
Today or tomorrow?
Good.
Today or tomorrow, Mr. Shin?
Tomorrow.
Come back.
I'm very sorry, Lord.
Your expression is priceless, actually.
তবে তো সুবিধা।
Well, can it be day after tomorrow, my lord?
Unless Mr. Shin has.
No, no,
No, no, actually, I mean, very well, day after tomorrow. What will be the excuse for that? After commencement of hearing, it transpires that certain documents in the copy of the reply served on the petitioner are alleged to be illegible. Full stop. Learned counsel for the parties are requested to peruse the originals of the documents annexed to their respective copies. In the meantime, full stop, let them attest and adjourn till day after tomorrow. Mr. Jha, whatever, I mean,
I'll try to gather those copies, my lord.
The supplementary affidavit your lordship has taken on record.
No.
No. Or at a refusal to record. Not at this stage.
Lord, this came about on the basis of Lord the disclosure made in their affidavit.
Mr. Shen, what they are saying is that you are disputing the, you are saying that one of the rent receipts is fraudulent, which they have produced. Now, nothing hinges on only that. There are other documents they are saying which will also clinch their case, prima facie case of possession.
Lord, when I show your lordship the supplementary affidavit, your lordship is not satisfied with the relevance, lordship will disregard it. But not it arises out of disclosures made in their affidavit in reply. In their affidavit in reply, they have annexed a rent receipt.
Yes.
And they have annexed, Lord, I'm sorry, a partnership deed. They've annexed a partnership deed.
Yes.
Lord, we made inquiries with the Lord corporation on the basis from which it appeared that they had obtained Lord the certificate of enlistment by showing this partnership deed and a certificate, a death certificate of a gentleman who has died many years ago.
That is not germane to the adjudication of this, my lord.
It is genuine because I am the propounder of the will of that person.
Even if I am in wrongful possession of that particular premises, can an installation of a new meter be installed, my lord? I put a question to myself.
Day after tomorrow, Mr. Shen, try to satisfy me on that.
My lord.
But when my turn comes, I'll show you a lot.
Copy has been given to you.
Yes, yes, long
the copy. You also satisfy yourself whether on what grounds you will be opposing.
My lord.
Well, come back. I'm not recording anything, refusal or otherwise.
কি রেকর্ড আরে দিয়েছো তো আবার রেকর্ড কি করবে আছে তো
What opposition supplementary you have filed?
Yes, Lordship, it is.
No, give it back.
Oh, you lordship is not taking it.
I was going to refuse. I have not refused now.
আচ্ছা
You will have to satisfy me on whether I should take it on record at all.
Let it be on the record.
No,
you need not record it when I make submissions on it. If your lordship
keep it with you.
But let the copy be with my learned friend so that he may go through.
I am that.
So he may go through.
I'll go through that.
Give a receipt also, Mr. Judge.
I'll.
On usual terms, as they say in the original side.
Usual terms is very tricky.
Then folio has to be taken and payment has to be made as per folio. Lord, it is difficult to be found, Lord.
He's saying it has not been given.
No, I have handed over, right?
It is deemed to have been filed.
No, I can't.
Oh, it এখানে থেকে গেছে।
Call on the next matter.
I'm sorry, but comedy of errors.
I apologize.
No, it's not.
38.
38 who is appealing for it?
For the petitioner.
Yes, Mr. Vaidya. What is it?
Earlier occasion, my lord, your lordship has directed us to serve the copy to the my lord, state respondent. We have already served, my lord. My lord, that is the matter, my lord, of where my lord WBSCDCL my lord stated that the suite certificate is needed.
Yes, yes.
And they have my lord shown a notification, my lord. We have not found the notification, and also your lordship directed them to affirm an affidavit annexing that notification. That has not been done, my lord. My contention is that suite certificate is not needed because it is not the semi-critical area, and I am entitled to get the my lord, the electric connection for my submersible pump.
My lord, I was directed to file an affidavit showing that there was a gazette notification. I am told that no such gazette notification is in place, and I have to make my submissions on that. My lord, I have.
So you cannot insist on suite certificate if there is no gazette notification. It has to be shown as a critical or semi-critical area for you to insist on suite certificate.
My
That's
lord,
the only criterion, Mr. Das. If there is no gazette notification, then
And also, my lord, in my reply, my lord, I have shown that some other 4 persons, my lord, they have given my lord the electric connection without suite certificate, and also within the my lord the.
then I'll allow his application, Mr. Das.
my lord,
Learned counsel for the petitioner submits that the WBSCDCL is insisting upon production of a SWID certificate for giving new electricity connection to the petitioner for the purpose of operating the petitioner's pump. Full stop, next para. It is seen from the records as well as learned from the submission of the parties that previously an opportunity was given to the for this WBSCD to the respondents to the WBSCDCL to produce a copy of the gazette notification indicating that the zone in question is a critical stroke semi-critical zone. Full stop, next para. However, comma, learned counsel for the WBSCDCL submits today that no gazette notification in that regard has been traced out. Full stop, as such, comma, as the position remains as of today, comma, there is no gazette notification produced on behalf of the WBSCDCL to insist upon a suite certificate on the assertion that the area for which the petitioner seeks electricity connection is either a critical or a semi-critical zone. Full stop, next para. Hence, comma, such insistence of the WBSCDCL is misplaced. Full stop, accordingly, WPA 26938 of 2022 is allowed, comma, thereby directing the WBSCDCL to give a new electricity connection to the petitioner as per the petitioner's application, subject to compliance of all other formalities apart from the production of a suite certificate. Full stop, such connection shall be given within a fortnight from the date of compliance of such formalities or this date, comma, whichever is later. Not as to state, you are to actually disclose whether it's a critical. It's your responsibility, Mr. Mukherjee. State's responsibility. Why not?
Nowadays, in some area, the area which is saying suite certificate is not required because now WBC distribution company. I was.
No, if you do it indiscriminately, then Mr. Mukherjee, the difficulties there are other difficulties regarding pollution and water level also. We have to take care of that also. So, but you have to produce this. You have to be ready on these.
39.
But I appear on behalf of the CSC.
Right.
For the response number 3.
Yes.
Written
undertakings are
on
already
behalf of the petitioner's lordship.
written undertakings are
given undertaking.
Lordship. See,
still some defect.
Lordship, I don't know whether I'm right or wrong, but I want to clarify one point here, Lordship. Lordship, page 2 of the undertakings, 3 to.
You have filed it already?
Yes.
Yes, I have filed.
Undertaking the counter.
I don't know.
That's undertaking. Help.
4th April 2023.
What was the undertaking? I've forgotten the subject matter actually. What was their prayer?
Through
The writ petition?
To access the meter room. Of the
that.
Yes.
we will give prior notice or we will give an SMS.
Yes, that is acceptable. We have given us.
Yes,
Undertakings are dated 4th April.
In several matters today, people are saying that they have filed
4th
documents.
April 2020.
After it is not traced out, they are saying that it's with
आगे
them.
होगा, आगे
So
होगा,
please
आगे।
check up.
4th April आ जाए बेटा। 4th April आ जाए।
Page 2 undertaking,
There.
good. Page 2,
Yes, Lordship.
yes.
Lordship,
Respondent number 4 or 8,
Lordship, this is from
identical must be.
3 to 7.
Same.
3 to 7 and respondent number 8, Mr. Bani Brato Tat is appearing. That's right. Right.
Page. The 5, 6. সাজানো নেই গো। 7 you are, I'm looking into, yes. Page 2.
Page 2, yes, Lordship. Lordship, page 2,
Hmm.
I certify all the annexures are legible. As such, there are no annexure. Maybe my learned friend has not signed in the lower portion. The upper portion he has signed, Mr. Tulsidas Roy. So I don't know whether he has to sign here or not. But this I feel,
Who has to sign? Where? This is the original
yes.
filed in court.
Yes, and-
Hey, এটা দাও।
There are two signatures.
Please check up from here.
Yes,
Yes.
please, yes.
If it is there in this original,
No, it's not there in this.
When we kindly see, there are two signatures
Lordship,
where
I'm
the advocate has to put. One
prepared
is
in my
prepared
office.
in my office,
Yes.
advocate and
oh,
subsequently I.
annexures are legible.
All annexure, there is no annexure.
Might
Yes,
kindly
yes.
see the affidavit given by the respondent
Respondent
number
number
8.
8, yes. Yes. Respondent number 8 has signed, Lordship.
He signed, that's what.
Yes.
There is no annexure.
হ্যাঁ, ওখানে সই করেছে, ওই জন্যই আমরা
What,
বলছি।
what prevented advocate?
This is a
to
very,
sign?
very interesting question of law. I'll refer it to the larger bench. Come on, there is no
Lordship,
annexure.
I don't have
Because-
any objection with. That's okay, Lordship. That's up to your Lordship. That's fine. Lordship.
So I'll dispose of the writ petition
Yes,
in terms of
Lordship.
the
Yes,
undertaking.
Lordship. Yes. Lordship.
Next para. Sorry, take down. It is submitted by learned counsel for the petitioner that the second required signature in the undertakings filed are missing in 3 of the undertakings filed in court. Full stop.
Not 3 to
3
7.
to 7, my
3 to
respondent
7,
3 to
Lordship.
7.
In one it is there.
No,
No.
only for respondent number 8 has done that.
7. So 4.
5, 3, 4, 5, 6,
3,
7.
4,
5,
5,
6,
Lordship.
7. 5.
Yes.
3 ko badale 5 kore daw. 5 of the undertakings. Full stop. Next para. However, comma, it is seen that the vacant space left for the signature of the advocate is underneath an endorsement that all annexures are legible. Full stop. Since there are no annexures to any of the undertakings, comma, such signature, comma, therefore, comma, becomes redundant. Full stop. Hence, comma, the undertakings filed are in form. Full stop. Next para. It is seen from the undertakings that respondent numbers 4 to 8 have categorically undertaken on oath that they shall give access to the CSC staff and /or officer on each and every occasion when the CSC personnel visit the premises, comma, as mentioned therein above, comma, to the meter room for inspection upon prior notice to the said authors of the undertakings in writing or through SMS, and it is further undertaken that the deponents in the undertakings shall keep the passage clean to the best of their ability or through their representative to facilitate the access of the CSC personnel to the meter room for the inspection. Full stop. Next para. Since the fulcrum of the dispute was that the CSC personnel were not giving access, were not getting access to the meter room, comma, thereby jeopardizing the interest of all the consumers, comma, including the petitioners, comma, the filing of the undertakings has taken care of the issue. Full stop. Hence, comma, WPA 27920 of 2022 is disposed of by keeping on record the written undertakings filed by the respondent numbers 4 to 8.
It will be 3 to 8.
3 to 8. 3 to 8 in terms of paragraph number 2 of each of the said undertakings. Full stop. That's it. No rest to urgency.
Earlier also it has gone down as 4 to 8.
এখানে 4 to আছে সেখানে ঠিক। Then that number will be more than 5.
3, 4, 5, 6, 7, 8, 6.
তাহলে 5 টা 6 হয়ে যাবে আর 3 to 8 যেগুলো আছে সেগুলো 4 to যেগুলো আছে 3 to হয়ে যাবে। 4 গুলো 3 হবে আর 5 টা 6 হয়ে যাবে।
Grateful, Lordship.
Call next.
Thank you.
Item 40.
Madam, I'm for the WBACDCL. On this matter. Electricity, WBACDCL.
Shoma Rai Chaudhary is for the petitioner, but she is not well. Kindly make it not today and not tomorrow.
How long you are practicing?
2 months.
Adjourned till, on the prayer of the petitioner, the matter is adjourned till Friday? Till Friday.
Grateful, my lord.
Give your name, both of you. All of you, I mean. State is also there.
You have prayed for half to 10.
Please help her. Yes.
41.
I appear for the petitioner, madam.
Any private respondent, Mr. Bhattacharya?
No, madam.
Yes. What is the dispute? You won't file any reply?
No, I have filed, my lord. I shall file a reply and a supplementary affidavit, but they have filed a supplementary affidavit in opposition, which they have served. I want to deal with that opposition, my lord. If my kind grants me liberty to file a
Supplementary affidavits filed today be kept on record. However, learned counsel for the petitioner seeks to use an additional opposition stroke rejoinder to the further supplementary affidavit in opposition filed by the WBACDCL. Accordingly, time for filing such affidavit is granted till when?
2 weeks, my lord.
For supplementary affidavit opposition?
Difficulty is, my lord, I could have prepared it before that. My client is suffering for fever and cold, my. That is why I am.
Fever and cold.
And now, my lord, in COVID situation again started. That's the difficulty I could not.
You personally go there and take the signature.
Now
the next adjournment will be on your ground then. Acha, thik ache. At till May 3, 2023, fruits of the matter shall be listed for hearing on 4th May. May 4.
4th May, my lord.
Pardon?
4th May.
4th May it will appear in the list.
Please, Your Lordship, Lord, I'm appearing for the petitioner in the matter.
Yes, Mr. Bag, what is the matter?
Lord, may I have Milord's kindly.
Mr. Lal is appearing online. But Mr. Lal, your microphone is muted probably. From which end we have to check up?
Yes, sorry.
No, no,
It's
sir.
my end. It's my end.
Yes.
May I have Milord's leave to file the affidavit in reply?
Reply.
It has already been served, Milord, on the
Right.
respondents.
What is the case? You are for the?
Milords, I am for the performer respondent number 6, Milords.
You are supporting him or him?
No, Milords, I am against him. Milords,
Essentially, we are, Milord, caught between the fight amongst two brothers. Milord, here there was a lease deed. May I encapsulate the facts, Milord? A lease deed of 2018, 24th February 2018, with Machino Transport Private Limited. That is the company with which,
yes.
Milord, that matter, Milord. Milord, Machino Transport Private Limited, Milord, the respondent number 4 in the proceeding was required to, Milord, provide electricity. Yeah, that was the arrangement, and we would reimburse the charges.
Respondent number 4 in which proceeding?
Respondent number 6. Milord, I stand corrected. Respondent number 6, Machino Techno Sales Limited.
Yes.
Was required, Milord, in terms of the lease deed to provide us the electricity. And they have been providing the electricity. Milord, the arrangement was that we would reimburse the charges. And we have been doing that. Milord, that is it.
No seats. Keep standing there. Yes. Yes, Mr. Bag, please continue. I'm sorry.
Just pull up this chair that way and sit.
Anyway. Do not do that, Mr. Bag.
No,
not to that extent.
Just so that they can sit and not interrupt.
Machino Techno Sales was to give you electricity connection. They did not give.
Milord, they in terms of the agreement, they kept giving it the electricity connection, and we were, Milord, required to reimburse the charges, which we have. Milord, till we receive a notice on 28th of September 2022. This notice, Milord, referred to another letter of 20th of September 2022, which we had not received. But we my lord, received it through the subsequent letter because it was annexed to the letter. In paragraph 7 of the letter, it was alleged that we will be disconnecting the electricity and you get a connection within 10 days. And the other paragraphs, I will quickly take your lordship through the other paragraphs. It
You better
indicates that it was indicated in the letter
It will be
that
disconnected
will be disconnected
and you are to-
and you take a separate electricity
Correct.
connection
Correct.
within the next 10 days.
who wrote to you? Machine Techno?
Machine
I mean, sales.
my lord, respondent number 6.
6. Very good.
And my lord, the reasons given therein are completely contrary to the reasons now taken in the affidavit in opposition. Reasons given therein where inter alia, it was in the nature that they want to increase their business activity. They want more load on the electricity transformer. And that is the reason we were the tenants, because we are one of the tenants. There are other tenants also. The tenants should not be using the electricity so that they can use it for their manufacturing purpose for expanding their business. But immediately we took steps. We took a no objection certificate from the respondent number 3, the district engineer. And also from Machino Transport Private Limited, because they are the original lessors. Machino Transport Private Limited. I must pause here for a moment. Respondent number 5 and 6 are companies of 2 brothers.
Yes.
And it's a property. Their allegation is it's a joint property, not divided yet. So
But these are independent companies.
independent
juristic
companies,
entities.
Independent entities.
Very good.
We take a no objection certificate and then we apply for a separate connection. There was a demand raised, service charge demand of 5,69,000 odd. We have paid that. Having paid that, electricity connection, while this was in process, my endeavor to get a fresh electricity connection in the premises, the electricity was disconnected on 22nd of November 2022. Thereafter, this happened on 22nd of November 2022. 29th of November, we get a fresh electricity connection from the authorities. Thereafter, we came to learn about another tenant, Origami Cellular Private Limited. There was a division bench order by which they got a separate connection. Their similar situation had raised for them, and their interest was protected. We stood on a different footing because we had to apply subsequently and get another electricity connection from the CESC. We did that. Till here, there was no dispute. Even if there was dispute, we were ready to settle and we had applied for separate electricity connection. Thereafter, there was a complete reneging from the stand taken. They take a U-turn. On 14th of December, they issue a notice.
They
that
means
is
special techno. I mean 6.
6. May I indicate that? That's at page 44. This was by 6 Machino Techno Sales Limited. Techno Sales, through their advocates, give us this letter of 14th December 2022, where it is contended that
page 44.
Page 44
of the writ petition.
Of the writ petition. It's annexure P6.
Yes.
The second paragraph of this letter, they refer to another coordinate bench order, interestingly, which was passed on 2nd of December 2022. I pause here. Why I say it is interesting is it is on this date, when this proceeding happened, the coordinate bench of this Honorable High Court was not informed about this proceeding. Nothing was brought to the notice. We were not parties there.
Proceeding means which one?
This writ petition, which is pending now, which is being heard. This, was not brought to the notice of the Honorable Judge, who was, considering the matter. And we were not parties there. So, we did not know about this order. This order, is between the brothers in a dispute, in a revisional order, where it is indicated that you continue with the way you are giving electricity connection till a certain period of time. But this entire dispute, what has happened, was not brought to the notice of the Honorable Court.
But you were a party to that.
We were not a party. We were not a party.
How does it bind you according to
It does not bind us. That is my submission. It does not bind us, and there is nothing which is in the nature of an impediment for us to enjoy electricity connection. Nothing. Now, my lord, kindly note from the second paragraph. It is apparent that the root cause of the caption disputes was the illegal electricity connection obtained by the petitioner in an illegal construction also undertaken by the petitioner at the premises in issue. Next paragraph, needless to say that the electricity connection along with meters, panels, electric cables were illegally installed by CESC and its officials at the behest of the petitioner, who is the tenant of Machino Transport Private Limited, in a brazen disregard of a judicial order and our letters dated 20th September 2022 and 29th September issued to your good offices. Over the page, my lord, page 45, the third paragraph. Please note, this is where, my lord, the reneging, the fact that they have reneged from the previous stand. Please note that our client is ready and willing to provide electricity. I pause here for a moment. Because they are the ones who told us that we will disconnect it immediately if you do not apply for it in writing. I'll indicate that, my lord, that document is that
We'll come to that.
my lord. Now they take a turn and they say, we are ready and willing to provide electricity to the tenants and occupiers of Machino Transport Private Limited at the premises, as was being provided earlier, that is before the instant dispute started, and also in compliance with the order dated 2nd December 2022. However, we shall provide electricity subject to compliance of limit as restricted by CESC apropos withdrawal of electricity from our client's existing transformer. And the last, my lord, paragraph of the page, in these circumstances and in view of the order of 2nd December 2022, we on behalf of our client request you to immediately stop drawing electricity from any other meter and particularly one lying in the name of Suraj Molders at the premises, so as to enable us to supply electricity in the said premises to you all in compliance with the order of 2nd December 2022. It is needless to mention that unless you stop withdrawing electricity from the panel connections installed by the CESC in the illegally constructed property being in the name of Suraj Molders, the order dated 2nd December 2022 passed by the Honorable High Court shall not be complied in letter and spirit. That is the stand they now take.
Two allegations. One is that is an illegal portion.
Illegal portion, illegal
And you are in
construction.
violation of the order of the court.
We are in violation of the order of court where we were not a party.
Yes, that will be.
We were not a party.
Yes.
My lord, now, kindly, my lord, take up page 47, the next page. This is the order of the Honorable Coordinate Bench. My lord, 2nd of December 2022, subject matter of challenge in this case is against the order of 24th November passed in misappeal before the court refusing a prayer for ad interim injunction. Admittedly, trial court declined to grant ad interim injunction dissatisfied with the prima facie case made out together with the urgency presented. And I'm not troubling your lordship with the, my lord, submissions. It is an admitted position that we were not a party to this proceeding.
Release the other matters.
Lord, I will take 10 minutes. So I think, my lord,
Other matters are released. Yes.
my lord, page 49, the last two lines. This is where, my lord, the operative portion of the order starts. The root cause of litigation may be the issue of employment of electricity by the opposite parties, consequent upon application of the opposite parties for installation of a new meter. Such point appears to have been presented before the court below. Matter needs further consideration, opposition, direction for affidavits. Last paragraph, my lord. In the meantime, enjoyment of electricity by the opposite parties may be permitted to be continued in the manner as before being supplied by the petitioner till the end of January 2023. The essence in my very humble submission of this operative portion of the order is that the party should not be deprived of the electricity connection. But it was not brought to the Honorable Court's notice that, my lord, what has transpired with this tenant, where they have given us a letter directing us to immediately apply for a separate electricity connection. We have paid for the electricity connection. We have got it.
You can take a seat and watch because no advocate is there. So you can take a seat. Yes.
But we have got the electricity connection pursuant, my lord, by following the due process of law. We have paid, my lord, the amount which was demanded, and we were enjoying that electricity connection. Thereafter, my lord, there is a recovery chart which was given.
According to them, how does this affect you at all?
This order in my very humble submission does not affect us at all.
What is their best case according to you?
There, my lord, they have taken two grounds. The first being it's a joint property between the brothers. So no new construction can be made.
That's on the
Construction
illegality
is-
of the construction.
Construction is not an issue at all. The construction is not an issue at all because it is only in relation to the electricity connection and the conduct of the CESC. Because they thereafter, my lord, issue us a notice. I will indicate that. That is the reason why we are, my lord, in difficulty. That is at page 64. The reason for, my lord, the cause of action for the instant proceeding.
Yes.
Because in the meantime, my lord, there was a letter which, my lord, was written to the CESC. CESC, my lord, gave us, my lord, the private respondents gave us a chart for 6 months of electricity and asked us to make a payment. That I should also indicate because these are all annexed to the letter which they have issued, which I was just, my lord, referring to, of 14 December 2022. Page 51 is a chart which they give. Your lordship will find at page 51, the left hand, it's my lord, horizontal.
Right.
The left hand are the names of the tenants. Suraj Molders, the first name is, my lord, the petitioner before your lordship. And they indicate, my lord, that we have to make payment of this 1 crore rupees to total demand from the tenants. This is the amount which we have to pay, my lord, against 6 months usage of electricity. My lord, there's also, it's followed by a letter of, my lord, 7th December. This is also annexed to the previous letter. My lord, client Machino Techno Sales Limited, addressed to the CESC. They say that they have given this letter to the CESC, where they take these points and they indicate to the CESC that there was an order of the Honorable Court by which you are not supposed to give electricity connection. It is now on us. We will give the electricity connection. You cannot go ahead and give the electricity connection. CESC, my lord, thereafter, kindly take up page 59, again a part of the letter. Page 59, my lord, the first row is, my lord, the petitioner before your lordship, Suraj Molders Private Limited. Kindly see the amount, 1 crore 98 grand total. One-time investment, share of security deposit for 2 months, one-time bill in charges, area. And the amount comes, my lord, to 1 crore 98 lakhs. This is what they are charging now again for giving us electricity connection. Now, thereafter, we immediately write to the CESC not to take steps. My lord, kindly see page 60 is our letter. And CESC, this was received, my lord. Page 64, my lord, CESC writes to us. Page 64.
Yes.
Kindly see the first paragraph, my lord, they indicate the order. They refer to the order of the Honorable Court. They refer to the letter issued by Machino Techno Sales Limited. Second paragraph, the aforesaid letter, together with the said order, communicated to us inter alia mandate that the enjoyment of electricity by the opposite party, Machino Transport Private Limited, may be permitted to be continued in the manner as before through the petitioner, Machino Techno Sales Limited, till the end of January 23. Over the page, my lord, in compliance, we shall depute our personnel on 9th January 2023 at 10 a.m. to 12 noon to de-energize the supply of captioned meter at the premises in question. Re-energizing the same will be subject to further orders of the Honorable High Court. So this is the cause of action which, my lord, compelled us to approach your lordship immediately.
What is the
and, my lord,
position today? You are enjoying that new connection.
That we are, because, my lord, we are protected by your lordship's order. My lord, the interim order which your lordship was pleased to pass in our favor, my lord. We have, my lord, thereafter there is no disconnection. This, my lord, letter was not acted upon by the CESC. Thereafter, my lord, pursuant to the order passed by your lordship, there has been no material, my lord, development on facts. Facts remain the same. May I only indicate the first letter, my lord, which started the entire dispute. Because, my lord, as a tenant, my lord, we are not concerned with the dispute between the, my lord, erring companies which belong to separate brothers. My lord, the lease deed starts from page 21 of the writ petition. Lord, at page 25,
Yes.
Kindly note at page 21, it is a lease deed agreement of lease between Machino Transport Private Limited being the lessor, and next page Suraj Molders being the lessee.
Yes.
And at page 25
Transport is
respondent number 5.
Yes.
Respondent number 5. Page 25, the last paragraph. Electricity up to 50 kilowatts shall be supplied provided from the transformer installed at the premises in the name of Machino Techno Sales Limited. Respondent number 6. And the lessee shall pay all charges for electrical energy consumed by the lessee and the proportionate transformer loss on the demised premises as shall be payable to Machino Techno Sales Limited according to the reading in an exclusive submeter already installed at the demised premises. This is, the arrangement, and they cannot today, renege and say that we were not parties to this agreement. This issue was considered by your lordship on the previous occasion because they have acted on this. They have given us electricity connection. We have made the payments, and it is not their case that we have not made payments, and it is for such reason that they are disconnecting the electricity. That is not the case. Now, very interesting is, the letter, which is the notice at page 35. Page 35.
Yes.
This is the letter of 20th September 2022. One page prior to that, page 34, is the letter by which they have made over this subsequent letter. This letter starts from page 35. Paragraph 2. This is issued to 4 separate tenants. We are one of the tenants. And they indicate in paragraph 2, for more than last 5 years, you are altogether acquiring 1/4 of the portion of the property in the capacity of a tenant. Next line, however, from the very beginning, instead of being tenants of MTPL, you are all enjoying supply of electricity connection at your respective premises from our clients' electricity connection bearing consumer number and never tried to obtain a separate electricity connection. I pause here for a moment. This itself is an admission, that they have been giving this connection to us. Because they say right from the beginning, you are enjoying the supply of electricity in your respective premises from our client's electricity connection. So they have acted.
There was an arrangement between them, 6 and 7, 5 and 6.
There was, which we are not aware of. There must be.
There must be. So they fell out in the meantime.
They fell out in the meantime. And their entire case in the affidavit, I will take your lordship to the affidavit. Their entire case is it's a joint property. One of the brothers must be developing something in the property, and they say you can't develop. So you stall everything. You create hindrances for the tenants who are there in the property. You are the lessor, they are the tenants. Let's create hindrances. That is the
It is apparent from his expression also. Your learned friend's expression. He's trying to create a hindrance. Yes.
The next page, page 36.
I shall show that this allegation per se from the records and the order of this court is not correct. This allegation per se.
Yes, you are confident on something.
Yes.
What something
particularly this allegation. Specifically because they have admitted. I'll show that they have done so.
Don't disclose so much. Yes, Mr.
At page 36, paragraph 3. Instead of being aware of the fact that you are the tenants of MTPL, that's respondent number 5, and are not connected with our client in any manner whatsoever, our clients never tried to create hindrances or disturb the supply of electricity at your respective premises due to its moral superiority. This is in the nature of a waiver, my lord. Paragraph 6. Moreover, our client is also planning to have future new projects. I request your lordship to underline this. This is the reason. Future new projects at the said premises, which will otherwise increase the electricity consumption of our client. Paragraph 6, the first 3 lines, then paragraph 7, the last 4 lines. In that event, our client is no longer willing to supply electricity at your premises from its own connection. It would be more prudent for both of us that you should apply with the CESC for separate connection at your respective premises for supply of electricity over the page mirror. In view of the above facts, we on behalf of our client above named hereby call upon you to obtain a separate electricity connection for your respective premises within 10 days of the receipt of this notice, else our client will disconnect the electricity supply at your respective premises. This is the, my lord, stand taken by them. This is what, my lord, set the entire course into motion. We applied for a no objection certificate. We got a separate electricity connection. Now, my lord, apropos this, they issue a letter to the CAC that there is a, my lord, direction from the honorable court. You can't give them electricity connection. CAC acts upon it, gives us that notice that will come and de-energize the electricity connection which you are enjoying. That is, my lord, the facts of the matter.
Mr. Bagh, is the issue that they were enjoying electricity, some amount of electricity in total. Now they wanted more electricity load factor. For that, they asked you to take a new connection.
My lord.
And they would be using that extra load.
But that is what appears from the letter.
But after the order of the High Court, probably that is to be distributed among the others also. So that's why they again resile from that position. Is it something like
no,
this?
my lord. In my very humble submission, that is not the case, my lord. In my very humble submission, the Honorable High Court, while, my lord, deciding the 227 petition or considering the petition, my lord, this fact was not brought to the, my lord.
So that is different. That is different. But I'm trying to read into their minds. I mean, because they had litigated with another party, another tenant. Before the High Court and order was passed, they have to continue supply to
No, my lord,
those people.
they had not litigated with another tenant. My lord, they had litigated between the brothers.
Oh, business brothers, whatever.
The brothers. So, my lord, the essence of that litigation was because they did not get a, my lord, prima facie case was not made out. They could not get an ad interim order of injunction. From
Ultimately, it
there,
boils down to the load factor. They're resiling from that position.
My lord.
Very good.
And we were paying. It is not that we are not paying or we were not paying them. It is on their letter, my lord, that we took a new connection.
Now they have asked you to disconnect.
CAC has asked us, my lord, they indicated that they'll come and de-energize, disconnect the electricity connection.
What is the premise of the CAC notice?
My lord,
their request.
My lord, page 64.
That is important.
Page 64.
I'll look into that.
Order of the High Court. We refer to the order, my lord, this page 64 should be, my lord, in my very humble submission.
We refer to the order.
Right.
Read along with, my lord, their request, which is at page 52. Page 52 is their request to the CSC.
Yes.
So they request the CSC, it starts from page. They indicate, my lord, kindly see page 53, the last paragraph. In fact, the entire page, my lord, they enclose a copy of the order of the Honorable Court, which is self-explanatory according to them. And then they indicate in the last paragraph, by the order, the Honorable Court has specifically directed our client that our client shall only supply the electricity connection in the premises. Resultantly, our client should be the lone recipient of electricity from your offices.
This derivation you say is not correct. They're deriving this, deducing this.
That is not correct.
That
In my
is
very
not-
humble submission, that is not correct.
Very good.
Because the Honorable Court has
Not an
not said
automatic
that.
corollary of that order. I mean,
This is not the automatic corollary of the order.
Very good.
This is not, my lord, something concomitant to the order that they can, my lord, rely on. Next page, my lord, upon a true and correct interpretation of the order. They're now seeking to interpret the order, my lord, page 54, second paragraph. It will manifest that henceforth electricity in the said premises ought to be supplied by your good offices only to our client and no one else. This was never brought before the Honorable Court.
Very selfish. The language is very selfish.
Thereafter,
That was the purport of the order, my lord. Two orders of High Court asking us to give
Your
only
main issue will be whether it can bind them at all.
I'm not page
and
55.
that too, my lords, despite apart from that, my lords, I'll have to show that what is their conduct apropos this whole issue. No, he today,
Only one
the
line may I
petitioner has
indicate.
today come before your lordships as
So
a
disclose
third.
all your defenses. Yes. Keep it for tomorrow.
My lord, only one paragraph before, my lord. I'm sorry for troubling your lordship. Now it's time, my lord. 55, only the last paragraph. Therefore, in the light of the aforesaid, we hereby once again call upon you to disconnect the electricity being supplied from the said illegally installed meter. So, my lord, it is on this request that the CSC send us the letter, which is at page 62.
So two premises basically. One is that the illegal construction comes in later probably, according to you, and the High Court order.
And the High Court order. And I will indicate, my lord, from the affidavits exchanged, what is the stand and how they have dealt with, my lord, the allegations, my lord, the points which we have raised, how they have dealt with it.
Because it is spreading over so many days, can you bring in a nutshell written notes of arguments?
We will.
I mean, not elaborate written notes.
Not more than 2 pages, my lord. 2 pages is more than sufficient.
Yours may be 3. It appears from your, yes, but not more than that. Just in a nutshell, just the points.
But this whole
They have to
dispute,
point
spans.
Because I
over,
want a
my lord.
reference to the page numbers
I
which you are
shall do
saying.
that.
That I'll lose track of.
But my lords, there are certain facts which need to be brought, which
No,
need
definitely I'll hear
your
you.
lordship's consideration. my lords.
I'll hear you at length. Heard in part for further hearing tomorrow. I'll continue with the hearing of this.
I'm deeply obliged.